Good morning. Good morning. Good morning. We are live. Hello, hello. We are waiting for the trial to start. They are in the courtroom. So we are here. So we are just waiting for court to begin. And then we will get it added. So I did something crazy. I actually emailed the defense attorney to tell him that the prosecutor kept using the wrong drug name because it was driving me crazy. I couldn't stand it. Just to have it on the record because, like, what the heck? So I did email and tell them to correct the drug name. Maybe they will, maybe they won't. I don't know. Maybe it matters, maybe it doesn't, but I think it matters.
Computer's being slow.
Oh, I forgot my water. So good morning, everyone. Welcome. Today is rebuttal witnesses from the prosecution, and then I think there's going to be closing arguments. I am only going to be here this morning. But I will leave it on the trial. If you like. I don't know if you saw yesterday, we did watch the Corey Richins sentencing. She made so many faces.
Is 23 CF 475 State versus Josie Dikeman appearances.
Matthew Tarbinson and Emily Rood appear for the state. Also present at state's counsel table is Investigative Sergeant Rich Amundsen. Good morning.
Morning, Your Honor. Ms. Dikeman appears in person with her attorneys Chris Sacker and David Bowles. Also present is paralegal Emily Sanchez.
So a couple things. What I was doing right now is I was looking at the emails that were sent last night. They were forwarded to me by Ms. Langer. Just so you know, I realized after we were done yesterday.
Good morning, Kim. How are you?
Two different instructions we had not put in. One was
yeah, I did. I just couldn't stand it.
The other one was hypotheticals. We never put the hypothetical one. It's pretty short. I also knew that there was an issue on the falsus new instruction, knowing that's disfavored. I knew that from the instructions, looking at the history of it. There is a lot of contradictory information that's out there for a lot of different witnesses. If I do have it in there right now. We can discuss it more later. I just put it in there just as a.
And Corey was awful. Her
at
face.
The end of the witness section. I agree.
While Eric's sister was talking, I was like,
neutral. It should be just general. It shouldn't be specific for the children. I know I said something about the children, but I think what I was thinking is that it would be put in there generally. I'll give you an opportunity to respond to that, Mr. Zacher. I'm just wanted to let you know that's where. So I did put those two in. I know that we've done the verdicts, and we've done the redid the whole verdict section at the very end of the jury instructions. So we have that. we're not actually done, so we can do one more jury instruction conference to go after the details. Plus, I see the additional information for Mr. Pedrin for 275. And I don't know if that was just a couple minutes ago. I don't know if you had even a chance to look at it, to be honest.
Because I also filed amended information. Incorporate the language that we talked about yesterday.
Yeah, that. Let me look to see if it's got.
Are they talking about
maybe
jury
crossed over.
instructions
Maybe it was.
or how to do the charges? I don't have anything.
Yeah, and I see there's a. What? It's sitting out there. Okay, we'll cross that over. We'll take a look at that. And the state had said that you will have at least maybe 2 witnesses on rebuttal now.
I believe they'll just do one at this point, Your Honor.
Oh, just one. So maybe we'll get to hear some closing before I have to go to
and,
work, or I will. You
any
guys will get to
issues
hear it.
Other than what I just talked about, which we'll talk about again after your witness is done.
I don't believe so.
Mr. Zacher?
Beyond what we have to discuss on the falsus and uno and the amended information.
Okay.
I agree that the hypothetical standard instruction.
Yeah,
Hypotheticals.
did you have a problem with the hypothetical? We just didn't mention it last night.
It was done a number of times. So I think it's appropriate.
Okay. All right. Having said that, actually, I don't even know if the jury's up. We have a few minutes before they come in.
Want to take not guilty pleas on the new information, Judge?
Yeah, it's crossed over now. Okay, yeah, why don't we do that? Hold on one second. All it did was change the language, correct?
On count 2, it just.
Yeah.
Yes.
Also, I know we saw that Alec Murdaugh is getting his conviction was overturned. It wasn't just overturned; it was unanimously
Everything's a little slow this
overturned.
morning.
So that is pretty shocking. But he's going to be in prison for decades. He's not
You
getting
have a
out.
copy of the information, the amended
But
information?
I got
The-
an electronic
he's
copy by
not
email.
a convicted murderer. So that's pretty.
So, Ms. Dikeman, in count 2 now, in the amended information, this might be the second amended information. It charges, same charge, chronic neglect of a child, consequence death, that between January 1st, 2021 and February 11th, 23, that the same time, the only difference is that it changed the language to that says did negligently fail to provide necessary care, necessary food, necessary medical care, necessary education compliance under 87 or
Yes, China.
118,
Her facial
115,
expressions were
and strict
insane.
exposure to drug abuse is defined by 46.4, 46.973 parent 1, parent D. And then the rest is the same.
We watched her
Do
sentencing.
you need
It was
any
like,
more than that?
No, Your Honor, we'll acknowledge receipt of the amended or the Second Amendment information, waive its formal reading. We are specifically objecting, as we did before, to Ms. Dikeman's constitutional right to notice and present a defense. Second subsequent amendment, those objections notwithstanding, Ms. Dikeman will never plead not guilty.
oh, I did not
I'm
see
gonna
that.
Plead to that amended count.
I
The
missed
not guilty is
that.
already,
That's
entered in
sad.
for count 1 and count 3. Also, the court made a decision allowing the state to amend it as of yesterday. So that does remind me, I did modify those instructions.
How old are
on count
her kids
2,
now?
with the language for 118.15 and 46.973 parent 1, parent B. I just took, there is actually a jury instruction for 118.15. Then I had to take this to statutory.
Really?
language for that
Nuh-uh.
46.973 parent 1, parent B.
Oh, I got to go back and watch
Um,
that.
But we'll get you copies of that. I'll have Christina send what current copy we have. Remember, this is still a rough draft. It's not the final draft, but.
Want to hear my response on falsus in uno now, or do you want to do that?
Sure. Why don't we have a little time. We still don't, if you want to talk about falsus in uno, go ahead.
I absolutely agree.
Oh, you never know what kids will remember.
And that falsus in uno is a distinct instruction for a number of reasons.
Oh, I didn't hear. I have to go back and watch it then. I didn't hear the kids. I just heard Eric's sister. I went back and listened to that, and I saw her face, like when the sister was talking, and I was like, oh, she was pissed.
Previously, my problem with making it general is that it, or at least not carving out an exception for the defendant, is that it impacts the presumption of innocence. If the jury's instructed that they can just disregard her testimony entirely at that point. So if we're giving a general instruction, I would just like a caveat added onto there that this doesn't apply to Ms.
I think that's why it's disfavored, actually, for exactly that reason. And it's one of those questions yeah, I mean, that's why it's disfavored.
Judge, my response is actually that it shouldn't be given at all. There's two cases. There's the Wisconsin Supreme Court case, it's State versus Kluge, that is found at 2008 WI 58, and it's discussed at paragraph 71. That case was overturned on other grounds related to another issue, not on that specific issue. And it's State versus Lagar, LAGAR, which is found at 190 West 2nd 423.
The sad part about all these cases is that the kids are the ones that are impacted the most.
Why the instruction is disfavored, and it's in essence, it's because the credibility instruction tells the jury how they're to weigh credibility with regards to all the witnesses, and certainly a witness giving contradictory information goes to that witness's credibility. My problem with the instruction is a witness can get up and say something that one party may interpret as material, the other party may not interpret as material, and they're going to argue that all of his testimony should be discounted because of that one thing that he said, whereas there may be motives and reasons to explain why he did what he did, and he came in and subsequently corrected that when he testified. So I'm asking the court not to give the instruction. I think the credibility instruction adequately covers all the factors that the jury is to consider with regards to all the witnesses, the defendant, and every single other witness that took the stand.
Your Honor, the problem with that is that we'll be left without a remedy for these that we got into with Brantley in particular. So our request is that it, at the very least, be given specific.
So they're talking about jury instructions already. They're going to make her charges so vague. It sounds like. That she is going to get charged with, convicted of whatever.
What I'd point out is some of the case law where it discusses it, it's where the prosecution asks for it relative to a defendant's testimony. So that's the other reason why it appears as though the prosecution may be able to ask for it relative to the defendant. I am not in this case. I want the general credibility instruction for Ms. Dikeman, and I want that for every other witness as well.
Yeah, one thing that it says in the logger is that impeachment of a witness with prior statements does not necessarily mean in falsus in uno instructions appropriate. The testimony must show a willful and an intentional disregard of the truth. The trial court has the best position to make the call. We see no error in the court's discretion. It's obviously jury instructions are left to the court's discretion, which is part of why they didn't strike it down on that basis. But what I find interesting, the question is, is it a willful and an intentional lie? I think the argument has been that it's been influenced from the defense, correct?
That the testimony was coached and influenced, yes, but I mean, I think all we needed was when he came back on the stand after the break and acknowledged that he had lied under oath. That seems to fit the definition of willful intentional.
Yeah, it's a kid though. I mean, this gets more complicated because it's a kid. I mean, I think that's where it gets. I mean, there are a lot of issues with children testifying, and it becomes very complicated because even getting to the truth and lie, where there was sort of there are hesitations in the original and about if they understood fully what it meant. Of course, with the explanations, red, blue.
So are they trying to
markers,
throw out the
etc.
kid's testimony?
Those are easy things to say yes and no to. Do you understand the consequences? And there was
Which
sort of a blank.
it's already out there.
Response to it at different times. I mean, that's all part of closing argument to a degree. I mean, about the reliability of those statements. The question is falsus nunu, is that really appropriate given that situation? We're going to have one more meeting. Give me a little more time to think about it. But I understand the state's position. I understand what the case law says. I read the other case before. I hadn't read this case. The question really in my mind is, are you getting to a willful, intentional lie, or is this part of this? The theory of the case is the theory of at least the statement by the child is that it was somehow influenced. Not to mention the ability to essentially manipulate memories. We know that happens with children. There's a famous cases over that. Probably one of the most famous from Minnesota. So it becomes one of these issues of,
Or Florida.
what's the real intent of the child, or is it the manipulation of the child? Or
Y'all remember that case?
Sometimes for children, it's also not even a manipulation. It's just
where the mother,
I mean, it was testified to that Brantley,
that her son testified on the stand that she didn't,
active imagination.
didn't like she
So I'm
killed
not
her husband in self-defense.
Thought out loud and said it out loud, and so give me a moment.
And then years later, she ended up
one thing on that last part.
almost killing her son.
When he came
Or
back,
she paralyzed him
I think it's
in Las
important to note
Vegas.
that when he went outside, his father was upset with him, not coaching him. Upset because he was denying that there was domestic abuse back in, and said
It was a famous case.
exactly that he had an encounter with his dad. And so the testimony establishes, he also said he was trying to protect his dad. He thought somehow, I think there's questioning by Attorney Zacher, that he believed that if he said something relative to his dad abusing Miss Dikeman, that may cause his dad to get in trouble. That's not an intent to get Miss Dikeman in trouble. That's an intent to protect his dad, which is very different, at least in my mind. I think that all of that can be argued in credibility. I don't think we need the falsus nunu to address it.
The other issue, just generally, is I don't want it to create the constitutional issue, which is, as you were saying, the constitutional issue, which is all of a sudden. I know this is why you want the specific, language in it, Mr. Zacher. But the reality is that I'm not sure. So it says, okay, in this one witness, it also would highlight this one witness. I mean, it's not necessarily that's not necessarily the purpose of it.
He's like, basically, I don't want to see this case again.
Attorneys argue the rotten piece of meat in the stew, analogy of many times. Do you eat the whole bowl of stew, or do you eat the rest of the stew, or do you throw it all out because one piece is rotten? So
I'm more of a sandwich guy, Judge, but
the sandwich guy, yeah. I think it's a Belzer can one.
Yeah, my just correcting the record on the point. I believe what the child came back and testified to was that he was lying about his father drinking, not about the violence.
Okay, so this is, I'm gonna hold off a little bit. I'll be frank, I'm leaning towards taking it out right now altogether and just letting you argue it.
Sure.
But let's give it another moment. Plus, we have to work on the language on the 275.
Judge, I just sent our counter proposal on 275. We can talk about that later,
All
since I
right.
know no one's had time to review it.
Yeah, let's talk about that later. You sent that to Christina, right?
Yes.
All right, so she'll forward it to me eventually. Let me go see what's going on with the jury. Oh, okay, somebody's running late. Why don't we take about a 5-minute break and we'll start once they're all here.
I mean, he is just like, first of all, the prosecution threw in that they want to add lesser charges. Remember the other day, they were like, oh, we're going to have lesser included charges. And the judge was like, whoa, what? Because they were going for first degree, the whole shebang. And then they decided, oh, wait, our case is not as strong as we thought it was. We need to add lesser included. So I don't know how they're allowed to do that. Like in the middle of a trial, that you're just allowed to add lesser included charges on the jury sheet, the verdict form. I guess you're allowed to do that. Like an eeny, meeny, miny, mo kind of thing. That's crazy because somebody's life is in your hands. That's nuts. I would be pretty pissed. But I mean, it's a lot harder to prove first degree than it is all the lesser ones. Because then, I mean, as a juror, you would just want to pick something, right? I mean, most of the time, jurors just want to pick something. So they're going to pick something. Just to get some kind of justice for Alexavier. And I know most of the jurors probably feel like we all feel, well, Derek should be going down, but we can't get Derek. So, Alexavier needs to get justice somehow, some way. So it just, at the end of the day, so, I mean, it just makes sense. And obviously she's not Mother of the Year. So, but no, I did not watch, Corey's kids statement. That is wild. I did not know that she locked them in the basement when she had company. I didn't know that that guy went to her house. I did see the trial, but I didn't know that he ever went to her house. I thought they always met other places. So that's crazy. And I can't believe, when she did her statement that she addressed the whole cheating between the two of them. And then the whole statement, she was all like, be like your dad, be like your dad. It was super frustrating and annoying because I didn't think she did a very good job of the whole pandering. But at the end of the day, I also felt like, when else is she going to get to talk to her kids other than that moment, if they have pretty much isolated the kids from her? And if she were free, she would have done the same thing to his side of the family, I'm sure, as they stated. It's just really sad. Kids are just used to be pawns. And it's just a sad life. But the Alec Murdaugh, the Supreme Court unanimously decided that his conviction should be overturned. He is going to be in prison, though, for like nearly 70 years for his financial frauds. Although the state of South Carolina says they're still going to retry him for the murders of Maggie and Paul, and they are intending to do it back in Colleton County, which I don't know if he will be able to get. I don't know where on this earth he would be able to get a fair trial. If y'all can think of anywhere he could get a fair trial, please tell me. Like, maybe in like some village in Africa, but not any, I don't know, like somewhere there's still no satellites, or I don't know. Like, I don't know where he could get a fair trial, because where has there not been a place that they haven't heard of Alec Murdaugh? I just don't know, because he is all over. I mean, he's had Hulu specials made out of him, Netflix, 48 Hours, Dateline, every YouTube channel has covered him. I mean, TikToks, what there, I don't know where. I mean, the freaking court clerk was writing a book about him while she was covering the trial. So I don't know where in the holy earth he could get a trial. It just doesn't make any sense. So, and they're intending on doing it in the same county. It just, I don't believe so, but and they're just talking about, oh, we have a different court clerk now. I don't think that's how this works, but I'm pretty sure his attorneys are going to ask for a change of venue, and I'm pretty sure they're going to ask for a different judge and a different everything. And I don't know if they're going to get it, but I'm pretty sure they're going to request it. But I don't foresee Alec Murdaugh getting an impartial jury for a new trial. Not on this planet. But I could be wrong. I don't know. Okay. Let's see what they're going to do with Josie. So the prosecution only has one rebuttal witness. Thank God. Thank the good Lord above.
Objection.
Okay, so you're, I heard that.
Oh, you heard that, but you didn't hear the kid call the defense attorney an MFer. They were sitting right next to the other day.
All right. Okay. Everybody's back in the courtroom. The jury is all here now. Can we bring the jury in?
Yes.
Before, one thing, I will say to the jury that defense rests. Now it's an opportunity for rebuttal, just to explain where we're at, and then I'll have you call your witness.
I wonder who their rebuttal
Okay,
witness
bring
is.
the jury in.
I wonder if they're calling back the medical examiner.
You may be seated. Morning, everyone. We will, at this point, I think when you left yesterday, we had, the defense had rested. At this point, the state has the opportunity for rebuttal. We had to wait a little bit till this morning. What we'll do is we'll start with the state's rebuttal if you want to call your first witness.
Thank you, Your Honor. State calls Investigative Sergeant Rich Amundson.
Oh, him again? Oh,
Do you solemnly swear the testimony you give in this matter shall be the truth, the whole truth, and nothing but the truth?
Thank you.
oh, he's gonna be up here all morning.
Good morning.
Morning.
Can I have you state and spell your name again for the record?
Richard Amundson, Amundsen.
And Sergeant, I'm going to hand you another stack of documents, and we'll go through them one by one, okay?
Okay.
Sergeant, do you recall during Ms. Dikeman's testimony yesterday that the bag of pills that we've been discussing in this matter may have been placed on or on top of her clothes hanger?
Yes,
And when you were processing the scene, did you have the opportunity to observe the clothes hanger in her bedroom?
yes.
If I can have you look at Exhibit 154, Sergeant, can you please identify what we're looking at here?
This is a photo from Miss Dikeman's bedroom showing the clothes hanger rack storage shelf.
And from your review of that photo, is it in the same location as it was when you processed the scene on the 11th of February, 2023?
Yes,
Is it a true and accurate representation in that photo?
yes.
Your Honor, I'd move for the admission of Exhibit 154 and request to publish, please.
Okay.
No objection.
You received? Go ahead. Publish.
All right, switch to my computer, please.
I finally figured out how to cover up the
Can you tell
long
us what
crime
we're looking
logo
at
so I don't
here?
get in trouble.
To orientate yourself, these are the French doors that go into the living room. Miss Dikeman's bed would be right in here. And then in this corner is that clothes rack with hangers here and here, and an area to store things above it.
Thank you. I'm going to have you look now at Exhibit 155. And before we go through this, do you also recall over the last few days there being testimony about the pictures Ms. Dikeman was taking around 9 p.m. on the evening of February 10th?
Yes,
And was there discussion of whether or not Ms. Dikeman had makeup on in those photos or was using a filter or things along those lines?
yes,
I can have you now look at Exhibit 155. Is this another Cellbrite extraction report from Ms. Dikeman's iPhone extracted on the 13th of February, 2023?
it is.
And is this specific report related to the photos Ms. Dikeman captured between 9 p.m. and approximately 9:30 p.m. on the 10th of February?
Yes,
Hey, Jenny Peach.
Given your review of this data, is it a true and accurate reflection of what was on the Cellbrite extraction for Ms. Dikeman's phone?
Hey, Gwen. Good morning.
And Your Honor, I'd move for the admission of Exhibit 155.
We have
no objection.
boring man on the stand again for rebuttal.
Sergeant, does this extraction report identify that there were 41 files contained in this portion of the extraction?
It does.
And from your review of this report and the data, does it appear that the phone is capturing both the full-size image and also a thumbnail image when we're pulling the information in this report?
It does.
So when we're looking at the overall total of photos actually captured, does it appear that there are about 20 photos of Ms. Dikeman captured in this time period?
That is correct.
If we look at
China's
entry
here
number
too.
1 in this report, Sergeant, can you please tell us what the capture time is for that first photo?
February 10th, 2023 at 9:02 and 42 seconds PM.
And then if we look at number 39 on page 10 of this report, what time does it indicate that that selfie or photo was captured?
February 10th, 2023 at 9:20 and 14 seconds PM.
And then if I can have the Elmo, please, I'm going to republish exhibit 254. Sergeant, is this the photo that was testified to as being sent to Mr. Suarez by Ms. Dikeman on the night of the 10th of February?
Yes.
And if we look at entry number 18 on exhibit 155, does it indicate that the file name related to this image is IMG_0549 period HEIC?
Yes.
And what is the capture time of that image?
February 10th, 2023 at 9:16 and 31 seconds PM.
I can have you now turn to exhibit 156 in front of you. Do you recognize this exhibit?
Yes.
Is this one of the selfies captured by Ms. Dikeman during the period of time we're talking about right now?
Yes.
And if you can, while we're identifying this, refer to report 150 or exhibit 155, Sergeant. Does this photo have the file name IMG_0541 period HEIC?
Yes, it does.
And what is the capture time related to that image?
February 10th, 2023 at 9:02 and 42 seconds PM.
And is this information, including the contents of the photo, true and accurate based on your review?
Yes.
Your Honor, remove the admission of 156, not requesting to publish quite yet, though.
No objection.
Received.
If I can have you then turn to exhibit 157, Sergeant. What are we looking at here?
This is another selfie that Ms. Dikeman captured on February 10th of 2023. This time she's wearing glasses and makeup.
And if you refer to exhibit 155, specifically entry 38, does this particular photo have a file name of IMG0559.HEIC?
Yes, it does.
And what's the specific capture time related to that photo?
February 10th, 2023 at 9:19 and 12 seconds PM.
And
When you're doing
based
too much.
on your review of the information, is the content of the photo and that creation data we just discussed true and accurate?
Yes.
Your Honor, I'd also move for the admission of exhibit 157, not requesting to publish quite yet.
You know, my ass has no tips.
Now on to exhibit 158, Sergeant. Can you please explain to us what you're looking at here?
Exhibit 158 is the two photos I just discussed side by side on the same sheet of paper.
I've heard of ginger
And,
root.
is the information contained, including the content of the pictures and that file name and capture time, true and accurate, based on your review?
Yes,
Oh my
Your Honor,
gosh,
I'd move
publish
for
the
the
pictures.
admission of Exhibit 158 and request to publish.
Objection.
Receive, publish.
Can we see them? Has she got no makeup on?
Have it switch to the computer, please.
Is her hair wet?
Okay, Sergeant. So these are the two photos, 156, which was captured at 9:02 p.m., and then 157, which was captured at 9:19 p.m., correct?
correct.
Okay. And what facial features, based on your observation, do you see differently in these two photos?
To start with the one captured at 9:02, you can see how Miss Dikeman's hair isn't brushed out, more stringy. You'll see that there's no eyeliner between the first photo to the second folder. It appears her skin tone is more leveled out. Then she's also got lip gloss on in the second photo compared to the first photo. You can see here that Miss Dikeman's hair has been brushed out. It is on now the left side of her body compared to more on the right side on the first photo.
And that second photo's capture time is 9:19 p.m., correct?
Correct. And the most obvious is obviously she's got glasses on compared to no glasses.
Thank you. And that 9:19 capture time is about 3 minutes different from the capture time of approximately 9:16 that we saw in Exhibit 254, the photo with Ms. Dikeman and Brantley, correct?
Yes.
Thank you. I have nothing further.
Redirect or recross?
Oh, that was fast.
Cross. Excuse me.
Are you for serious? They're really going to pick on these damn pictures? Do you know how fast it takes me to put on to like try to make myself look decent in a picture? Okay, no, just kidding. It y'all see me every morning,
Sergeant, I
and
wanna
this
look
is
at
what I look like.
154 again. Copy of the state's exhibit. It looks like there's a flexible fabric shelf system in that photo. Is that correct?
I'm not sure, but
I have one of these in my closet, so I know what this looks like. Let me zoom in on it.
Yeah, Corey was not happy. She was smirking to the judge.
Kind of looks like it's kind of hanging and the shelves are sagging a little bit.
yes.
The only empty shelf on this unit would be the bottom one. I can zoom out if you'd like to see the top.
I mean,
Yes.
Don't see any hangers that were apparently knocked over from taking a bag off of the top there.
No.
Let's talk about the pictures. Sergeant, would you agree with me that everybody takes pictures that they don't necessarily like or say, I'm going to delete this one of myself?
Sure.
And Ms. Dikeman, in some of those earlier pictures, would you say looked a little bit haggard?
Yes.
Like maybe she hadn't been feeling well?
I don't know how she was feeling.
And the photos that she was sending to Mr. Porfirio were the touched up versions. Is that fair to say?
I don't see anything where a filter was used to touch him up. I think her face was touched up.
Yep, that's what I meant.
Oh, okay. Yes.
Where presumably if Ms. Dikeman's trying to impress her date, she's going to take the picture where she looks good and send it to him.
I would assume so.
And just looking at some of the photos here, I'm going to bring 158 up to you.
yeah, Corey
He has
definitely.
it in front of him.
Oh, sure.
I mean, she's a bad person.
you agree with me, Sergeant, that some of the same facial blemishes appear on both photos?
Yes,
In other words, she has a cold sore or something above her lip.
I don't think it's a cold sore. It
Or
looks like a freckle or
Freckle or
something.
something. Same thing on her cheek there. Looks like there's either a freckle or something else.
Yes,
I was not a makeup expert until yesterday, but does it look to you that she applied foundation?
I'm not a makeup expert either.
Okay. And just looking at the earlier photo here, Sergeant, the 156. We can actually see that Ms. Dikeman does appear to have eyeliner on, just maybe not applied as consistently. Can you see that?
I can see her bottom eyelashes, but it doesn't appear that there's any eyeliner on there compared to 157.
I'll just walk up to you for 156 here. And again, I'm not sure the glare will capture this on the Elmo, but do you see eyeliner or what appears to be eyeliner on the bottom of Ms. Dikeman's eyelids?
I see black individual eyelashes.
I'm gonna try and publish 156. It's glossy, but we'll.
Yeah, she's not getting out.
And I'm gonna zoom in on her eyes. Can you see the shade underneath? I guess that would be her right eye.
Yes,
You see the shade under portion of what would be her left eye.
I
Why
can
are
see what
we-
you're pointing out. Yes,
And does it appear that there is, I knew the word for this yesterday, but the makeup that you put on top of your eye lids,
I don't know.
mascara?
I don't, I'm gonna object to this. I don't think he has a frame of reference for what our eyes look like with or without makeup based on this photo.
Well, you guys are talking about it.
I mean, he,
No, he's saying he doesn't know makeup,
Okay,
so
yeah.
I'll sustain the objection.
Why are we harping on her frickin' selfies? Her hair's not wet.
It's apparent to you that Ms. Dikeman was trying to make herself look cute to send a picture to Raphael.
asked and answered, Your Honor.
Yeah, sustain.
Is her hair wet or dry?
All right, any redirect?
Very briefly, Your Honor. Investigator, was the testimony we heard from Ms. Dikeman that the bag would have been placed up high out of the reach of children yesterday?
Yes,
And is there a flat surface on top of that clothes hanger?
yes, on top of that clothes hanger, there is a flat surface and there's other items on top of it as well.
Thank you. Nothing further.
Thank
Any
the
requests?
good Lord
Sergeant, do you still
above.
agree that there's no way to determine whether or not that bag was actually there on February 10th on top of the shelf?
I do not know that.
Nothing further.
Anything further?
Not on that, Judge. Thank you.
All right, you step down when I handle the exhibits.
Yeah. Now they have to talk about the damn jury instructions.
Any other witnesses from the state?
No, Your Honor. State rests.
Thank God.
So with that, ladies and gentlemen, that ends the testimony evidence for the trial. We did some work yesterday, so we do need a little time to finish up what we were working on. There are the jury instructions, which I'll be giving to you next, and then we'll be going to closings. What I still ask you to do is please don't talk about the case. I know we're done with the evidence, but until I give you the instructions, I can't have you talk about the case. And then once we do the closings, 2 random numbers will be picked, and 2 of you will be the alternates. I really do appreciate all 14 you made it through all the whole time, but we do need to get down to 12 people at that point. Having said that, we will see you. Every time I predict this, I predict wrong, but it will at least be about half an hour to 45 minutes. It could be a little bit longer. Okay, thank
Yeah,
you.
because the attorneys are a-holes and they can't agree on anything. So now we have to go back and forth about the language of what I'm going to tell y'all in the jury instructions. Okay, so yeah. So now we have to figure out what he's going to tell the jury, what they're going to actually charge her with. So we definitely know first degree. Now, what else are they going to throw?
Maybe give me 1 minute to incorporate what you just sent me, and then we'll print this off, have you look at it. We'll take about 5-10 minute break, and then we'll get together and talk. Just so you know, I did highlight 305 just because to remember that we need to talk about it and finish our discussion. But I'll incorporate, actually, I'm going to have Christina, and just so, this was not on the record. There was Ms. Rude sent a proposed addition to 275, and I happen to overhear that there was no objection to it. Is that correct, Mr. Zachary?
The 275 as to Mr. Pedron, yes.
Right, the part, and I was going to add that before the propensity language.
Sure, yeah, I agree, the state's version's cleaner.
Is that agreeable with the state?
It is, Your Honor. I think the indication was that it was okay to use the definitions of the pattern instruction. The only thing I indicated is that there's not a pattern definition for source of injuries. That one might be more self-defined anyway. The other ones, right, are more legal terms. But that was the only
Okay,
unknown there.
all right. So it's adding that and then the definitions of, I believe it was.
Yeah, the bracketed definitions in 275.
Right.
Okay, so they may not get to closings
Right,
till
that will
after
take
lunch.
me
I don't know.
a moment to do that. I'm not going to do that right here.
I don't know how long jury
but
instructions are going to take.
What do you, source of injury question? It's almost,
I think it's self-explanatory.
okay. All right. Well, we'll use the other definitions then. Anything else I should put in? In the jury instructions? Other than is there anything else?
To my knowledge, they're complete. We'll eagerly await our copies from Christina.
Yeah. And the state's okay so far, trying to incorporate that. Then the last issue are the verdicts. We are putting those together. One thing I did on count 3, which is normally we just say guilty, not guilty, then go to this question. I did put in that language that they must agree on about the event for either causing death or for great bodily harm underneath it. You'll take a look at it, and we can change that if you want the order to be a little bit like that sentence before the sentence or after. But I did add that. That doesn't necessarily, I'm not sure I don't know if there is a standard verdict on this, to be honest.
I'm not sure there is, but I think that language is really important because they do have to be unanimous as to that fact.
Right.
I would agree with the unanimity language.
Yeah, I don't want.
Jury
this to
instructions are
run into
very,
the
very
unanimity
important,
issue.
and the verdict form
Yeah.
is very, very important.
Okay. I'll, as soon as.
If y'all remember in the Karen Reed trial,
Thank you.
how they did the verdict form the first time was very, very important. That's why it was a mistrial the first time. In Michael's trial, the way the verdict form was written was very confusing. So it's very important how they make the verdict form. If they don't write it out properly, then the jurors are confused. So they don't understand the language. If you say someone is not guilty of one charge, then you think that you're saying they're not guilty of other charges or what have you. If you say they're not guilty of the first charge, you think they're saying you're not guilty of the other charges. You're assuming that the jury thinks you're saying not guilty of the other charges, so you don't mark the other boxes. That's what happened in the Karen Reed trial. So that's why she had to have another trial. So it was very confusing for the jury. Remember, the judge, who was such a witch, didn't do the verdict form correctly. So the same thing with Michael's verdict. They found him not guilty. It was confusing because they were trying to charge him with lesser charges, but he was found not guilty. The prosecution was still trying to come back and charge him with the lesser charges, but you couldn't do that because of double jeopardy. But they were trying to claim that since the jury didn't find him technically not guilty on the lesser charges due to the way the verdict form was written. See, it's all how the verdict form is written. It's all how the jury instruction is given. It's all like little loopholes in the system. So this is very important, how the verdict form is written, how the jury instruction is given. It's all very important. So if the jury form says guilty, not guilty, and those are your only options, and it says like manslaughter, involuntary manslaughter, or what have you, or it says like it's very broad and it says neglect of a child during, and you heard them talking about earlier, during the dates of January such and such to February such and such. Well, if she's found guilty of those certain dates, then of course of neglect, well, yeah, duh, she's going to be found guilty of those particular dates. So, right, yeah. So, yeah, and then the judge in Michael's case specifically said, we're never going to get you for these charges. So I'm going to put you in prison for X amount of years for the full length of time. Yeah. Yeah, they didn't have him on camera doing anything, actually, but walking. He was walking. Yeah, downtown Detroit, he was walking. So, yeah. It was he's no angel. We all confirmed, he's no angel. But, you can't put a guy in prison for walking all night long. That's like that's just so messed up. But I have been up, like I've lost so many hours of sleep just thinking about. I've gone on to the MDOT camera system. There are at least 4 cameras that her car should have been picked up on, coming from the wedding venue to her house, that we never saw video footage of. They could have picked up her infotainment center on her car. We didn't get that information. What about Herbsman's infotainment center off his car? But they claimed that, nothing was on. They claimed that there was nothing on any of their, GPS systems. His phone, remember, was on airplane mode, or it was off. And they just accepted that fact because it was, Shabbat or Jewish, whatever. It just makes me. And then remember, even in the podcast spiraled, is that what it's called? They said that, oh yeah, and then the white guy that ran the distance to see if Michael could have done it. Yeah, that guy. Yeah. Yeah, where they blocked off the streets with cop cars. Yeah, and in the podcast even they admitted that they had the autopsy rushed, and they knew someone. The family actually was interviewed for that podcast, and the family said that they knew the medical examiner and they had the autopsy done quickly so that they could have her buried in time because of Jewish tradition. So yeah, they didn't do a thorough autopsy. Just like the medical examiner that got up on the stand for the defense said it wasn't finished. Remember, they didn't even measure the actual depths of the wounds. And the assistant medical examiner, I believe, that got up on the stand and testified, she was she was giving measurements not even based on actual measurements. She was just saying, and then she said none of the wounds were fatal. Actually, they weren't even deep. So she basically just bled out. So we don't know, and there was no time of death per se. We don't know how long when she actually, yeah, they based her time of death on her ADT sensor. So we don't know how long she was on the sidewalk. Like that was the other thing. Well, we don't know if he had a pocket knife. We honestly don't know. There was one in his jacket, but we don't know if he was carrying it that night. They're just assuming because she had knife wounds and he had a pocket knife, but we don't know. Like they're just trying to pin it all together. They were just trying to piece it all together. And none of her DNA was found on anything, it just makes no sense. So they were just trying to piece it all together. They're trying to put a square peg in a round hole. Yeah, it's just frustrating. Yeah, none of them. They took those knives apart. So it's just crazy to me. But I have like followed the route of her coming home from the wedding venue. I just have to like, and there were at least 4 main cameras that could see her driving from the wedding venue to her home. And never mind the smaller cameras. And then there's so many cameras from just around the school area. And then I remember back then I talked to the man who owned all the stuff up there is nuts. Oh, did Detroit win last night? That's what I meant to check. Please tell me Detroit won. Oh, man. Detroit lost. In overtime? Crap. That sucks. Dang it. Stop it. I stop it. I'm now that you will not believe it, but I love the Pistons. I have been a Pistons fan since Isaiah days, honey. I love the Pistons. Dang it. Oh, in overtime. Damn it. It's bad luck to watch. That's why I didn't know if they won or not. Dang it. Dang it. I'm so upset. This is the first time they've made it this far. And oh, man. Oh, dang. I love the Pistons. I'm an Isaiah Thomas fan from like way back. He was, Isaiah Thomas played in the very first McDonald's basketball when McDonald's teams paired up the best basketball players in the country. Isaiah Thomas was on the very first team. I love Isaiah. He's one of my favorite basketball player of all time, over any basketball player ever. Isaiah Thomas, my favorite. So, and he was a bad. He was tough little point guard. I wanted him to be like, I thought he's better. He was better to me than any ball player. So, oh. And I'm not big into basketball, but I know I watch any sports documentary. Anything that has to do with sports, I will watch it because I love sports. But basketball, I'm kind of over because all these players right now are on my nerves. But I love old school sport, like old school back in the day. Come on, Judge. Let's go, Judge. I don't know if y'all been following the Julio trial, but that's in the penalty phase, which is crazy. That one of the moms of the gangbangers got on the stand and she was trying to say her son was being misrepresented, and the judge stopped that quick, like. So she took her off and sent the jury out. She wasn't having that. Oh yeah, so we go to MotoGP, Superbike. Yeah, my husband used to race motorcycles, Jenny. So Austin is the only city in the US that has MotoGP come to the US. We used to have 3 US races. There was one in Indiana, one at Laguna Seca in California, and Austin, but now it's only Austin. So we only get to, thank God it's here in Austin. So it's usually right around our anniversary, and we get to go see our favorite rider. Who's your favorite rider? Because this is going to make or break our friendship, Jenny. This is a deal breaker. I don't know what's gonna happen now. This could be the end. Oh no. Oh no. Yeah, we never miss racing. And then we have Superbike coming in September. F1, I've never been to an F1 race. Can't afford it. Are you that's insane. Ooh, and the guy who used to run F1 is taking over MotoGP. So maybe MotoGP will finally get the coverage they deserve, but that means tickets are going to go even higher than they already are. And it's already expensive. So our favorite rider until he retired, obviously we never wanted him to stop, but he had to stop. He can't race forever, right? Was Rossi. Rossi's our favorite. And then our favorite rider now is, well, we love Luca because he's Rossi's brother, but Luca is not winning. So we love Bez. I mean, Bez and Ross Rossi's the GP rider. But Bez is our GP rider. I'm not big into the F1. Keanu Reeves, he has his own bagger team for his ARC motorcycles. Michael Schumacher, man, he's like old school. And even Keanu Reeves is racing in the Toyota GP, I think. Yes, Rossi. Oh my gosh, Rossi. Oh, we miss him. He was so good. He was like, he is the ultimate champion. And Marc Marquez just wrecked last weekend before last. I don't remember, but Marquez is trying to break Rossi's record. He's not going to break it because Rossi has won in every class on every kind of bike except the Ducati, I believe.
You be seated. You be seated. Did I bring? Oh yeah, I did bring that in.
Horner's team? I don't know. Horner's name? I don't know. Okay, we need to get on with this shenanigans. This is going to take them forever. Okay, we're waiting for jury instructions for them to decide what they're going to do for jury instructions. And we all know how this goes. Yes. Oh my gosh. And you know Rossi always like pulls his leathers out of his butt every time.
We didn't print out the verdict.
Rossi's racing cars now.
Just realized that.
He's still racing. He's just racing cars. And he has look at my Sky. I have my Sky Racing sticker.
There should be a cup.
You know I represent.
I'm gonna go check something quick.
Oh my gosh.
I'll come to this house. You don't have to do all the rest.
I have so many Rossi. Oh my gosh. I love Rossi. He is so fun. I just wished he could have won. We were at the race in Austin where he almost won and Rins pulled it out at the very end. And then we were at the one where he crashed out in the freaking second lap. and Marquez, of course, won. But yeah, we were at the race where Renz beat Rossi at the very end. I can't believe he didn't win. And then it was the last season that Rossi had the chance to win like his 10th championship. All because of Marquez. Marquez is a bunghole. Yeah, Schumacher, man. He's amazing. That F1 is crazy. I've never seen an F1 race. I've watched the documentary though. Like I said, I'll watch any sports documentary. Anything that's got to do with any kind of sport. Even if golf. I've even watched golf documentaries. Although I have not watched anything about curling because I don't think that's a sport. I don't even know why they put that in the Olympics. That does not make sense. Oh, really? 1991? See, we have it here in Austin every October. But it is so expensive. Outrageously expensive. Like, there's no way we could afford to go. We have everything here in Austin. We have MotoGP, we have F1, we have PGA. The only thing, we don't have here is an NBA team. I mean, an NBA team and an NFL team. We don't have those two things, which is crazy. So we don't have that, but we have like other really, really, really expensive things here. Yeah, usually he's like, let's go. Yeah, we only get to watch the highlights of the races. But it used to be MotoGP came here in April. Now they're here in March. They come like a couple weeks earlier than they used to. So we go. We haven't. Well, Mike got to go this year. I didn't get to go this year because I was having a nervous breakdown. So I missed the race. And last year I didn't get to go because I think I was having a seizure. I don't freaking know. But whatever. But we're not going to miss next year. I'm not missing next year because Bez. I hate that I missed this year because Bez is our guy. But maybe next year. Okay, let's figure this jury instruction out and how many charges we're going to throw at her. Well, my husband works with motorcycles. He used to race motorcycles. He knows everything and anything inside out, upside down, sideways, corners, all about motorcycles. Like, there's not a thing. If there was a way, I don't know how, but if there was a way that man could make money just on the useless knowledge he has about motorcycles, I mean, we would be filthy rich. Just the amount of stuff he knows about motorcycles. And he gets to drive home a different motorcycle from work like every week. He's on a different bike. And he has 2 bikes. It's just silly. I keep telling him he needs to make a YouTube channel. Riding these motorcycles. Oh my gosh. Dude, figure out the jury instructions. Okay, so I know I told y'all yesterday and this morning, but I have to go to work this afternoon. So whenever they go to lunch break, I will still keep it on the trial, but I will not be here. So I'll let y'all keep watching it. So I guess they're going to do jury instructions, closing arguments today. And I don't know if the jury's going to get this in their hands today or not. I don't know. Because, the prosecution does their closing, then the defense will do their closing, and then the prosecution gets to do their rebuttal closing. And we know how they've been going tit for tat back and forth with each other. And I don't know how long these jury instructions are going to be. So, as long as it's taken him to figure out the jury instructions, so this could go into the afternoon, obviously, before the jury gets it. So do y'all think that the jury will get it today? Yes or no? And do you think the jury will come back?
Okay, everybody ready?
Yes, Your Honor.
Yes, we're ready.
Stay ready.
Yes, Judge.
All right, let's go through the instructions. We'll deal with the verdict. I already see there's some problems with the verdict, but we'll deal with that second. Okay, page 1, standard, page 115, or page 2, which is 115. Any corrections to page 1, 2, 3, 4, and goes for a while, 5, 6. Any corrections from the state's perspective on 115?
No, Judge.
State or defense?
No, Your Honor.
Okay. So that takes us to page
Oh, Judge, I was specifically referring to count 1. We do have a minor change in count 2 on page 9.
Yeah, I was just getting there.
Okay.
No, I'm just talking about count 1. Now we're in count 2. I'm sorry. I meant count 1. Now we're in counting chronic neglect of a child consequence. Where's the, what needs to be changed?
On page 19, excuse me, yes, 9. Thank you. It should be action or failure to take action, which is what the language is on page 10 when the elements are described.
Can you just say what?
Yes, so Josie Dikeman, reading the charging language there, being a person responsible for the welfare of a child through her action, and then it should be or failure to take action for reasons other than poverty. That language is already on page 10. Just
Right. Yeah.
Hey, Mark,
You
how
agree
are
with that?
you? You made it.
I think that's what the court ordered yesterday.
They are going over jury instructions right now,
One more moment.
trying to decide how they're going to tell the jury to use all of the evidence in their decision making. So basically, right now they're also trying to decide if to use Josie's lack of action or action. She's screwed. No matter what. We've been talking about sports while we were waiting on the judge and everybody to get their act together.
Sorry, it's all of a sudden I did that and all the spacing got strange.
And what our favorite sports are. I don't know what your favorite sports are, Mark, if you like sports. But what got us on it was that the fact that my Pistons, I don't know, lost last night. So I'm pretty upset about it. But I love all sports.
Okay. All right.
Except curling. I don't know what that is.
Count 2.
No, Your Honor.
Anything from the defense? All right, hearing none, we'll go on next to.
I'm still scanning, but I.
Oh, okay, go ahead, sorry.
All right, yeah, we can go to, no, someone else.
Okay. Hold on one second. All right, going on to count 3, which is on page 13. Any from the state, any changes?
No, Judge.
Oh, athletic. I played volleyball too for like 2 seconds. I actually, one time I was practicing my overhand serve, which I really, really sucked at.
Previously, no.
Okay.
And I was practicing it up against the wall.
And then 140
Dumb.
is standard.
And the ball bounced back and smacked me
We did
right
make
in the
that
face.
Change to reasonable
My coach
hypothesis
died
yesterday.
laughing. It hurt.
Spacing's off. I know. Hold on one second.
Needless to say, it just verified that my overhand serve sucks. And you shouldn't use the wall as a practicing.
Anything on 140?
No, Your Honor.
Well, I was not even good enough to try out for college. Or even high school, apparently, because.
Any corrections to that?
No, Your Honor.
No, Your Honor.
170, 155, any corrections?
No, Your Honor.
No, Your Honor.
I think I just wanted to be athletic, but I just was not.
So here's 275 with the modification that we've added. I just put evidence presented for Josie Dikeman, evidence presented for Derek Hedren as a way to distinguish the two as headers. That's one addition, plus I added obviously the definitions below.
Judge, I think there are some changes in the definitions for Mr. Pedren, because obviously the pattern instruction is designed for defendant.
Oh,
So
yeah.
we need to change defendant in there, or the defendant to Mr. Pedren, and then I think probably change offense charge to conduct alleged
Yeah.
for each of those.
Yeah, it was
Okay, Jenny,
quickly
again,
done.
who would your team be in the U.S.? Because this is a make or break also, because I know my team.
Needs to be done.
We I don't know if we can be friends.
to conduct alleged.
I think that fits best.
Any objections to that?
Judge, I distracted by the noise outside, which section?
So we're still on definitions of Derek Pedron. So it says right now, opportunity, that is whether Mr. Pedron had the opportunity
Yeah, no objection.
to
Objection to swapping.
commit to,
I think just relating to the conduct alleged.
so it'd say whether Mr. Pedron had the opportunity relating
Well, that's
to
smart
the
thinking
conduct
because
alleged.
Texas and Florida have no state
Basically,
tax.
Whether he had the opportunity at the conduct alleged.
Yeah, I think if we just change offense charge to conduct alleged for each of them.
I need one more word in there, though. That's the problem.
For each
To
of them,
commit conduct alleged,
commit the conduct.
the conduct
Alleged.
alleged, yep. Intent, whether Mr. Pedron. Active.
They got to get this verbiage just right in these jury instructions, or else. Well, my team for baseball is the Dodgers. I'm all over the map with my sports stuff. Basketball is the Pistons. Baseball is the Dodgers. Football is San Francisco 49ers. My college team is Auburn, of course, because I'm from Alabama. All right, come on, y'all. LA. They're from Los Angeles, California. What's crazy is California is a beautiful state. It's gorgeous. You go from like sunny, beautiful beaches to snowy capped mountains, but that state is garbage.
Okay, so this is how that paragraph will read.
So pretty though.
Um,
I used to live there. So nice. But it's
the
so
definitions
expensive.
For Derek Pedron, the evidence was received on the issue of motive, that is, whether to, excuse me, I know I missed one. That's why I read it out loud.
I think gas there is like over
Whether
$6
Mr.
a
Pedron
gallon.
has a reason to desire the result of the conduct alleged. Opportunity, that is, whether Mr. Pedron had the opportunity to commit the conduct alleged. Intent, that is, whether Mr. Pedron acted with the state of mind that is required for the conduct alleged. Identity, that is, whether the prior conduct of Mr. Pedron is so similar to the offense, the conduct alleged. That it
Now,
tends to
hockey, I'm the
identify
Bruins,
defendant as the one who
the Boston
committed the
Bruins.
conduct alleged.
Weird.
Context.
I know.
Defendant.
All over the place.
Let me find that, Mr. Pedron. As the one who committed the conduct, so it says.
That's in
let me go back.
Massachusetts.
Identity, that is, whether the prior conduct of Mr. Pedron is so similar to the conduct alleged that it tends to identify Mr. Pedron as the one who committed the conduct alleged. And then finally, context or background, that is to provide a more complete presentation of the evidence relating to the conduct alleged.
Good.
All right.
I think we have the same issue or slightly different issue in the propensity-free reasoning part.
Yeah.
Because that's still just relating to Ms. Dikeman.
Just hold on one second.
Judge, I think we could just change that to because a person committed another act or crime, they probably acted the same way again.
Shuzacker.
Judge, this is another one of those scenarios where the constitutional rights belong to Ms. Dikeman, not to Mr. Pedrin. I think the language is appropriate.
Woo! I mean, can't say a person because
Even with character, though, Your Honor, you can't argue propensity.
what other person would it be? The man in the moon?
I'm going to leave that as, because the issue you run into with the propensity-free reasoning is really paramount on the issue of the defendant. There are other issues that come in. It's, as seen, 275 was originally designed to be for defendants. That's why we ran into the issue. I'm just going to leave that as is. Yeah, I mean, the propensity-free, it's explaining an example anyway. That's what it really is doing. And then the very last phrase needs to be there because that's correct, about Ms. Dikeman.
Sounds good.
Yeah, all right. So 157,
Objection.
No objection.
150, I should 148, 147, 150,
Looks good.
No objection.
hold on one second, 158, 190.
Standard instructions, no objection.
Yeah. I did have to modify 158. Is that okay?
Yes.
Yeah, it's fine. It's modified.
Okay.
Could you imagine, like your life is on the line and you have these people just
195,
going back and forth?
and then 195, 200, and then
I mean,
205.
and you obviously don't
All standard,
understand
No objection.
this language.
300, standard,
No objection.
3,
No objection.
325, 327. We change those.
Then
No objection.
340.
No objection.
no objection.
And then I made the decision not to include 305 in the end. I decided that it's, there's too many issues that come up with it. It's not recommended. You can make arguments, obviously, during closing. And then back to this 160, 465, and 484. Let's do 160, 465 first. Any problems with that?
I feel like I'm in math class.
No objection.
Okay, 484. I'm just wondering.
Right, Jenny? That's why we watch trials.
I think
Other people's.
I was going to add, so this gets to the verdict question. What I was going to add at the bottom of maybe before the dated line on, so if we're looking at count one, verdict, page 1, that I would add if you find Josie Dikeman not guilty of count of first degree intentional homicide, go to page 2 and then, or go ahead, or do you have better language?
Because the way I usually see it done is that it says first degree intentional homicide, and it just says guilty. Then there would be a second one for first degree reckless homicide that says guilty. Then there would be a third form for second degree reckless homicide that would say guilty. And then there's a fourth independent verdict form that says we, the jury, find the defendant not guilty as to count 1.
Yeah, That's how we did it in a number of other cases. That would be my preference as well.
Okay, all right. So we'll, I have to admit, I don't have very, very often, especially this one. So you would just have everyone listed. Do you need to have a line that if you find them not guilty, just,
Because they're not necessarily finding not guilty, they're just saying they can't agree, so then they're moving on to the next one to consider that one. That's how the instruction tells them. It says if they can't agree on the higher count, then they move on to the next one. Not that they're making a finding of not guilty on those higher counts.
should that line be in there? If you
I
cannot
think
agree
it-
on
If
this
you
first
wanted,
count?
I think you could add a line as to each one. If you cannot unanimously agree as to first degree intentional homicide, you must consider the next lesser included offense. Then, but it's up to your honor. Otherwise, I think we'd be fine just having a guilty for all the three, and then having a not guilty as to count one as the fourth.
I'm confused. Now I'm
If
confused.
the court still has the instructions from the Mitrell Anderson case, that was the language we used.
Well, that might be helpful. Hold on a second. Oh, that's a long time ago. I'm not sure I have that. All right. So assuming we change that, that's in count one. Count two, any problem with the language in count two? And oh, by the way, what I would do is 484 would then change to reflect whatever we end up doing. Count two, any problem with how count two is listed there?
No,
Reserving our earlier objections, no.
And then count three. I think the language,
I think you just have to add under the first question.
yeah,
To answer yes, you must agree on the violation that caused death.
yeah, I would put it, yeah, I would put exactly the same line. For some reason, we just don't have that there, but that would be the one change I would make. It would say, to answer yes, you must agree on the violation that that caused death. Yeah,
Which is what?
that makes sense, Mr. Zacher.
Yes.
Okay. I'm gonna make those changes. We're gonna go make those changes and then I'll be right back and we'll do that last little part. Otherwise, I think we're doing good on the,
Yeah, does the court want to address the verdict forms now, or?
that is I'm gonna address the verdict forms and change one. We would change it to what we just talked about. Or is there another issue?
Yeah, my request would be to require a four-person signature under the jury questions as well on count three.
Any objection to that?
Sure, that's fine.
Okay,
I mean, no objection.
yeah. All right, we'll try a four-person signature.
Oh, as if the trial's not
Okay,
tense
well,
enough,
we'll
but
have to figure out how to do that for me.
think
All right, I'll
about
be right back.
how many people are in that seat. They're not that educated. Think about it. I mean, Josie Dikeman, she has a high school diploma. I'm not knocking a high school diploma. I'm just saying none of us are well versed in the law, right? They're just spouting off. I felt like I was in a math class with all these numbers they're spouting off. I don't know what the frick they're talking about. So we don't understand what the heck they're saying. They know all of this legal jargon. And I mean, she doesn't understand. They're talking about all of this stuff. Her life is in their hands. They're talking about how they're going to give the jury instruction. How the judge gives this instruction is very important. What is on that verdict form is very important for how they decide her fate. That's anybody. So it's crazy. I mean, guilty, not guilty, innocent, whatever. It's your life is in 12 people's hands. 12 people. Could you imagine? I mean, I've never been called for who's been called for jury duty in here? I've never been called for jury duty. I've always wanted to. Never been called. I know. Would you rather? So, would you rather have a judge, just a single judge, or a jury decide your fate? You've been called for jury duty. Did you get picked? I've always wanted to be called. Oh, dang. My husband got called for jury duty and he didn't even have to go. But I was sick. It was when I was in the hospital. So they let him slide. Yeah, I know. Could you imagine if Michael had said, "I'll do a bench trial"? We call them here, Jenny. We call them a bench trial. If a defendant can choose to do a jury trial or a bench trial, and a bench trial is just the judge. So a defendant can decide if they want to have a jury of their peers or if they just want a judge to decide. And when we do a judge, just only a judge, it's called a bench trial. But could you imagine if you got a judge that was like snot face, like, yeah, like the one in Karen Reed's trial or Michael's trial? Ugh, you would be like screwed. Or what about this judge even? This judge is like in a hurry. I don't even feel like he's paying attention to a lot of this stuff. Like he's just like move it along. Let's go. I don't want to hear this. Yeah. So I don't know. I have seen a few judges that are very, very attentive, take notes, pay attention, but I've also seen some judges that I just wonder if they're even in the same room sometimes. I mean, I don't know if you've noticed on some cases where, like, are these judges, some judges are on their phone, some judges I wonder if they're falling asleep. I don't even know what's happening. So I would be curious if I would want a bench trial. I don't know. It would worry me. And again, the corruption, the amount of corruption, and if they're burnt out. But then again, I don't know if I would trust 12 people, because I don't know what kind of mood those 12 people are in. Especially like right now, these people are about to get this trial at the end of the week. They're ready to go home. They're done. It also involves a child. So, I mean, a child has passed away in a very awful manner. So, in their minds, somebody's got to go down for this, right? Whether she physically did it or did not do it, she neglected the child. She should have left. That's how everybody's thinking that. Everybody's saying that, especially in other chat rooms. Everybody's like, why didn't she just leave? Why did she stay? And if he was really abusing the kids, why didn't she do anything about it? I mean, everybody's saying it. So I just think no matter what, she's going to get something. So if you think about it, it's a toss up. But I don't know. If you'd rather have a jury or a possibly corrupt judge. Or if you just don't do anything, then you don't have anything. Yeah. Yeah, Jenny. I mean, it's, or if you just don't get in trouble, then you're good. You don't have to worry about it. Maybe don't do stuff. But these jury instructions are super confusing. Yeah. Move out to the woods like I'm about to do. Move out to the middle of nowhere. Well, I'm not moving out to the middle of nowhere, but it's going to feel like the middle of nowhere because I am going to be farther out. I'm not going to know anybody. Be all by myself. I'll be all alone. Oh my goodness. Okay, so he's going to get jury instructions out. They're going to go to lunch. Then they'll come back probably and do closings. I'm not going to make gingerbug. I'm not going to make bread. I'm not going to make anything, Gwen. I barely do my own laundry. Are you for serious right meow? It's a miracle that my house doesn't look like frickin' Josie's. Don't look at my bathroom. No, I'm just kidding. I am already bored. That's why I'm doing live streams now. Again. As you can tell, I have no friends. I have no life. This is my life. Yeah, but I'm not going to start cooking. I'm not that bored, honey. I'm not so bored I'm going to start like cooking. Mm-mm. We are not going to be sharing cooking tips or tricks or none of that. That will never happen. That would be like, no. I know. I won't ever be that bored. I think, you know what? That's not true. I think there was one time, one little snippet in my life where I cooked, but I had a tumor. In my defense, I had a tumor. Before I had my tumor removed, I cooked all the time. And then the tumor got removed, and miraculously I stopped cooking. So weird, right? So weird. Well, Gwen, I mean, you keep talking about all this bread and all this stuff. I know, Mark, right? Like, I'm saying, it took a tumor to make me cook, okay? I learned my lesson. Well, Gwen, we are not benefiting from you cooking. You're talking about it, but we are not getting anything out of it. I'm just saying. I don't have any bread. I don't have any ginger. I got nothing. No soda. No nothing. So Working is overrated. As I am broke, so broke, I can't afford to pay attention. Yeah, I don't want anything, any explosives. I think that would be. I don't watch any cooking programs because I'm not. I have my mama's cookbook. She gave it to me, passed it down to me. I don't know why she did that. Why would you bake 40 mini loaves? Who needs that many loaves? Mini loaves, mini loaves. I used to have this girl at work, this young girl. She was really young, in her 20s, and she would make sourdough bread all the time. I'm like, who is doing? Why? Are you a Quaker? What the heck? She loved doing it. I mean, I didn't complain. I'm not complaining because she would bring sourdough bread to work all the time. I mean, yeah. I mean, I didn't buy it. She brought it for free, thank God, because. But now I don't get sourdough bread because she don't work there no more. But oh my goodness, you're doing too much, Gwen. Doing too much. So I have instant noodles in my pantry and instant mac and cheese, if anybody cares. Ooh, I do make rice in my rice cooker. I put the rice in the rice cooker, pour the water, and then I hit the button. And it makes the perfect rice. If you don't have a cuckoo rice cooker, you need to get a cuckoo rice cooker. It's the best rice cooker. They're on Amazon. I'm not sponsored by Cuckoo. Although I am a little cuckoo, so I could be sponsored by Cuckoo. That'll make a lot more sense. Okay, don't forget, y'all, I'm going to leave it on the trial so y'all can watch it. But I know it's going to suck for y'all, but I have to go to work. I know y'all are heartbroken, but I will leave it on so you can watch the closing arguments so you don't have to go to another channel because but I will leave it on so you can watch the closing arguments and verdict watch because I guess they're going to get it today, but I don't know. I don't know how long the prosecution is going to talk. Like I said, the prosecution will do their closing, the defense will do their closing, and then the prosecution will do their rebuttal. I imagine it will take all afternoon because they're pretty long-winded. But I'm going to have to be going to work at noon. but I'll keep it on for y'all. They're going to go to lunch. You guys will get a lunch break, but you can stare at the flags. But just so you don't escape to another channel, I'll keep it on. So you can watch the closings. And then I will see you back when I return from work. Okay, Jenny, enjoy your supper. We say supper in the South too. Maybe by the time Jenny gets back, they'll be on jury instructions. It's too bad they had a rebuttal witness this morning, because they could have had the jury come in later and not wasted their time just chilling. Because, you know, even though they say don't talk about the case, you can't discuss the case, do you think that the jury is in there not talking about the case? What do you think they're talking about? What do you think they're doing? Because we're here, right? We're talking about it. I mean, of course, we're talking about other stuff like sourdough bread and ginger bug. But, I mean, do you think they're not talking about it? Or do you think somebody's monitoring them in there to make sure they're not talking about it? Because it would be hard not to, right? I've never been in a jury room, so I don't know. I would just think it would be hard not to. Oh, and can someone explain to me why is Trump in China? Why are we rubbing shoulders with Gigi? What are we trying to get out of this trip? Do we know? We are not. We are not trying to get anything out of this trip to China. I know, right, Mark? I'm like, what are we trying to do? Oh, they're trying to get something out of us? I mean, I don't get it. I don't understand. I don't Thank you, China. China. Either way, I don't understand it. What is the whole rubbing shoulders, having champagne? Why is Elon Musk there? Why is Apple there? Why are all of these heads of companies having a big dinner party in China? I mean, I don't get it. What is happening over there? What's going on? Well, I'm pretty pissed about the whole Iran crap anyway. I don't even want to. I probably shouldn't even get this started. We should have never did the whole bombing of Iran in the first place, because now I'm seeing, okay, Gwen, high gas is crazy. That's why we got to move to the other side of town. I could have just stayed in my little cloffice. But I don't know. I don't get it. I haven't really been paying attention. I just know we're paying almost $5 a gallon for gas. And that's insanity. The only thing I got out of it is that they definitely want the US to like be on their side with the whole Taiwan thing, which I don't understand the whole Taiwan situation. Is it 438? It's like 450 at one of the gas stations here in one of the ritzy neighborhoods. It's nutty. And they're saying that it might go as far as 560. So I'm just flabbergasted. I'm just flabbergasted at how much. I mean, in Texas, everybody has a 4x4. It's just wild. I mean, it's just wild. Everybody has a jacked up pickup truck here. It's just, and why, I don't know, because everything's flat as hell. It's like, so it's just shocking. It's just shocking to me. I'm really like, I don't know. I don't get it. Yeah, and my friend, she used to have a diesel. Thank goodness she doesn't have that anymore. And then my cousin lives out in California, so they're paying like almost $6. Okay, y'all, what the heck are we doing here? Have y'all seen, so I know I asked about worst ex ever on Netflix. Have y'all seen that? That has the story of Wade Wilson. Obviously, I think we talked about the detective that could have put him, like those two women could possibly still be alive if it weren't for that detective that basically let him off. Yeah, worst ex ever. There's 2 seasons of Worst Ex Ever on Netflix. It's pretty wild. If you watch that, first of all, if you watch it, you just see how messed up. Just that's like that show I was telling you about, Should I Marry a Murderer? I mean, I just the fact that the show is called Should I Marry a Murderer, the fact that you even have to ask yourself that already says everything we need to know about you. But your self-esteem has to be in the crapper. If that is, they made a whole documentary series about you and called it Should I Marry a Murderer? What the? Like, honey, that's where you're at in your life? So yeah, this is, I mean, I'm sorry, not all women, but women need to get their shit together. Like, we cannot change men. We can't change them. It's not going to happen. You're not the one that's going to do it. But all of these women in every one of these worst ex evers, Should I Marry a Murderer, all these shows, every damn one of them fell in love in like the first 2 or 3 weeks. And this was the one. This man was the one. And next thing you know, he killed like how many people? I don't know. Or tried to kill them. It's crazy. It's crazy. But when you see the shows, you'll just be like, what? Just listening to it. You just go, I can't believe that makes no sense. That makes 0 sense. But Wade Wilson on Worst Ex Ever. Because they made a Hulu show about him. They made the Netflix show that, I mean, he's the one in Florida. He had the tattoos on his face. He's pretty awful. What's so sad is he had a good family that raised him. And he could have been a good person. So I don't know what happened to him. Some people are just evil. What is going on in the courtroom? I thought all they had to do was change the verdict form. They are still not back. This is wild. So Corey Richins, they're going to try to get her a new trial. They ask for a 90-day extension because both of her attorneys are going to be out of the country in June and July. The judge said no. They could get I think a 14-day extension, but not a 90-day. So, I think they were asking for a new trial, not an appeal. I think a whole new trial yesterday. I did not see the kids statement. I'm going to play it because I want to hear what they had to say.
I was in a bedroom with my brothers and I didn't know what was happening. At first, I was really scared because I didn't know what was happening and I had no control and I felt helpless. I felt really overwhelmed. After my dad died, Corey would put us in the basement while she was with the neighbor. I felt scared because I thought something really bad was happening again. She would take me to places that smelled really bad. Everything she did made me feel uncomfortable. When someone talks about Corey, it makes me feel hateful and ashamed. She took away my dad. It's made me have a hard time trusting people. I was scared that Corey's family would come to my school and take me. I had to go to counseling with DCFS in Heber, and I did not like it. DCFS made me talk to Corey, and I couldn't do things that I wanted to do. I felt not important to anyone. I feel a lot better about myself now than I did with Corey. I can't ever see my dad again. I want her to go to prison forever. If she got out, I would be so scared, really mad, and I wouldn't want to go with her anywhere. I'm worried that she would take me away from Katie and Clint. Once she is gone, I will feel happy, and I will feel safer and relaxed and trust people more.
Thank you.
Oh,
Christina.
Yes,
Good
Your
morning.
Honor. I am Christina Greening. I'm a licensed clinical social worker, not registered play therapist, and I will be reading for AR. You took away my dad for no reason other than greed, and you only cared about yourself and your stupid boyfriends. You were not caring and watching over me and my brothers. I had to be a parent to W. C and I would walk him to the bus stop, feed him, and watch him. You were not concerned about our health. When we got hurt, you didn't even care. When C got ran over by a side-by-side, you still made him go to the soccer game that day without taking him to the doctors first. You would lock C in his room and I would have to go to the kitchen and bring him food. You shamed us when we didn't want to eat uncooked lasagna you made. We threw it away because we couldn't eat it. Then you made us watch videos of children starving in war areas. You wanted to scare us into eating something that wasn't cooked. You wouldn't let our dog outside, and then the dog would pee inside. You created this problem, then you would smack my dog on the head as hard as you could. You wouldn't let me put my kitten in the garage for safety at night, and we found it eaten by raccoons the next day. You wouldn't let us turn on and use the heater lamp for the chickens and bunnies, and they froze to death. You would always argue with my dad and lock the door. You were not playing the role as a real mother does. You were doing the opposite. Now my dad can't be my coach anymore, can't be at any of my games. He won't be at my birthdays. He can't teach me how to drive. He won't be at my graduation, and he can't take me camping or fishing. You made me paranoid about sleeping on my dad's side of the bed by saying I might die or get harmed when I was just trying to be close to my dad after you killed him. You took away everything from me and my brothers. I don't want you out of jail because I will not feel safe if you are out. You have never said sorry for anything that you have done to me and my brothers. I don't want you to hurt anyone again. I know that you will need to stay in jail to fully take accountability for what you did to me, CW, and my dad. With you in jail, I will be able to continue to feel safe and live a happy and successful life without fear of you hurting me or anyone I love. Thank you, Your Honor.
Thank you. Sarah?
Wow.
Yes, my name is Sarah. I'm a licensed clinical social worker and registered play therapist, and I'm going to read the victim impact statement for CR. My name and age now, my name and age I was at the time of the crime. CR, age 12, now 13. I was 9 when my dad was murdered. What I would like to see happen if the perpetrator is convicted of the crime, I would like to see Corey get a life sentence. My thoughts regarding an appropriate sentence for the person who is accused of this crime and if they are found guilty. I think Corey should get a life sentence because what she did is very sick, because it had no reason to happen and it impacted a bunch of people, including me. These are some reasons why I think she should have a life sentence. The information I feel is important for the judge to be aware of in sentencing. I think the judge should know that my dad was a good person and very thoughtful and kind and helped whoever needed help. He was always taking the extra mile to help people. My physical injuries as a result of this crime are as follows. I was sleeping and then I went to get a drink of water, then went back to bed. And when I woke up shaking and Bailey called the ambulance and they came and I couldn't talk for a while, I think Corey had something to do with it because she didn't call the ambulance. She called Bailey and Bailey called the ambulance. At the ER, Corey resisted to have my blood drawn. And kids who usually have this kind of seizure is when they are a few months old to a year old. I learned later that Corey bought more fentanyl and had it in the house when this happened. I think this is what happened. She did what she did to my dad in the living room. My experienced emotional injury because of this crime is described as follows. Sad. I feel mad that I have to feel sad. I went from being scared for my life to feeling really good. I was scared for my life because I didn't eat that much. Corey was always drunk or gone. I was always locked in my room. I can't remember, but I am pretty sure the lock was on the outside. Corey threatened she would kill my lizard because we didn't want to watch some weird show with her. All of our chickens died because there was no food or water. My rabbit died because we didn't have food or water. The goats almost starved to death because she bought moldy hay and she didn't water them. Nothing ever got fed or watered. It didn't feel good to worry about my animals. I felt like I had to take care of my siblings. Ash mostly took care of me though, because I was locked in my room. Ash would bring me food. Corey would lock me up if I told her she was drunk. This happened pretty much daily. I feel angry that she locked me in my room. I am angry almost all my animals died. I am angry she threatened to kill them. I am angry she killed my dad. I started to feel really good when I moved into a safe place. It was safe because the people around me were safe, Katie and Clint. I felt safe at Jake and Shalina, I believe, because I wasn't with Corey anymore. Counseling. I feel annoyed that I have to go to counseling and tell the story about what happened 55 million times. I feel better now because I know it's to help me. I would like to not have to go to counseling. I would like to have to not worry about anything after this trial is over. I want the judge to know. I hope Corey gets convicted to a life sentence. Corey is always drunk. I want the judge to know my dad was a good person and I miss my dad. I miss my dad, but I do not miss how my life used to be. I don't miss Corey. I will tell you that. Thank you.
Thank you.
What? Okay, we're back. Oh, right?
We've now changed 484. I believe I've given the parties copies of that.
Dang, those kids
There
were
wasn't any
brutal.
mistakes on,
Locked in the room, locked in
I
the
say that now,
basement,
but
always
that were
drunk. But
noticed
hey,
at
they
this
were
point in
consistent
time. I
about
think we've
the
incorporated them
animals.
to the jury instructions. We'll make the copies.
All their
for the
chickens
jury.
died.
That's gonna take another 10 minutes or so. And these are the verdicts. It doesn't have to be the final verdict.
That is wild.
Hopefully it's right because it's pretty much what's at 44.
Maybe
I
she
would note
wasn't a good mom. I
Where's the
don't
mistake?
The verdict
know.
offers an option to convict on second degree intentional.
Oh, yep, you're right. The 40. What the heck?
Yeah, my request with the verdict would be just like one single verdict form for each count: first degree reckless, second degree reckless, and then not guilty.
Oh, really? I thought you wanted them all in a row.
No, yeah,
I agree with how Attorney Zachary
Yeah.
says. Having one form for each of them as to guilty and then not guilty that covers all.
yeah. I'm sorry if I wasn't clear on that. That was
So you want one page,
one page
essentially.
each. Yes.
Okay. That is a change. All right. What about count two? I hate to say it, but Christina had it that way and I made her change it. She might not be happy with me on that one.
Blame it on me, Judge.
Sure, I usually do, don't worry.
I think count two looks.
I'm fine with that. I mean, if we want to keep consistency, we can break it back up again, but count two is as is.
Most verdicts, we do this.
Yeah.
We don't break it.
Yeah, I think it's fine in count two.
Yeah. And then count three. And there's 2 pages. Not guilty's on the second page.
Count three looks fine to me.
It looks fine.
Okay.
It's okay.
Let me go change count one.
OMG.
Just realized it's completely wrong. Just changing it. I wonder what happened.
It is right in the actual instructions. I don't know.
Yeah, there must have been a glitch when we, we'll get it.
I mean, this is not something you can mess up, like even in the slightest. Like, oh, like a typo, like nothing. Like that's why. So, Mark, you weren't here this morning, but I did email the defense attorney and tell him that the prosecution kept calling it lorazepam. That's really was ticking me off the other day. It really bothered me. So, I mean, I'm just saying, if for the record, if they're going to be like everything has to be just so, you can't call it one drug when you're accusing her of giving him Xanax, alprazolam, which is what the generic is. You should have just kept calling it Xanax instead of trying to use the generic name if you're not going to call it the correct generic name. I'm just saying. And they were so like stuck on everything being perfect and everybody using the correct terminology for everything, and the prosecution didn't even use the right freaking generic name. So I did email the defense attorney. I don't know if they ever if they read it or not, but I did email them to tell them that the prosecution used the wrong generic name of the drug the entire time he was cross-examining Josie. Just, I don't know if it matters, but obviously every detail matters when your life is on the line. And, you know, I would think, even though obviously she's not Mother of the Year. I mean, I just think for the record, I mean, as they always say, you know, for the record, you can't just say lorazepam. Lorazepam is Ativan. alprazolam is Xanax. But if you're gonna say Xanax, just say frickin' Xanax. If you can't say the correct generic name, just say Xanax. Just that and something else I was thinking about that they I was thinking about telling him which is too late now, but maybe in the when she gets a new trial, which I think she may possibly be able to get one, they should look at the treadmill trial. I don't know if you saw that one. We referred to it a lot in this chat, but the Corey Michelot trial, it happened up there where Corey Michelot was abused by his dad, and it didn't show until like 13 days later. So he didn't show his symptoms, I guess, or whatever from the abuse did not show up until many days later. And he didn't die from his injuries until days later. So this could be similar with Alexavier, that it didn't show until hours later. So maybe, which I don't think they pressed that enough. I don't think it was hit hard enough for the defense with anyone, with any expert witness, with anything to show that an abuse victim injuries can show up at a later time and they can suffer a long time. I mean, even, I just don't think they prove that. Not that the defense has to prove anything, but given the fact that the prosecution is trying to say that she did it, if you're going to put a defense on, I think that should have been what they put on instead of just showing that she's a victim. I think that they should have put up as a defense. If they were going to say Derek did it, then I think they should have shown some more evidence that he could have suffered from injuries later, much like she did, from her head being beat into the tile. Obviously, she had a TBI. Alexavier could have suffered from a concussion. Maybe that's why he was throwing up. That's a sign of concussion. I mean, there's all these things they could have used. I feel like they could have gone deeper into, but maybe they weren't allowed to. I don't know why they didn't use that, or why they didn't have the medical examiner talk about, like, go into deeper, like, well, can you determine, like they talked about the bruises, like you can't tell how long the bruises were there. You can't determine what stage a bruise is in. Why didn't they discuss further? Well, you don't know when those injuries occurred. They didn't delve into that deeper. You don't know when the injuries happened. You can't say if they happened the day before, 2 days before, 3 days before, like you don't know. And you can't determine that liver injury. You don't know what caused that liver injury. I know they brought it up a little bit. They touched on it, but they didn't really like delve into it, because I think the prosecution somehow, some way had it suppressed that they didn't want Derek to be. I haven't really seen a case where the defense wasn't allowed to have an alternate suspect, I guess, for lack of a better term, used. So I'm confused as to how they weren't able to put Derek out there more. I'm curious how they got that pushed down so far. They really weren't able to use Derek as their alternate source. It's really strange. Yeah, I don't know how long it's going to take him to read. Well, he may not. Well, they're going to have to take a lunch break. But he's got to get this verdict form correct. I didn't understand how they wanted the verdict form to read for the charges, first degree, second degree. So they want all the guilties underneath every charge. I was confused when they were talking about that. So do they want first degree, second degree, or involuntary? And they want guilty. I guess we'll see when he reads it, because I didn't understand it. I just didn't know if that was better or worse. I mean, it doesn't really matter, I guess. I mean, it does matter. It matters. All right, we're still waiting for the jury, and the verdict form now has to be corrected again. They came back. The judge thought the verdict form was correct, and it wasn't. So they're having to fix it again. So at some point, the jury will get this instruction, at least. We did hear Corey Richens' kids' statements while we were waiting for this judge to come back, and got to hear their so they don't call her mom anymore either. They call her Corey. So I guess they have decided they don't want her in their lives. That is so one of them was 9 years old. So they were old enough to pretty much know what was going on. Yeah, Ew. Okay. That's what this guy looks like? Okay, so remember we didn't get to see Derek on the stand because he was a victim. So they covered him up. So hold on. I have to show you what he looks like. What the are you for serious right now? That's what this guy looks like. This is what women are falling all over themselves for. I mean, what? Ugh. Okay. Okay. All right. Okay. I'm going to show y'all, because I don't think I've shown you, what Derek Pedron looks like. Here you go. This is what the what? Yeah. So this is what all the women are rushing to and having kids with. Ew. So this is the guy they wouldn't show on the stand because he's considered a victim, obviously, because his son is the one who died. Yeah, he is gross. And this was in November of 2025. He was arrested, and he had $150 disorderly conduct, cash only, and a battery $500 cash only bond. Now, mind you, this man has been arrested countless times for assault, battery, drunkenness, and again was arrested in November just this past year. And his bond is still only as low as $500 or $150. What is Wisconsin doing? That is sad. That is disgusting. Wisconsin is only that's the best Wisconsin can do. So this man has custody of his children. They just keep letting him out, and he gets a free pass. He just keeps this is why there are people out there who end up becoming this is exactly why we watch these trials all the time, is because we see people and we're like, how did they end up becoming a killer? Because the state kept letting them out. Oh, we're back.
Here's, I forgot, these are count one modified, without the not guilty, the not guilty recap. This is an extra, I don't know if you wanted that one. So lunch may not be till noon anyway. Yeah, that one will deal with it later. Okay. Yeah, actually, why don't we give her that extra copy? Here's the extra copy. Okay. All right, you ready to go on the record? Okay, all the parties are present. What you have in front of you is a copy of the jury instructions. The verdicts we changed to what we had just talked about. I don't know if the states had an opportunity to glance over it.
I did. I'm assuming you have the not guilty one and just gave us the.
Right, I just gave you the 3 guilties.
Yeah, that was my question as well.
Yeah, we have the 4 pages on the count 1. We just didn't reprint that one. And then the other, so what the plan is right now is I'm going to read the instructions. We have lunch coming early. We'll probably have you come back. Depends on when I get done here, 12:30, 1:45, and then we'll do closings. Does that make sense? I will also apologize for the court being slow this morning, but anything else from the state and defense?
Oh, yeah.
Bring the jury in. Oh, it took way too long. All right, everybody may be seated. Best laid plans. We thought we had this pretty well in hand, and then things didn't go right. It's my fault. Part of it is that we had a misunderstanding of certain things and we had a glitch. So I apologize for the late wait and the long wait. So I'll just to explain to you what we're going to do right now. I'm going to do the jury instructions as the last part I read at the very end after closings. Do the jury instructions, have you eat lunch, and then we'll probably bring you back hopefully a little bit early. Then we do closings. There is a limit on the closings, so it won't go for 2 days or 3 days. It's going to go for a few hours though, to give everybody an opportunity to say what needs to be said. So having done that, let's start with the jury instructions. As you can see, it's very long. You will get copies of this for the jury room when you're deliberating too. But let's start with these instructions. Members of the jury, the court will now instruct you on the principles of law which you are to follow in considering the evidence in reaching your verdict. It is your duty to follow all these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply the law to the facts in the cases which have in the case which have been properly proven by the evidence. Consider only the evidence received during the trial. The law as I given to you by these instructions and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of facts solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The first count of the information in this case charges that count 1, first-degree intentional homicide, first-degree reckless homicide, second-degree reckless homicide in section 940.01 parent 1 parent A, 940.02 parent 1 in the Wisconsin in 10/4/18. Josie Dikeman on or about Saturday, February 11th, 2023 at County Road OS in the town of Madera, La Crosse County, Wisconsin, did cause the death Alexavier Pedrin, date of birth 7/10/2016, with intent to kill that person or another, contrary to 940.01 parent 1 parent A with stats. To this charge, Josie Dikeman has entered the plea of not guilty, which means the state must prove every element of the offense charge beyond a reasonable doubt. Crimes to consider. The information charges Josie Dikeman with first-degree intentional homicide. You must first consider whether Josie Dikeman is guilty of that offense. If you're not so satisfied with that Josie Dikeman is guilty of first-degree intentional homicide, you must consider whether or not Josie Dikeman is guilty of first-degree reckless homicide or second-degree reckless homicide, which are less serious degrees of criminal homicide. Intentional and reckless homicide. The crime referred to as first-degree intentional, first-degree reckless, and second-degree reckless homicide are different types of homicide. Homicide is the taking of life of another human being. The degree of homicide defined by law depends on the facts and circumstances of each particular case. While the law separates homicides into different types and degrees, there are certain elements which are common to each crime. Both intentional and reckless homicide require that Josie Dikeman caused the death of Alexavier Pedron. First-degree intentional homicide requires that the state to prove that Josie Dikeman acted with intent to kill. First-degree reckless homicide and second-degree reckless homicide require that Josie Dikeman acted recklessly. First-degree reckless homicide required proof of one additional element, that the circumstances of the Josie Dikeman's conduct showed utter disregard for human life. It is for you to decide what type of homicide Josie Dikeman is guilty, if guilty at all, according to the instructions which define the two offenses. Statutory definition of first-degree intentional homicide. First-degree intentional homicide is defined in Stats 940.01 is committed by one who causes the death of another human being and with intent to kill that person or another. State's burden of proof. Before you may find Josie Dikeman guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Elements of first-degree intentional homicide the state must prove. 1, Josie Dikeman caused the death of Alexavier Pedron. Cause means that Josie Dikeman's act was a substantial factor in producing the death. 2, Josie Dikeman acted with intent to kill Alexavier Pedron. Intent to kill means that Josie Dikeman had the mental purpose to take the life of another human being or was aware that her conduct was practically certain to cause the death of another human being. When may intent exist? While the law requires that Josie Dikeman acted with intent to kill, it does not require that the intent existed for a particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. Deciding about intent. You cannot look into Josie Dikeman's mind to find intent. Intent to kill must be found, if found at all, from Josie Dikeman's acts, words, and statements, if any, and from all the facts and circumstances in the case bearing upon intent. Intent and motive. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in the establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. Jury's decision. If you're satisfied beyond a reasonable doubt that Josie Dikeman caused the death of Alexavier Pedron with the intent to kill, you should find Josie Dikeman guilty of first-degree intentional homicide. If you're not so satisfied, you must find Josie Dikeman not guilty of first-degree intentional homicide, and you should consider whether Josie Dikeman is guilty of first-degree reckless homicide in violation of Stats 940.02 parent 1, which is a lesser included offense of first-degree intentional homicide. Make every reasonable effort to agree. You should make every reasonable effort to agree unanimously on the charge of first-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after full and complete consideration of the evidence, you conclude the further deliberation would not result in a unanimous agreement on the charge of first-degree intentional homicide, you should consider whether Josie Dikeman is guilty of first-degree reckless homicide. Statutory definition of first-degree reckless homicide. First-degree reckless homicide is defined in Wisconsin Statute 940.02, parent 1, is committed by one who recklessly causes the death of another human being under circumstances which show utter disregard for human life. State's burden of proof. Before you may find Josie Dikeman guilty of first-degree reckless homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. Elements of first-degree reckless homicide the state must prove. 1, Josie Dikeman caused the death of Alexavier Pedron. Cause means that Josie Dikeman's act was the substantial factor in producing the death. 2, Josie Dikeman caused the death by criminally reckless conduct. Criminally reckless conduct means the conduct created to a risk of death or great bodily harm to another person. The risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that her conduct created the unreasonable and substantial risk of death or great bodily harm. 3, the circumstances of Josie Dikeman's conduct show utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what Josie Dikeman was doing, why Josie Dikeman was engaged in the conduct, how dangerous was that the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. Consider also Josie Dikeman's conduct after death to the extent that it helps you decide whether or not the circumstances showed utter disregard for human life at the time of the death occurred. Jury's decision. You are satisfied beyond a reasonable doubt that Josie Dikeman caused the death of Alexavier Pedron by criminal reckless conduct, and that circumstances of the conduct showed utter disregard for human life. You should find Josie Dikeman guilty of first-degree reckless homicide. If you're not so satisfied, you must find Josie Dikeman not guilty of first-degree reckless homicide, and you should consider whether Josie Dikeman is guilty of second-degree reckless homicide in violation of Wisconsin Statute 940.06, which is a lesser included offense of first-degree reckless homicide. Make every reasonable effort to agree. You should make every reasonable effort to agree unanimously on the charge of first-degree reckless homicide before considering the offense of second-degree reckless homicide. However, if after full and complete consideration of the evidence, you conclude the further deliberation would not result in unanimous agreement on the charge of first-degree reckless homicide, you should consider whether the defendant is guilty of second-degree reckless homicide. Statutory definition of second-degree reckless homicide. Second-degree reckless homicide is defined under Wisconsin Statute 940.06, is committed by one who recklessly causes the death of another human being. Difference between first and second-degree reckless homicide. The difference between first and second-degree reckless homicide is that first-degree offense requires proof of one additional element, that the circumstance of Josie Dikeman's conduct showed utter disregard for human life. Jury decision. If you're satisfied beyond a reasonable doubt that all the elements of first-degree reckless homicide were present, except the element requiring that the circumstance of the conduct showed utter disregard for human life, you should find Josie Dikeman guilty of second-degree reckless homicide. In other words, if you're satisfied beyond a reasonable doubt that Josie Dikeman caused the death of Alexavier Pedron by criminally reckless conduct, you should find Josie Dikeman guilty of second-degree reckless homicide. If you're not so satisfied, you must find Josie Dikeman not guilty. You are, in any event, to find Josie Dikeman guilty of one or more offense as to count 1. Just so I'm going to just repeat that. You are not, in any event, to find Josie Dikeman guilty of one or more offense as to count 1. Count 2, chronic neglect of child consequence is death. Josie Dikeman between January 1st, 2021 and February 11th, 2023 at County Road OS in the town of Madera, La Crosse County, Wisconsin, being a person responsible for the welfare of a child, Alexavier Pedron, through her action or failure to take action for reasons other than poverty, did negligently fail to provide necessary care so as to seriously endanger the physical, mental, or emotional health of the child, and the child suffered death as a consequence, and the actor is guilty of chronic neglect as she committed 3 or more violations under 948.21 parent 2, with a specific period of time involving the same child, to wit, Alexavier Pedron, contrary to 948.215 parent 1 and parent 2, parent A, Wisconsin statutes. To this charge, Josie Dikeman has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Statutory definition of the crime. Section 948.215 of the Criminal Code of Wisconsin is violated by one who commits 3 or more violations of Section 948.21 parent 2 within a specific period of time involving the same child. State's burden of proof. Before you may find Josie Dikeman guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt the following 3 elements were present. Elements of the crime that the state must prove. 1, Josie Dikeman committed 3 or more violations of Section 948.21 parent 2 involving Alexavier Pedron. Section 948.21 parent 2 of the Criminal Code of Wisconsin is violated by any person who is responsible for the child's welfare who, through action or failure to take action for reasons other than poverty, negligently fails to provide any of the following so as to seriously endanger the physical, mental, or emotional health of the child, necessary care, necessary food, necessary medical care, education in compliance with Section 118.15 or to drug abuse as defined on 46.973 parent 1 parent B. Elements of Section 948.21 involving the same child. A, Alexavier Pedron had not obtained the age of 18. Knowledge of Alexavier Pedron's age is not required, and mistake regarding Alexavier Pedron's age is not a defense. B, Josie Dikeman was a person responsible for the welfare of Alexavier Pedron. A person responsible for the welfare of a child includes a person who is employed or used by one legally responsible for the child's welfare to exercise temporary control or care of the child. B, Josie Dikeman, through action or failure to take action, and for reasons other than poverty, failed to provide the necessary care, necessary food, necessary medical care, education in compliance with Section 118.15, or to drug abuse as defined under Section 46.973, parent 1, parent B. Section 118.15 of the Wisconsin statute is violated by a person who has under her control a child between the age of 6 and 18 years and fails to cause the child to attend school regularly during the full period and hours that the school is in session until the end of the school term, quarter, or semester of the school year in which the child becomes 18 years of age. Section 46.973, parent 1, parent B, the Wisconsin statute states, drug abuse means the use of drug in such manner as to endanger the public health, safety, or welfare. D, failure to provide seriously endanger the physical, mental, or emotional health of the child. To seriously endanger means to create a serious risk of harm or injury. E, the failure to provide was negligent. Negligent means acting or failing to act in such a way that a reasonable person would know or should know seriously endangers the physical, mental, or emotional health of a child. Element 2, at least 3 violations of neglect as previously defined involving Alexavier Pedron took place within a specific period of time. The specific period of time is from January 1st, 2021 through February 11th, 2023. More than 3 acts alleged. Before you may find Josie Dikeman, you must unanimously agree that at least 3 violations of Section 948.21 involving the same child occurred between January 1st, 2021 and February 11th, 2023, but you need not agree on which acts constitute the required 3. Element 3, Alexavier Pedern suffered death as a consequence. Jury's decision. If you're satisfied beyond a reasonable doubt that all 3 elements of this offense have been proved, you should find Josie Dikeman guilty. If you're not so satisfied, you must find Josie Dikeman not guilty. The third count of the information in this case charges that count 3, physical abuse of a child, repeated acts causing death, 948.03, parent 5. Josie Dikeman between January 1st, 2021 and February 11th, 2023 at County OS in the town of Madera, La Crosse County, Wisconsin, did commit repeated acts of physical abuse involving Alexavier Pedern, where at least 3 of the acts were violation of 948.03 parent 2 Wisconsin statutes. And at least 1 violation caused the death of Alexavier Pedern, contrary to 948.03 parent 5 parent A 1 Wisconsin statutes. Statutory definition of crime. Just a second. Section 948.03 parent 5 of the Criminal Code of Wisconsin is violated by one who, within a specific period of time, commits 3 or more acts of physical abuse of a child, of the same child. State's burden of proof. Before you may find Josie Dikeman guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 2 elements were present. Elements of the crime the state must prove. 1, Josie Dikeman committed at least 3 acts of physical abuse of Alexavier Pedern. In this case, Josie Dikeman is alleged to have committed physical abuse of a child by violating Section 948.03 parent 2 parent B. Physical abuse of a child as defined by 948.03 parent 2 parent B of the Criminal Code of Wisconsin is committed by one who intentionally causes bodily harm to a child. Before you may find Josie Dikeman guilty of committing an act of physical abuse of a child, the state must prove by evidence which satisfies you beyond a reasonable doubt the following 3 elements were present to establish an act of physical abuse of a child. A, Josie Dikeman caused bodily harm to Alexavier Pedern. Bodily harm means physical pain or injury, illness, or any impairment of physical condition. B, Josie Dikeman intentionally caused bodily harm. This requires that Josie Dikeman had the mental purpose to cause bodily harm to Alexavier Pedern, or was aware that her conduct was practically certain to cause that result. C, Alexavier Pedern had not obtained the age of 18 at the time of the offense. Knowledge of Alexavier Pedern age is not required, and mistake regarding Alexavier Pedern age is not a defense. Element 2, at least 3 acts of physical abuse took place within a specific period of time. The specific period of time is from January 1st, 2021 through February 11th, 2023. More than 3 acts alleged. Before you may find Josie Dikeman guilty, you must unanimously agree that at least 3 acts of physical abuse occurred between January 1st, 2021 and February 11th, 2023. But you need not agree on which acts constitute the required 3. Jury's decision. If you're satisfied beyond a reasonable doubt that Josie Dikeman committed 3 violations in 948.03 parent 2 parent B within the specific period of time, you should find Josie Dikeman guilty. If you find Josie Dikeman guilty, you must answer the following question. Did at least 1 violation cause the death of Alexavier Pedern? You must all agree on the violation that caused death. If you're not so satisfied, you must find Josie Dikeman not guilty. If you cannot agree on the violation that caused death, you should consider the following question. Did at least 1 violation result in great bodily harm to Alexavier Pedern? Great bodily harm means bodily injury which creates a substantial risk of death, or which causes serious permanent disfigurement, or which causes a permanent or protracted loss of or impairment of the function of any body member or organ, or other serious bodily injury. If you cannot agree on the violation that caused death, you should consider whether a violation resulted in great bodily harm. To answer yes, you must agree on the violation that caused the great bodily harm. In reaching your verdict, examine the evidence with care and caution, act with judgment, reason, and prudence. Presumption of innocence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. The presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt the defendant is guilty. State's burden of proof. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt the defendant is guilty. Reasonable hypothesis. If you can reconcile the evidence with any reasonable hypothesis consistent with the defendant's innocence, you must do so and return a verdict of not guilty. Meaning of reasonable doubt. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt which a reason can be given arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt that would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from the fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as that may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth and give that defendant the benefit of any reasonable doubt that remains after carefully considering all the evidence. An information is nothing more than a written formal accusation against the defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Evidence is, first, the sworn testimony of witnesses, both in direct and cross-examination, regardless of who called the witnesses. Second, the exhibits the court has received, whether or not the exhibits go to the jury room. Third, any facts which the lawyers have agreed or stipulated or which the court has directed you to find. Anything you may have seen or heard outside of the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. It is not necessary that every fact be proved directly by a witness or an exhibit. In fact, a fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed an offense before you may find the defendant guilty. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Evidence presented for Josie Dikeman. Evidence has been presented regarding the conduct of Josie Dikeman for which she is not on trial. You may consider the evidence only for the limited purpose and not to conclude that Josie Dikeman has a bad character or a general tendency to commit crimes. You must not use this evidence to decide that because Josie Dikeman allegedly committed another act at some other time, Josie Dikeman must have committed the offense now charged. Specifically, evidence has been presented that Josie Dikeman was involved in prior incidents in 2011 and 2013. If you find that conduct did occur, you should consider it only on the issue of identity. You may not consider this evidence to conclude that Josie Dikeman has a certain character or a certain character trait that Josie Dikeman acted in conformity with that trait or character with respect to the offense charged in this case. Definition for Josie Dikeman. The evidence was received on the issue of identity. Is the prior conduct of Josie Dikeman so similar to the offense charged that it tends to identify Josie Dikeman as the one who committed the offense charged? Evidence presented for Derek Pedron. Evidence was presented regarding conduct of Derek Pedron, specifically that Derek Pedron was physically abusive to Josie Dikeman, Alexavier Pedron, and other children in the home, and that Derek Pedron purchased and used alprazolam Xanax. If you find this conduct has occurred, you should consider it only to the issue of motive, opportunity, intent, identity, context, and source of injuries. You may not consider the evidence to conclude that Derek Pedron has a certain character or a certain character trait, and that Derek Pedron acted in conformity with the trait or character. Definitions for Derek Pedron. The evidence was received on the issue of motive, that is, whether Derek Pedron has a reason to desire the result of the conduct alleged. Opportunity, that is, whether Mr. Pedron had opportunity to commit the conduct alleged. Intent, that is, whether Mr. Pedron acted with a state of mind that is required for the conduct alleged. Identity, that is, whether the prior conduct of Mr. Pedron is so similar to the conduct alleged that it tends to identify Mr. Pedron as the one who committed the conduct alleged. Context or background, that is, to provide more complete presentation of the evidence relating to the conduct alleged. Propensity-free reasoning requirement. To use this evidence properly, your reasoning must be propensity-free. That you must not reason in this way. Because Josie Dikeman committed another act or crime, she probably acted in the same way again. That kind of reasoning is forbidden. If you cannot follow this propensity line of reasoning, you must disregard the other acts and evidence entirely. You may consider the evidence only for the purpose I have described, giving it the weight you determine it deserves, and not to be used to conclude that Josie Dikeman is a bad person and for that reason is guilty of the offense charged. Remarks from the attorneys are not evidence. The remarks suggested certain facts not in evidence, disregard the suggestion. Attorneys for each side have the right and the duty to object to what they consider are proper questions asked of witnesses and to the omission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received or the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witness and the weight of the evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggests that certain information might be true, ignore the suggestion and do not consider it as evidence. During the trial, the court has ordered certain testimony be stricken. Disregard all stricken testimony. You have heard and viewed an audiovisual recording. Recordings are proper evidence and you may consider them just as any other evidence. You may consider the actions of a person, facial expressions, and lip movements that you can observe on videotapes to help you to determine what was actually said and who said it. The weight of evidence does not depend on the number of witnesses on each side. You may find the testimony of one witness is entitled to greater weight than that of another witness, or even of several other witnesses. In weighing the evidence, you may take into account matters for your common knowledge and your observation and experiences in the affairs of life. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight you give to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reason given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you're not bound by any witness's opinion. During the trial, a witness was told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts which upon it is based. Consider the opinion only if you believe the assumed facts upon which it is based have been proved. If you find the facts stated in the hypothetical questions have not been proved, then the opinion based on those facts should not be given any weight. It is the duty of the jury to scrutinize and weigh the testimony of witnesses and to determine the effect of evidence as a whole. You are the sole judges of the credibility, that is, the believability of witnesses, and the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other physical characteristic. And determine the credibility of each witness and weight you give to the testimony of each witness. Consider these factors. Whether the witness's interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matter the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any, has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or discredit testimony. Then give to the testimony of each witness the weight you believe it should receive. Josie Dikeman has testified in this case. You should not discredit the testimony just because Josie Dikeman is charged with a crime. Use the same factors to determine the credibility and weight of Josie Dikeman's testimony that you use to evaluate the testimony of any other witness. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourself the reliability of things people say to you. You should do the same thing here. Evidence has been received that some of the witnesses in this trial have been convicted of crimes. This evidence was received solely because it bears upon the witness's character for truthfulness. It is not to be used for any other purpose. Evidence has been received that Josie Dikeman had been convicted of a crime. This evidence has been received solely because it bears upon Josie Dikeman's character for truthfulness as a witness. It must not be used for any other purpose, and particularly you should bear in mind the criminal conviction at some previous point, let me say that again, at some previous time is not proof of guilt of the offense now charged. The testimony of a child should be weighed in the same manner as testimony of any other witness. Considerations of age, intelligence, ability to observe and report correctly, ability to understand the questions and the answer to them, sense of duty to speak the truth, conduct on the witness stand, interest, appearance, and other matters bearing on the credibility applied to a child witness in common with all other witnesses. Now, the next two parts I will read when we get to the closing arguments. Because of the timing of this, what we're going to do is we'll take a break right now, have you have lunch. I would like to start at a quarter to one, so it gives you a little less than an hour so we can get to the closing arguments. Please still don't talk about the case, even though I'm halfway through the jury instructions, but we'll have lunch and we'll have you come back and we'll go from there. See you then. Could you leave those here for right now? Yeah, leave them here. Thank you for asking. All right, everybody being seated. Any problem with the way I read the instructions so far? Defense?
Oh, yeah.
There was one word I changed, by the way. There was a "the" that was sort of misplaced, but it was pretty minor. So be back at, let's say, 22, so we can start right up at 1:45.
You're good.
Thank you.
Okay, so lunch break. And then they're gonna come back, finish. They're gonna do closing arguments. I think that's gonna take. I think the jury will probably get the case today. So then we'll be on verdict watch. I don't know if he's going to make them stay. So anyway, I have to go to work. I'm going to keep it on the screen. And then you guys can watch it, watch the closings, put in the comments anything that you have. I put a poll up. Given the instruction, it's pretty clear she has to have been shown intent and been pretty vicious and done this to him, and the prosecution has to have shown that beyond a reasonable doubt. So I would just say, do you guys think that the jury will find her guilty or not? I think at least on charge 2, I would say, yeah, she neglected him, and that did cause his death. So I would, as a juror, probably pick that. But as far as the recklessness, the homicide part, I don't know, because that shows a lot. There's an intent there, and I don't know if she intended to do it. So, but I will be back in a few hours, probably by the time they're done doing closings, and you guys will have to fill me in on how those went. I'm going to try to listen to them while I'm at work. But I don't know. Y'all just don't leave my channel. No, I'm just kidding. Y'all have fun.
Please rise.
Okay. All the parties are present. Just one question before we bring the jury in. We'll start with closings by the state. Probably take a break between the state and the defense. If we need a break, we'll probably take another break at that point. I'm guessing we're aiming for probably 4 o'clock to be done, given the limitation I put out on the closings for an hour and a half. What I anticipate is saying to the jury, just so you know, start your deliberations, but we'll break at 5:30 tonight, so they don't feel like they have to go all night. I'm changing this plan. My guess is they'll want to do that because I think these are very complex questions and a lot of evidence and stuff. So it'll take them some time anyway. But at 5:30, I would have to bring them back so you'd be here and give them a break and then, tell them not to talk about it, think about it, et cetera, until tomorrow morning. We'd start up at 8:30 tomorrow morning. The question I have, well, I can ask this later, is that think about it is if we need to have them meet here, usually I have them go right to the room and start deliberating. I don't have them come back into the courtroom. Everybody okay with that process?
Yes.
Okay. Okay. So anything we need to talk about before we bring the jury in?
No, Your Honor.
All right, let's bring the jury in. Everybody may be seated. All right. Let's, it's time for closing arguments, and so we'll start with the state. Go ahead, Mr. Toberson.
Good afternoon, ladies and gentlemen. On February 11th of 2023, this defendant forever silenced the voice of Alexavier J. Pedron, or as you've come to know him through this trial, Alex. On February 11th of 2023, this defendant extinguished Alex through her brutal assault and her intentional drugging. Alex's voice cannot tell you what happened, but Alex's body is screaming out to you that he was abused and he was drugged. You saw the graphic photos displayed of Alex at autopsy. You saw the bruising on his body on multiple planes on both sides of his face and head, and throughout all sides of his scalp, including on the top of his head. That was this defendant's stamp of abuse. You heard the levels of Xanax inside of his body. That was so this defendant could quiet his cries. Alex suffered in his final hours as he bled internally from inside of his abdomen. The Xanax slowed his respiratory system. Every breath that he took was pained by that rib fracture he had. With less blood to deliver oxygen throughout his body, his brain swelled and his body began to shut down. until Alex took his last breath. At 9:44 a.m. on February 11th of 2023, Alexavier J. Pedron was declared deceased. If Alex were alive today, he would be 9 years, 10 months, and 4 days old. He would be finishing the 4th grade. Alex is missed by brothers and sisters. Alex's death has left a hole in the heart of his mother, Jenna Love, and his father, Derek Pedron. Through this defendant's abuse and intentional drugging, this community, your community, has forever lost the potential of Alex's life and what it could have been. Alex mattered. This trial process is about protecting the defendant's constitutional rights and proving that this defendant is responsible for Alex's abuse, Alex's neglect, and his death. At 9:25 a.m. on February 11th of 2023, this defendant called 911. You know it because you heard it. According to that call, she woke up to find Alex on the ground. Twice during that call, she represents that Alex's body was on the ground. She says that Alex was unresponsive and that there was an open bag of her medication on the floor. The defendant reported that she tried CPR on Alex's body to no avail, and that Alex was not breathing. As that 911 call is taking place, deputies Jar and Anderson arrive on scene. It's perhaps one of the fastest responses one could see to a 911 call. The person is still on the call and the deputies are arriving on scene. When they arrive and this defendant opens the front door, Alex's body is on the bed, not the floor. There is a white sheet under his body to protect the bed from any accidents during the previous evening. That white sheet is undisturbed. It tells you that after Alex was put on that white sheet and in that bed, he did not move to the floor again. It's where he died. Alex's body was in rigor. His left hand was tucked inside of his pants, and his right hand was up towards his head. The left hand being tucked into his pants tells you that his body was not moved from the floor to the bed. As Deputy Jar touched Alex's body and rotated it onto its side, you saw the black substance start to leak out of the side of his mouth. That small movement of just rotating his body to one side caused that substance to start coming out of his mouth. That tells you that this defendant never performed CPR. It was a lie. This defendant told Sergeant Williams that she performed CPR for upwards of 10 minutes. You observed Deputy Jar actually perform CPR and what happened when he just started to perform CPR. You saw the substance start to ooze out from Alex's mouth. And then as the body was moved to the floor, how it continued to ooze out and pool behind his head. That tells you there was no CPR before Deputy Jar arrived on scene. This defendant also said, when she was on the stand, that after trying to perform CPR, she held Alex's body in her arms and cried. You saw the simple movement of moving his body to the side. The simple movement of holding his body in her arms would have caused that same reaction. This defendant didn't hold Alex's body. This defendant didn't cry. You saw her face when the door was opened. Through the investigation into this case, you know that this defendant texted Laura Lee Raines at 9:07 a.m. According to the defendant, she did not immediately notice Alex was not on the bed. You know from the forensic interviews of both Araya and Brantley that they slept upstairs. You know from the testimony of Brantley that he verified once again that he slept upstairs. There were only 2 people in the bed on the evening of February 10th, 2023. This defendant and Alex. And as soon as this defendant woke up, if what this defendant was reporting was true, she would have known immediately that Alex's body was not in that bed. But Alex's body was in that bed. It just wasn't moving. Because he was dead. The children tell you that's what happened. The scene investigation tells you that's what happened. Alex's body tells you that's what happened. Your common sense tells you that is what happened in this case. At 9:20 in the morning, this defendant texts Rafael Suarez. "Something is wrong with my son, don't come." The text message to Rafael Suarez, the person that she's supposed to go on a date with, goes out before she calls her own mother about Alex. The text message about Rafael Suarez saying don't come over regarding her date goes out before she calls 911. At 9:21 a.m., the defendant calls her mother, not 911. For 52 seconds, they talk. And then over 3 minutes pass after that phone call to her mother, where the testimony establishes that the defendant's mother instructed her to call 911. 3 minutes plus pass until at 9:25 and 52 seconds, she calls 911. There's only one person in the whole world who could have drugged Alex. That person's in the room, and she's seated at that table. Common sense tells you that medication that you take anytime takes effect within an hour to 2. The amount of Xanax in Alex's system, you heard through the defense expert witness, was enough to potentially cause the death of an adult. That tells you about the amount of Xanax in a 6-year-old child's system. This isn't candy. This isn't something that you munch on. This is bitter pills. And they're inside of a 6-year-old child's body. It is impossible for Derek to have drugged Alex. Because if Derek did it, he left the house at 7:15 when he was arrested. If he drugged Alex, Alex would have been feeling the effects of Xanax by 8 to 9 o'clock. He would have been unconscious by 9 to 10 o'clock, dead by 11 to midnight at the latest. It is impossible. You know that Alex was awake until 3 a.m. That's what the defendant said repeatedly and did not deny when she took the stand. You know that she tried to put Alex to sleep around midnight, and he was still awake to the point that she turned the TV back on, and she continued to text Rafael Suarez. You know that Alex was actually awake because Laura Lee Raines heard over the phone Alex's voice saying what he wanted to do that evening. Alex was awake. Alex was alive. He was well. There's only one person in the whole world who could have staged the scene knowing that Alex had drugs in his system. That person is in this room, and it is the defendant. This defendant told you that she believes the bag that had the medication was up high. That was her testimony just yesterday. Her belief is that that bag was in a place where only adults could reach it. Derek was in jail that night. The only person that had the opportunity and the ability to take that bag and stage that scene is this defendant. This defendant knows what's inside of that bag because it's her medication. She's the only person that had both the opportunity and the ability to stage that scene. Both forensic pathologists that testified in this case agreed that Alex had Xanax in his system after he was beaten. Alex was brutally beaten first, and after he was brutally beaten, that's when the Xanax was in his system. After Alex is brutally beaten, you know that he already has a fractured leg and limited mobility. The beating left him with a broken rib that brought pain to him with every breath. You know that he had abdominal pain with a laceration to his liver and bleeding into the mesentery cavity. You know that that pain would increase over time. You know that he had multiple blows to his head and to his body. For Alex, movement would have meant more pain. And he couldn't even access a bag that was at a height that only adults could grab it. Only this defendant could have done that. The person who administered that drug to Alex would have to know that he was beaten. He would have to know and want to silence him after he was beaten. And they would have the ability and be the only person that had the ability to stage the scene, to put the bag out, to dump the pills inside of the bag and put the empty canister of the prednisone by Alex's body. The scene investigation conducted by law enforcement verifies that the scene was staged. Every bottle inside that bag had the child safety locks engaged. The pills inside of every single one of those bottles inside the bag matched. The pill bottle outside of the bag had pills inside the bag that matched the prescription. 10 of 12 dumped on the inside of the bag. For you to believe that after Alex was brutally beaten, he would grab and access this bag and then find medication in that bag, you would have to believe that he would A, be able to open the bag and unzip it after being beaten, B, engage the child safety lock, C, empty out all the pills in the bag except for the pills that were Xanax, and somehow magically ingest only the Xanax, and Xanax at a level that would kill an adult potentially. Those are the facts that the defense is trying to sell you, and ladies and gentlemen, do not buy it. The scene investigation in this case also tells you so much more. Alex's pants are stained with cotton candy. There's an empty cotton candy container on the floor. There's also, if you look close enough, an empty can of Red Bull. And you know from the autopsy results that Alex had caffeine in his system. You know that it was a problem for this defendant that Alex would get up in the middle of the night. That's a problem that this defendant created. But Alex would get up in the middle of the night. And like any 6-year-old child, he sought sugar, he sought Red Bull, he sought the things that taste good. And so his pants are stained with cotton candy. The testimony of Investigative Sergeant Amundsen established that there was cotton candy particles throughout the bedroom. It stained the carpet, it was on the wood. The pieces that he had collected from the bed, he originally sees and then he picks up and he says, this looks like cotton candy. It looks like what I'm seeing everywhere else.
Overruled. Keep on going.
You know from phone analysis that this defendant was texting Rafael Suarez during the evening of February 10th into the morning of February 11th over 160 times. Those text messages actually start at 6:18 p.m. while Derek is still at the residence. Derek arrives home from work sometime after 5:30 in the evening, and she is texting another man. And that's her right. You know that the relationship between Derek and this defendant is toxic to say the least. But those text messages establish a number of things. That she's awake. So just before 2 a.m., the last time she sends a message, and then after 2 a.m., when she's not texting Rafael Suarez, she and Alex are left awake and alone. This defendant beat Alex. The beating was a brutal beating. You saw the bruising on his body. During the welfare check conducted by Deputy Kerneen, he observed Alex, not once, but twice. He came into the residence and he saw one old injury above his eye and one bruise on the back of his leg. Deputy Kerneen also told you what Alex was wearing. The only thing that Alex was wearing at that time, when he looked a second time, was a pull-up diaper. The other thing that Deputy Kerneen told you is that between the 2 times when he saw Alex in the residence, Alex repositioned his body. He moved his body on the couch. No other bruising, no redness, no signs of tears or recent crying. And in this defendant's own words, Alex was asleep. In this defendant's own words, the next morning, to Sergeant Williams, Alex was asleep from 5 p.m. to 7:30 to 8 p.m., the entire time that Derek was home. That's consistent with what Derek told you when he took the stand. Derek said when he came home that there was a bucket of throw up that he took and cleaned up. And then he was cleaning up around the house. Both of those facts were verified by Deputy Kerneen. Because when Deputy Kerneen comes over after conducting the welfare check, the bucket next to Alexavier is empty. The throw up has been cleaned up. But when Deputy Kerneen arrives at the residence and he's looking in the windows, and Derek has no idea that law enforcement is there, Deputy Kernine testified and told all of you Derek was sweeping and cleaning the kitchen, which is exactly what Derek said he was doing. Here, the defendant's own words seal her fate. You saw the text message at 9:06 p.m. that this defendant sent to Rafael Suarez. She said, "I just showered." That text message is in response to a message from Mr. Suarez asking, "What are you doing?" From 7:47 p.m. through 8:29 p.m., there is no activity on the defendant's cell phone. From 7:47 p.m. to 8:29 p.m., her phone with no activity is consistent with a person showering. What's more, the photograph that you saw this morning, the selfie, the first selfie that she took, is consistent with someone who got out of the shower within a half hour. Her hair still looks wet. She's got a bathrobe on. She has no makeup on her face. And then within 20 minutes, she has makeup on, her glasses on, but the same bathrobe on. She was improving her appearance because she was having an ongoing conversation with Mr. Suarez. But make no mistake about it, she showered. Why is that shower important? Because this defendant told you when she took the stand yesterday that she would never shower with dirty underwear and a bottle that was used for urine in the bathtub. The defendant wants you to believe that Derek came home, became angry at Alex for using the bathroom in his pants, took him into the bathroom, and brutally assaulted him. And she says the proof of that is the dirty underwear and the bottle that was in the tub. The dirty underwear and the bottle that were in the tub couldn't have been there when she showered. They came after the fact. It came after the fact because they were photographed the next morning. The defendant's story that Derek beat Alex in that bathroom is just that. It's a story. She's attempting to escape responsibility from her actions, something that you know she does from Dr. Endres. And this defendant herself changes the story. She went from showering earlier to not showering. Think about all the children that were home when this defendant says that that beating took place. Major is in the room right next door. He's been interviewed multiple times. He would have heard that brutal beating because this defendant reports that she heard it from upstairs. Brantley is home on that same floor. Araya is home. The defendant's story is not supported by Deputy Kernine's observations. It's not supported by what this defendant originally reported to law enforcement, which is that Alex was asleep that entire time, which is completely supported by Deputy Kernine's observations, which is completely supported by what Derek told all of you, which is completely supported by the scene with the garbage can being emptied and Derek sweeping. You also know it didn't happen because Laura Lee heard Alex's voice on that phone call at 10:30 in the evening. You also know it didn't happen because this defendant reported that Alex was fine that evening. Multiple times she told law enforcement. At the end of performing CPR, when Deputy Anderson tells the defendant that Alex is gone, the defendant's response is, how is that possible? He was fine. After being in this trial for the last 2.5 weeks, it's really easy to want to blame Derek Pedron. You know that Derek Pedron is violent with women. He is. You saw disturbing and disgusting conduct on multiple videos that involved Derek. At the beginning of this trial, during my opening statement, I told all of you, Derek is a domestic abuser, and by God, he is. Large portions of this trial actually felt like this trial was a domestic violence trial and Derek Pedron was on trial. Perhaps one of the benefits of this trial be that Derek Pedron was faced with his domestic violence in those videos and his conduct. Will it change his behavior? Who knows, but one can hope. But don't fall for this defendant's smokescreen. Do not let her use his domestic violence against her to allow her to get away with a homicide of a child. You were told during opening statements by the defense that there were going to be multiple witnesses, one of which was going to come in here and tell you that they witnessed Alexavier get struck and beat more than 12 times. That didn't happen.
Judge, completely improper objection.
Go on to, what, no, overruled, go ahead.
You heard you're going to see multiple videos of the same. There's one video that's been admitted where Derek Pedron is yelling horrible things at Alex inside that van. Things that are abusive. There's another video from years ago where the children are tapping their heads and they say, "Dad just hit me." Those are the two videos you saw that are supposed to establish that Derek is a child abuser. Context also matters. Deputy Paff, during his testimony, talked about our prior domestic violence offense that he responded to the residents just a week or so before. He talked about Alex and Derek's interaction during that time. In fact, it came up again because on the evening of February 10th, Derek said, "Can I say goodbye to my kids?" And the deputies say, "You remember how it went last time. We can't do it again for that reason." Days before, they could not pull Alex off of his father. They could not pull Alex off of Derek. And it created a situation for almost 20 minutes where law enforcement had to work to separate them. That encounter tells you what you need to know about Alex's relationship and love for his father. Make no mistake about it, Derek has responsibility. He has responsibility for Alex's neglect. He has responsibility for not getting Alex to the doctor on time. He has responsibility for not ensuring that Alex was attending school. He has responsibility for bringing drugs into the home for this defendant to use. But Derek's responsibility is not for you to decide today. You are deciding this defendant's responsibility. And his responsibility cannot be an excuse for this defendant to avoid responsibility for her actions. You have heard even more compelling evidence that this defendant is responsible for Alex's abuse and his death. the defendant's own children. In a forensic interview that was conducted by Major, and remember the dynamics of the forensic interview. At the time that law enforcement originally responds on February 11th, they believe this may be an overdose of prednisone. There's bruising on Alexavier's body on the outside, but they don't know about all the trauma on the inside. In an abundance of caution, law enforcement sets up forensic interviews of the children. Major goes and stays with his dad, a dad who has no idea what's happening inside the home of the defendant. Brantley and Araya stay with the defendant's family. They are with separate families and think about what they report in those forensic interviews. Major says that this defendant kicks Alex a lot in his chest and in his face. That this defendant kicked Alex the last time Major saw Alex. That'd be the night before he died. That this defendant has choked Alex on multiple different occasions. That this defendant gets mad at Alex because Alex gets up at night for snacks. This defendant puts hot sauce on his food as a punishment. That this defendant stomps or steps on Alex's chest. Major was interviewed a second time, less than a month later, on March 2nd of 2023. During that forensic interview, Major talked about the purported stairway fall and what this defendant did after that purported fall down the stairs by bending Alex's leg until Alex cried out in pain, and the defendant told Alex to be quiet or she would bend it further. Major also talked about seeing this defendant choke Alex during that same encounter. Brantley was interviewed originally on February 12th. Brantley talked about Alex stealing, that this defendant got mad for the stealing and kicked Alex in the chest, that Alex whined and winced in pain. Brantley made a statement in that forensic interview about how this defendant in the past used a spoon to strike Alex. When he was asked if there's any choking in the house, he said, yes, my mom does it, and she does it to Alex. Both Major and Brantley independently say all of this happens when Derek is not home. And Brantley says, the evening before Alex passed, he was asleep upstairs. Brantley made statements in that forensic interview about green poisonous water. He made statements about guns upstairs, diamonds upstairs, and the spoon being upstairs. Those statements have been represented as untrustworthy just because of the nature and the content of what they contain. This is a 5-year-old child talking. Do not judge a statement of a 5-year-old child from the perspective of an adult. I like to take my kids to sporting events. When they're much younger, I would take them to Brewer games. When someone would ask me what happened at that Brewer game, I would talk about the pitching, who hit well, what the final score was, and how the Brewers played overall. The perspective of my daughters, who are much younger, would talk about what they got to eat. Did dad buy licorice? Did we have ice cream? Did we go to the PlayStation inside the stadium? We had the exact same experience, but the perspectives that we had as an adult and as children were different. Brantley talked about green poisonous water. Remember the scene photographs? There was green water in the toilet. Brantley talked about his dad having guns. How many times in those videos that we are shown were there actual arguments about firearms in that house? It came up more than once. Brantley talked about diamonds being upstairs in that same area. It makes sense that jewelry and a gun or those type of items are all going to be stored in a safe area in the house. That's a 5-year-old child's perspective. That's what he's describing. Remember that. Brantley was interviewed a second time after Derek recorded Brantley. You saw Derek record Brantley. You saw the full recording. Derek actually asked open-ended questions. Tell me what you just said. What happened after that? What happened after that? Those are open-ended questions, the kind that you heard from Danielle on the stand that you should use when you're interviewing a child. Based on those open-ended questions, a second forensic interview is set up of Brantley. During this interview, Brantley said that this defendant pushed Alex down the stairs. But what's important about what he was saying is he's talking about a push down the stairs before death. He's not talking about the push down the stairs that happened resulting in the broken leg. He's talking about something that happened within the time frame right before Alex died, where this defendant was abusive of Alex. He says that Alex would get up at night for food, and he describes how this defendant pushed Alex down the stairs. Brantley says it happened the day before Alex died. Why is that important? Because when Brantley took the stand and talked about that fall, he said the exact same thing when he testified in this courtroom before all of you. That there was a push down the stairs the day before Alexavier died. You know the dynamics of where each one of these children lived in separate households. And you saw both independently testify to the vivid abuse they witnessed at the hands of this defendant. Major took the stand in the very same courtroom where his own mother is in the courtroom. Think about that from the perspective of both Major and Brantley. They came into the courtroom and they testified in the same room as their own mother about what she did to their own brother. Major said that the defendant would punch, hit, kick, and choke Alex. He said all of these things happened while Derek was at work. He described a specific instance of kicking in the kitchen where the defendant kicked Alex while Alex was on the ground, kicked him multiple times. He talked about another incident that happened in the living room where mom, quote, kicked Alex everywhere on his body. He talked about multiple instances of choking, including one that happened the day before Alex died, where the defendant was on top of Alex, straddling him. And he gave a really powerful and a really vivid description of Alex's response, his bodily response to being choked. He talked about how his arms and legs were flailing. Think about that. Think about that, because that is a natural response to someone choking and trying to fight off being choked. And he's telling you with his eyes what he saw this defendant do. He talked about how this defendant would punch Alex, and he demonstrated with his fists. He talked about how Alex would be treated differently with food. He'd be kept from eating. He only got crust from the pizza. He'd get hot sauce on his food. He was treated differently. He was made to sit on the floor if he didn't finish his food on time. Talked about how Alex would get up in the middle of the night. The defendant told you that Alex got up in the middle of the night. Brantley, who has not been living with Major, has been living with Derek, verified Major's account of events. He described this defendant assaulting Alex over and over. Talked about Alex being on the ground and the defendant kicking Alex in his chest. Brantley said this defendant would abuse Alex a lot, that she would routinely choke Alex. Alex's face would turn red and sometimes purple. This defendant would choke, kick, and hit Alex on more than 3 occasions. During this trial, he was asked about food for the first time. He says this defendant would put hot sauce on Alex's food. This defendant would add more hot sauce if Alex wouldn't eat the food with the hot sauce on it. Years passed between those original interviews in February of 2023. Major was now 12 years old when he took the stand. Brantley was 9. They have grown up. Their vocabulary has improved. They have more words to tell you what happened, and they use that vocabulary and those words to tell you what they've witnessed in their home with their own eyes at the hands of this defendant. Ladies and gentlemen, child abuse is a crime that happens behind closed doors. Perpetrators of child abuse rely on that fact. They rely on the fact that the public is shielded from their actions, that you can't see what happens in the home, that the victims of child abuse are people that they have relationships with, that the witnesses of the child in the home are people that they have relationships with. That provides perpetrators of child abuse like this defendant with protection. But this defendant's own children told you about this defendant's abuse of Alex. And if you're wondering why, and the state doesn't have to prove motive, there's a couple things for you to consider. This defendant suffered a traumatic brain injury by Alex's mother, Jenna Love, hitting her with a baseball bat. Alex's father, Derek, has repeatedly abused this defendant. Alex as a child, every time she looks at Alex, is a reminder of Jenna Love and being assaulted and having to take care of Jenna Love's son, and a reminder of Derek's domestic violence and having to take care of Derek's son. And if you still have doubt, and you shouldn't by now, you can consider this defendant's prior conduct and whether it establishes the identity of the person who abused and neglected Alexavier. You know that in 2011, Haley suffered a traumatic brain injury. Haley was admitted to the hospital with multiple skull fractures. According to this defendant, Haley suffered that traumatic brain injury from a fall downstairs. In 2013, Haley was admitted to the hospital yet again after living with this defendant and Dustin Barnes for a period of 6 months. In those preceding months, Haley went from the 80th percentile in weight to the 6th percentile in weight. She was losing hair. She had a fractured foot and potential fractures in her hands. Haley was not this defendant's child. There was another child the same age as Haley that lived in that house, and the two were treated different. Alex is not this defendant's child. There are children of a similar age to Alex in his home. According to those children, Alex was treated different. You can only use the evidence from 2011 and 2013 if the similarities from that evidence, and in this case, help you identify who the perpetrator of the abuse was. I want to talk a little bit about child neglect. Alex had over 100 absences from school in 2 years. In a little over the half year that he attended the first grade, he had 40 absences in 75 days. The principal of Alex's school testified about the harm that is caused to children when they don't attend school. It impacts their growth, it impacts their development, it impacts their functioning, it impacts their social skills. You also saw Alex's appearance at the time of his autopsy. He was extraordinarily thin. He was dehydrated. Conditions that were consistent with what the children described with terms of him eating or not being able to drink, because if he drank, it would cause him to have to go to the bathroom. You know that Alex had a broken leg. You know that Alex wasn't taken for medical treatment for days after that broken leg. Derek deserves responsibility for that, but so does this defendant. There are many ways in which you can get a child to a medical facility without having to drive them there. There are many actions that this defendant could have sought to try and help Alex. And I want to go back to Alex's death. A person who intentionally administers a drug to a child to put that child to sleep has a responsibility to watch over that child. When you engage in that extraordinarily dangerous conduct, that's not an excuse for you to go to sleep and hope that everything turns out right the next morning so you can go on that date. But that's what this defendant did. Giving Alexavier drugs and then going to bed after he is knocked out and not watching over him contributed to his death. Because if there was action taken, monitoring to counteract the effects of those drugs, Alexavier could still be alive. In this trial, you get to consider this defendant's words and actions. She never disclosed the abuse to the children outside of one arguable 911 call to police, to friends, to family, except for one video that she sent to Laura Lee. And what were her instructions with the video that she sent to Laura Lee? Hold on to it in case I need it. Not help me, not help my children, not protect me or protect my children. Hold on to this in case I need it. You know that this defendant got rid of the SD cards. Special investigator or investigative Sergeant Amundsen saw those SD cards on February 11th, 2023. He didn't collect them that day, and I imagine he's kicking himself for it. This defendant had the password, the ability to log in, and when you log on to the account, it sends a notification to the email of that account. We saw the notification when Investigative Sergeant Amundsen logged in. And as he's logged in, the videos are being deleted. The holder of that account would get the notification and be able to sign in and delete those videos. This defendant was deleting those videos. You know that after the death of Alexavier, Derek was meeting with law enforcement, gave a statement to law enforcement, was cooperating with law enforcement. And this defendant's response to that was to tell him he should not do it. This defendant's words, her actions show her guilt. Her lies about the shower establish her guilt. After I've been speaking to you for a while, I'm now going to talk about the law, the most exciting part. That was supposed to be funny, none of you laughed. Count 1 is first-degree intentional homicide. It has 2 elements. The defendant caused the death of Alex, and the defendant caused the death of Alex with the intent to kill. I want to talk about the intent to kill. Intent to kill includes language that the defendant's actions were practically certain to cause the result. You saw the brutal beating that Alexavier sustained at this defendant's hands. You saw the drugging and the amount of drugs in his system. There can be no conclusion, but each of those combined demonstrates that it's practically certain to take Alexavier's life. It is difficult to fathom a caretaker, someone who fills a parent-like role, extinguishing the life of a child. And for that reason, you have lesser included offenses to consider. You have the ability to consider whether or not the defendant's actions were intentional or utterly reckless. Make no mistake about it, it is the state's position that this death was intentional. The beating, the brutal beating, combined with the administration of a drug at that level, made it practically certain that Alexavier was going to die. Count 2, child neglect. One of the elements is a person responsible for the welfare of a child. A girlfriend to a parent is a person responsible for the welfare of a child because that parent is using or employing that person as a caretaker for their children. You have to find 3 acts of child neglect during that time frame, and you don't have to even agree on which 3 acts, as long as all of you agree that there were 3 acts of neglect. There's medical neglect, there's educational neglect, there's nutritional neglect in this case, supervisory neglect, and there's multiple forms of each. All you as a jury has to do is find 3 or agree that there were 3, and you don't even have to agree on which 3 constitute the 3. You do have to agree on the one that led to death. For that, the defendant had a responsibility to Alex to watch over him after giving him that drug, and she failed in that responsibility. I've talked about that already. Count 3, repeated acts resulting in death. Again, you have to find 3 acts, and you don't have to agree on all 3. The testimony of Major gives you 3. The testimony of Brantley gives you 3. Alexavier's body gives you more than 3. From that, it's easy to find 3 acts of child abuse that this defendant inflicted on Alexavier. Did the defendant cause bodily harm is the first element for each one of those acts. Bodily harm includes physical pain, injury, or impairment of physical condition. All Alexavier had to have was pain or impairment of his condition from this defendant's acts. That the defendant acted intentionally. Kicking someone is an intentional act. Punching someone is an intentional act. Hitting someone is an intentional act. And by God, choking a 6-year-old child is an intentional act. Did one of those acts cause the death of Alex? This is where you do have to agree. You have to agree on the act that caused his death. The testimony of the medical examiners give you 2 different ways. the abdominal injuries that Xavier had were a substantial condition resulting in his death. That's what Dr. Quinton testified to. He listed as the #1 cause on his report. Impairment of his physical condition by administering a drug is another way of committing child abuse. It's an intentional act, it impairs his physical condition, and the administration of Xanax caused his death. Either one of those, as long as all 12 agree, is sufficient for finding and answering that question, yes. Dr. Endres said in her testimony that this defendant avoids responsibility, that this defendant projects blame on other people. You witnessed that through the defense testimony over 2 days. There was something that the defendant said twice during her testimony that all of you should agree with. This defendant told you twice that Alex was murdered. Alex was murdered. Alex was murdered by this defendant. This defendant does everything she can to avoid personal responsibility. Give her a lesson in personal responsibility and find her guilty.
All right. Thank you, Mr. Treverson. What I'd like to do is take a break, obviously this long, so we're going to take a 15-minute break. We'll start back up at 2 o'clock. Just want to address one thing before we break up. Just to address the objection that the defense made, the argument was burden shifting. It was on the issue of did the defense present witnesses about Derek Pedron specifically?
It was about a witness a possible witness that was referenced in opening that.
Can you pull the microphone a little bit closer? Sorry.
It was about a possible witness in opening that the state faulted Ms. Dikeman for failing to call. That's black letter burden shifting.
I don't think it's burden shifting at all. It was something that the defense said would happen that did not happen, and I was pointing that out.
I think pointing out something that's said at opening that doesn't happen during the trial doesn't necessarily, it can be burden shifting. But given that, I don't think it shifted the burden overall. It was also in the context of talking about Mr. Pedron's abuse. That's what I had the impression it was about. If it was, I'll just say this, it was harmless if at all. The burden is very much clearly stated, and then the instructions will be restated. One thing I should say that I usually read 160 before I do closings. I realized I hadn't read that. I will do 160 after I do closings, which actually talks about, about evidence. It doesn't talk about the burden per se, but we're talking about the burden all throughout the instructions. And it also goes on about returning a verdict in 515. So at this point in time, court, I overruled the objection, moved forward, partially because I didn't want to make, a lot of times they're trying to avoid pointing out something that could become a problem. So in this case, I don't think it was. I don't think it was clearly burden shifting. So at worst, it was ambiguous. At best, it wasn't. So the court will go ahead and we'll get back at 2 o'clock. Anything we need to talk about before we bring the jury in from the state defense? Nope. All right, let's bring the jury in. All right, everybody may be seated. Defense closing, go ahead.
You just like getting your fucking ass beat. Ladies and gentlemen, is there a more terrifying thing a father could say to a 6-year-old child? A child who depends on him for protection? A child who cannot defend himself? And so he naturally looks to his father and should be able to expect that he won't harm him. Pedren's statement tells you something. Do you like getting beaten? Tells you that it happened before. It tells you it was going to happen again. Tragically, it was routine. And it tells you something else that is critically important in this case. It tells you that Derek Pedren was not Alexavier's protector. He was his abuser. And that matters. That matters because this case is not just about what happened to Alexavier. It is about what law enforcement chose not to see. It is about what they refused to investigate. It is about how they locked on to Josie Dikeman from the very first hour and never honestly revisited their assumptions, even after the medical science, the facts, and their own forensic pathologist proved that major parts of their theory were wrong. From the very beginning of this case, back in 2023, the government has tried to give us all a headline. Mother murders stepson and stages scene. That is the government's headline. It is dramatic. It is sensational. It is horrific. And it triggers a powerful emotional response. It is exactly the type of accusation that can hit hard and cause people to stop thinking critically. But our law asks more of you than simply reacting to a headline. You must read the article. You must critically examine the evidence and separate emotion from proof and search for the truth. And when you do that, you'll see that the government has tried to give us all the wrong headline. What the headline should be is innocent woman charged, suspect at large. Ladies and gentlemen, this is a case about how innocent people get convicted of murder. And I want to put something right out in the open, just to say it. Usually when I go to sleep at night and hit the pillow, I'm out. I'm out for the night. But last night I didn't sleep at all because I'm terrified. I'm terrified that something I failed to do or say or failed to explain will end up with an innocent woman being convicted. And so all I ask of you is that when I inevitably fall short in giving you my thoughts on this case, that when you go back into the jury room, you draw upon your collective wisdom and the many, many notes you took throughout this trial. Now, this case comes down to 3 fundamental truths. The first truth is that this investigation was not a search for the truth. It was a defense of a premature conclusion. The second fundamental truth is that the medical science does not support murder. And the third fundamental truth about this case is that there are multiple reasonable explanations that are consistent with Josie's innocence. Overdose, Derek as the abuser, injuries not intended to cause death. And the list goes on. I would like to talk to you about some of those as we go forward, but I first would like to start where the law begins, the burden of proof, proof beyond a reasonable doubt. And we've all heard that before. And what is the burden of proof? Well, the burden of proof was built on a hard lesson, which is that when the burden is too low, innocent people do get convicted. Because human beings, the courts are run by human beings. We are all human. We are fallible. We make mistakes. We make assumptions. We have biases. And the burden of proof is designed to protect against those very human errors. And that is why we have such a high burden. Because society concluded that it is unacceptable to convict innocent people for something they didn't do. So I'll talk briefly about what reasonable doubt is. But I'll first start with what it is not. What reasonable doubt is not, it's not that you think something probably happened. It is not enough that there is more evidence that you believe of guilt than there is of innocence. It is not even enough that you are firmly convinced, that you have a strong belief that something bad happened based on the evidence. That is not enough. The government must eliminate each and every reasonable hypothesis consistent with innocence, any reasonable explanation consistent with Josie's innocence. And we heard some of that in the trial testimony. We heard from Dr. Quinton that overdose is a very real possibility. It is squarely supported by the evidence. And if this was an accidental overdose, count one must fail. This is not an intentional homicide. And if it's an overdose, count three must fail. And that's just one example. And you'll hear more as we go forward. But it is important to know that you do not have to solve every mystery. You do not have to pick the explanation that you think is the most convincing. All you have to do is determine if there is one single reasonable doubt in this case, just one. Now let's talk about the first truth in this case, that this case was not a search for the truth. It was focused on defending a conclusion from day one. A 911 call comes in, reporting the tragic death of a child. And even in that first moment, Josie raises the possibility of overdose. And so what do law enforcement do? By sheer happenstance, they arrive within minutes. And they immediately judge Josie guilty. Immediately, they conclude that she must have staged that scene. Immediately, they thought she must be covering for a horrible crime. Only a murderer would stage the scene. And what was their evidence at that point? Pill bottles around on the floor. They had no testing on those items. They formed a conclusion based on an assumption from day one and began defending that conclusion rather than trying to find out what actually happened. Now, let's talk about the investigation and the incredible failure that we saw because of a breakdown in the chain of command. Now, you saw from the testimony that there was no single person in charge of this investigation. And Lieutenant Williams, he agreed, this is not just an issue about flow charts and organizational dynamics. This is a critically important factor in any investigation this complex. There are hundreds of witnesses to interview, multiple competing inferences and explanations, medical science, forensic analysis, thousands of hours of video and audio and paper, hundreds of thousands of documents in this very case alone. And so it is critically important that you have one person in charge to assign tasks and to ensure that things do not fall through the cracks, important things. But that is not what we had here. There was testimony again that no one was truly in charge. And even Sergeant Amundsen, when he testified very reluctantly that he was in the lead. He was the last man standing. Now, there's an analogy that I think captures the concerns with this investigation. Imagine putting together a puzzle while throwing away every piece that doesn't immediately fit. You probably wouldn't end up with a complete picture. Now, let's talk about the behavior, the actions of what happened. Because an investigation should not just draw a conclusion and defend that conclusion. An investigation should actively try to disprove its own conclusion, just like the scientific method, to test all of the other possible reasons or possible explanations of what happened. But we did not see that in this investigation. And so we cannot be certain of its results. And a very early example of that, an investigation at the very beginning, it should expand. It should look at all the possibilities. It should not immediately narrow. But we saw how this investigation immediately narrowed when instead it should have broadened. And we see that in the DNA evidence, which you didn't hear anything about in the closing argument of the government's attorney. And why is that? Because the investigation into the DNA evidence and who touched the pill bottle and the cap was not designed to search for the truth. It was designed to prove that Josie had lied about staging the scene. How do we know that? Because they sent it in, but they only tested for Alexavier's DNA. And guess what? It was on there. That supports the idea that he got into something overnight. It doesn't support the staging theory. And so what did they do? Did they say, you know, that's unexpected. We should look into this. No, they immediately stopped and asked no more questions. They didn't test samples from the other adults that could have contributed to those items. They didn't test Derek Pedrin or Josie Dikeman or Karsten Jar. They simply said, oh no, this doesn't support our theory, so we're going to stop looking. That is the very first investigative decision that happened in this case. Even though the crime lab analyst specifically said, please send us more samples from individuals believed to be involved. They did not do that. Folks, this only required mailing in a DNA sample. And they didn't do that. If this were truly a search for the truth, why would they not submit comparison samples? Why would they not want to know who touched those bottles? Because what we were left with was uncertainty. And that uncertainty belongs to the government that has the burden. And investigators never tested the coach bag. And think about that. What would that tell us? If Alex's DNA on the coach bag was on the coach bag, that would show that perhaps, that would show that he gotten into something. But they didn't do that. And so we don't know. We are left with incomplete evidence that we cannot rely upon. And there were pill fragments on the pillow that were never tested. And Dr. Quinton acknowledged this would be important contextual information, as well as Dr. Christensen, that would help us understand, was this an accidental overdose? They never tested. So here we have the centerpiece of the state's case, the state's homicide case against Josie Dikeman, and they never even fully tested it. Why is that? They want us to believe them. They say, believe us. We believe it, so you should too. But they don't have any facts to prove that because they didn't look for them, because they were afraid that the answer would not point to Josie's guilt. Again, they were not testing for their own theory being wrong. They were not truly searching for the truth. Contradictory evidence was ignored. And confirmation bias took hold of the investigation. And just briefly on confirmation bias, we all know what that is. even if we don't always call it that. It is what happens when everyone watches the same play in sports, and the Packers fans say, obvious pass interference, and the Vikings fans say, no, that was clean. And it's particularly powerful, for instance, in politics, when we seek out information and then have algorithms just feeding us back what we want to hear. And so we start filtering all of the evidence that comes in to be consistent with what we already believe. And to be clear, this is not about bad intentions or makes you a bad person. This is a universal human trait that we all have, and that is so powerful, not because it is overt or obvious, it is so powerful because it is subconscious. But it is powerful nonetheless, and that is impossible for any of us to deny. And police are not immune. Medical personnel are not immune. Children are not immune. We all seek to conform evidence to our existing beliefs. And it takes a lot of effort to avoid that pitfall. So again, let's talk about the tunnel vision on Josie. Investigators admitted Derek Pedron was a suspect. Sergeant Amundsen said he is still a suspect to this day. That is the very definition of reasonable doubt. And there's more. 10 days into the investigation, investigators were already working with Derek Pedron to defense-proof the case. Now, you heard Sergeant Amundsen come in and testify under oath. The first time that conversation happened, that was in September after Josie was already charged and arrested. Matter of fact, that's not true. It was 10 days after Alexavier had died. And I think that demonstrates one of the fundamental failures of this investigation, which is that none of the investigators had read all the reports. And the reason why Sergeant Amundsen didn't really know what happened in that meeting in September, which was a meeting that was never disclosed to the defense, no report was made of it. We only learned of it because we physically laid eyes on every bit of video evidence that was in this case, and we discovered this. We said, okay, here's a meeting with a key witness in the case, talking about problems in the case, talking about how the Xanax issue, and talking about Derek's phone. In the very beginning of that meeting, the investigators asked Derek, this was in September, do you still have that phone that we were interested in looking into? He said yes. But then, a little while later in that same conversation, they asked him again, can we see your phone? He said, phone, what are you talking about? It's broken. I don't have that phone. And they never even asked what he meant by that, not once. They never seized Derek Pedron's phone at all, this entire investigation. And let's draw the contrast between that behavior and that of Josie's. You saw Josie's interview with Lieutenant Williams at the very beginning of this case when this had just happened. And Josie handed over the phone willingly. Now, of course, it is true that investigators could have seized that phone without question. And maybe Josie knew that. Maybe not. But what they couldn't have done is compel her passcode. And Josie gave them her passcode without any problem. And that unlocked her life for investigators to inspect. Guess who didn't do that? Derek Pedron. And think about phones just for a moment. A phone is no longer this rotary dial, object that we had in our house that to communicate people across long distances. No, it is now essentially an alter ego. There is no single belonging that any of us possess that gives more insight into what we are doing with our lives, where we physically are located at any given time, what we're searching for, who we're communicating with, what we are communicating about. This gives police a roadmap into Josie's life. And because she had nothing to hide, she gave it to them. Can we conclude the same thing about Derek Pedron? That is up to you to decide. So again, we see the investigation immediately focusing only on Josie and not testing its own theories. Now, again, Derek Pedron admitted to Xanax bringing it into the house. But that wasn't what he said at first. He had to be caught lying in that very first instance, because he first said that it came from Josie. It came from Josie's mom, came from her prescription. And that was not true. And then he said it was from Ted Colkine. She got it from Ted Colkine. Investigators ran down that lead. Turns out that wasn't true. So finally, he admitted to being the source of this substance that we know could very well have killed Alexavier. But they never fully investigated. They never investigated his supplier. They never investigated drug transactions, and they never followed up on any of this evidence. There was a critical text about scripts on February 9 of 2023, one day before the evening into Alexavier's last day. And they never investigated that. We only found out about what was going on when Mr. Pedrin was up on the stand and Attorney Zacher asked him about it. That was the first time. Investigators apparently never asked. So we had to do that in open court in front of everyone and find out what the answer is. Let's talk about Derek Pedrin again for a moment. Investigators knew he had a lengthy history of violence, 7 criminal convictions, a serial strangler of women, Josie being first and foremost. Threats to kill Josie. He put her head through the wall several times. There were no contact provisions, but that was just a sheet of paper. And we also saw that there is evidence of child abuse. You saw that video. It was heart-wrenching. Do you like getting your ass beat? That represents rage, intimidation, and violence and abuse. And when Mr. Pedrin was asked about that particular incident, the question was, you were out of control, right? You would agree. You were out of control. His answer? I wasn't out of control. I was just angry. Does that match up? If any of us were walking down the street and saw somebody behaving that way towards a child, would we say, no need to worry. He's not out of control. He's just angry. Well, apparently Sergeant Amundsen agreed with that as he testified. Now, there's another thing. And here is a very telling exchange. When Mr. Pedrin was asked, have you ever punched or kicked the children? His answer, I don't think so. Is there a parent in this world who cannot simply answer that question with a no? That would be a parent who has done that more times than he is willing to admit. And so we have repeated lies from a suspect in this own investigation, lied about the Xanax, and let's just ask if he's willing, and he lied about his alcohol use. Even though he got arrested months earlier from his testimony while he was intoxicated. I guess we have to believe that he forgot about that, but the truth is much likely different. And so if Mr. Pedrin is willing to lie about some of these the smallest things that don't matter in a criminal trial, are we really to believe that he wouldn't be willing to lie about what's most important to him? His own responsibility for Alexavier's death? That is a question that you will have to resolve. But the importance of this, the point is that the government's investigation, it created the uncertainty in this case. And they own that uncertainty. They created it, and they took on the highest burden in the law when they filed these charges. And they don't just get to come in here and throw out different possibilities of what might have happened. They have to provide precise proof of what happened in that house and what caused Alexavier's death. And so again, we saw no single investigator reviewing any of the case file, key interviews without police reports. And again, I must say one more thing about this meeting that happened in September that was not disclosed in any report. In a search for the truth, investigators document important witness context when they're talking about problems in the case. They're talking about issues in the case. They write reports. I mean, they wrote a report about some random person who evidently didn't know Josie and said something about how she wouldn't let her look after her dog. But they didn't write a report with one of their key witnesses who apparently is still a suspect. Why? Because if you're searching for the truth, you document these contacts. But if you're defending a conclusion, inconvenient facts have a way of leaving no paper trail. So we see how evidence portraying Derek negatively was minimized or ignored. Evidence portraying Josie negatively was amplified and emphasized. Investigators never failed to follow up on statements that Derek treated Alex poorly. And these irrelevant comments were included. And we'll get to this later, but there was also a key piece of evidence in this trial that you heard, which was the 911 call in November of 2022, when Derek Pedron had viciously assaulted Josie by repeatedly punching her in the throat and strangling her because she cooked the beef, the ground beef for the kids. That was his ground beef. And so that's what he does when you cook his ground beef for the kids. And she told you that in the 911 call, that she had no reason to know would show up in a homicide trial 4 years later. But what does that tell you? It tells you that she said he did the same thing to his 6-year-old, to Alex, and that he was teaching Alex to lie. That was in that call. That is a snapshot of what is actually happening in real time before anybody knew it would become relevant in this trial. That is evidence you don't have to ignore. So let's move forward to some of the most dramatic, incredible testimony I've seen in a trial. When Lieutenant Williams was asked about what is the state's theory? Why would Josie do this? When she was looking forward to a date, she was taking selfies with Brantley, she was texting with Raphael, she was seemingly looking forward to a future with someone other than Derek. Why would she do that? And Lieutenant Williams' answer was, if you're saying she killed him that night, I have no idea. Once again, that is the very definition of reasonable doubt. If he doesn't know, how can we? And then you also heard from Sergeant Amundsen, the lead investigator, who apparently hasn't read all the reports, looked at the transcripts, or watched all the videos. He testified that that conversation about thinking like defense lawyers happened in September. That was wrong. It happened February 21. And he testified as well. What is your theory? Why would you do this? How did this happen? And he said the working theory is that Josie must have murdered Alex because he wouldn't let her go to sleep. She wanted to go on a date the next day, so she murdered a child. And that's their working theory. Like my working drafts, which go through 8 different versions before I finalize them. So maybe if we have a trial in 2 weeks, the working theory would change once again, because they do not know. They are required, beyond a reasonable doubt, to prove exactly what happened, not to provide us with a working theory. So if the supposed lead investigators can explain to us what happened, how can we know? And why don't they know? It's because the evidence in this case never supported the murder theory. The evidence kept pointing back towards overdose, towards Derek, towards uncertainty. But that overdose evidence was ignored. You heard from Dr. Quinn. He could not determine the exact cause of death, and he could not rule out overdose. And he said that Xanax's role in this was crucial. What does that mean? That means that overdose is not some far-fetched speculative theory. It is reasonable. It is medically supported. It is consistent with the toxicology. And it is so critically important to understand that if this was an overdose, intentional homicide is not proven. Count 1 is not proven. Count 3 is not proven. And that is enough for reasonable doubt just in and of itself. But then we have an example from the medical examiner, from Ms. Lubinsky, who, I guess in Wisconsin, well, I know in Wisconsin, we don't have medical doctors who serve as medical examiners. I guess that's unique to us. But it seemed like Ms. Lubinsky was much more of a police officer than a medical professional, because her entry into the case essentially was an attempt to overrule the pathologist who said that this was homicide due to the actions of some other person. But instead, she wrote that there was homicidal violence and that the Alexavier died from homicidal assault. Those were her words, not Dr. Quinton. He told you that. Those weren't his words. He wouldn't have used them. And so what does that tell us? Well, what it tells us, as well as Ms. Lubinsky's testimony, about how the mindset had taken such strong the mindset had taken such strong hold that this was only about proving Josie guilty. It was not about exploring what happened. And that is why Ms. Lubinski came in and she told us all that there were brown bananas on the fruit stand in their house. And we saw the photo. The brown bananas were next to fresh fruit and other snacks that the kids could get freely. And frankly, if brown bananas are criminal neglect, then you're going to have to lock me up too, because how many of us have not let bananas overripen in our kitchen? But the point is that bananas are not evidence of criminal neglect. They are evidence of how confirmation bias was so powerful in this investigation. And look, we know why that was. We know why. It was because Josie was never going to be able to move past her earlier convictions in 2001 and 2011 and 2013. And I will say, my biggest fear in this case is that you will not be able to look past this evidence for what it is. It is the state attempting to distract you, to overwhelm you, to provoke anger, to distract you from anything but the lack of evidence in this case. We never tried to hide this from you. We told you this was coming. But if the state had the facts to prove its case, they wouldn't have to rely on convictions that go back to up to 15 years ago. And the state is trying, not subtly, to use this prior conviction as evidence of current guilt. They're trying to say she was an abuser then and she's an abuser now. That is what they're trying to get you to conclude. But the evidence doesn't support that. The 2011 evidence did not conclude that she was abusive. This was an incident where a young child fell down the stairs. And this similarity, I think, explains why they believe that they can use that to say that she must have done something wrong here. But the facts are much different. In that case, Josie was a 19-year-old addict, and she did not care about her responsibility. She was neglectful, and a child was injured falling down the stairs at her apartment. Now, that was investigated at the time, and investigator Tony DeLapp, the officer who investigated this, walked through the house and noted no inconsistent information about what she had reported. Josie took the child immediately into the hospital. And there was no medical certainty in that case. 4 doctors agreed that this was consistent with the explanation. And there was not one doctor who was willing to say that this was abuse. And there's another important aspect of that. There was evidence that was destroyed as part of that. And the instruction says that you can conclude, you can draw the inference that this would have been favorable. But the point is that abuse was not established at all in that case. And there was no conviction. But there was another concerning circumstance with Haley in 2013. To be sure, there were some fractures and there were some other conditions having to do with malnutrition, vitamin D deficiencies, other physical ailments that are dangerous for a child if they're not treated. And that was investigated thoroughly. And it was believed that as to the physiological conditions, that she had celiac. And celiac basically explained all of these conditions. It's basically a disorder that prevents absorbing proper nutrients. And that explains vitamin D deficiency. That explains some of the other findings. This was a coherent explanation from the medical science of what would lead to some of these conditions. But then you did have these concerning injuries. But what did they find out? They investigated everybody in that household. They interviewed them. Not one of them said that Josie was abusive towards the child. Not one. In fact, her partner at the time, who was the other caregiver who was in that household all the time, he had no job. Josie didn't work full time, but she was picking up shifts when she could. But her partner, Dustin Barnes, told investigators she never hurt the children. That was what's called a statement against interest, because he was the only potential source of those injuries. And once again, there was no established abuse by Josie in that case. The conviction was for neglect, not abuse, and that is important. Now, again, the government wants you to conclude that Josie was an abuser then. She was secretly an abuser, and now she's an abuser now. But you cannot use that reasoning. The instruction tells you that you cannot use that evidence to say that this is what happened. And again, if they had the facts to support their case, they wouldn't have to go lean so heavily on an older situation that doesn't even prove what they say it does. And just one quick point on that, which is that most people don't know what actually happens in criminal cases. All people usually know is what is in the criminal complaint. And that is a document written by prosecutors that has all the bad information that makes you look guilty, makes you look the worst. But people don't have access to the police reports. They don't have access to the medical experts, any of the forensic analysis. They don't really know the facts. And so when somebody has a past, particularly in a very troubling case, people are inclined to believe the worst because they just don't know the details.
Because I'm gonna object, we stipulated to these facts, and we're now arguing the facts that we stipulated to?
I assume he's talking about the stipulated facts.
Yes.
We can
I'll
talk
move on.
about the
I'll
stipulated
move on.
facts.
So again, this is evidence meant to insinuate that Josie is secretly abuser without evidence. And there's a saying that where there's smoke, there's fire. And that is true. As far as I know, I don't know anything that produces smoke other than fire. But what looks like smoke is not always smoke. And in this case, what you're seeing is the massive cloud of dust that they are kicking up to distract you, to overwhelm you, to inflame you, to do anything other than look at the evidence in this case or lack thereof. Now, the neglect case was very serious. It was wrong, but it was not abuse. And it does not explain what happened in this case. But what it does explain is how the medical providers were so quick to conclude that Alexavier had been abused in the femur fracture incident. And I won't dwell too much on that because government's lawyer didn't talk about it too much. But just to be clear about that, the medical expert who looked at this femur fracture, who was most qualified to make an opinion about it, he said that this was 100% not abuse. Doctors don't speak in such certain terms unless they know something is true. And that was true. And Dr. Peterson knew that. And that was why he was so certain. And these other concerning conditions that I think the nurse was reasonably concerned about, and Dr. Glowacki, who you heard from, reasonably concerned about, those were found out to be not fractures, those were developmental conditions. But they look like fractures on an x-ray. And so the providers were concerned, reasonably. But the facts turned out not to support their concerns. And again, the only qualified expert that we heard from says that that was not abuse. And it is reasonable to believe him. But we saw through that femur fracture incident how suspicion immediately became conclusions. And that is the problem in cases like this, because we're talking about very difficult subjects. And it's hard not to get very angry about this. But anger clouds our judgment, and it clouds our ability to critically examine the evidence. And that's what we're here to do. So touching once more on the second point, which is that the medical science does not prove murder in this case. In fact, it suggests otherwise. Overdose as a possible cause of death. Injuries that were not inevitably going to cause death. Injuries that do not reflect an intent to kill. That's all testimony that you heard from the medical experts. You heard that there was no fatal head trauma, no strangulation, and the blood loss was not a fatal amount. And you heard that alprazolam was crucial to the finding of the cause of death. None of the experts qualified could conclude that there was an intent for Alexavier to die. There was toxicology, again, showing highly elevated levels of alprazolam. This is not disputed. That was enough to kill an adult and certainly enough to cause a child's death. But here's the other point that's very important, is that this was a gradual process. And that reflects not a sudden, violent, homicidal rage. That is a gradual process, and sadly, it's consistent with overdose in this case. And the blood loss numbers, again, not sufficient to cause death. Those were not injuries that were inevitably going to lead to death. You had effectively 1/15 of the total amount of blood volume lost when you have to reach approximately 33% to start going into shock. And so these were awful, but they were not the types of injuries that would inevitably lead to someone dying. So again, the medical science contradicts the state's murder theory, and it points toward overdose. So I'll move on to a very important issue in this case before getting to the elements, which is the witnesses that you heard from and determining their credibility. You have Derek, Lorley, Major, Brantley, and children's statements filtered through adults. And you heard the statement, do you like getting your ass beat, whether you punched or kicked the children? I don't think so. Derek testified that he couldn't control his violence. So let's talk about Derek Pedron's credibility. We've heard about all of the violence. Indisputably, he was deceptive throughout the investigation. He was shown to be manipulative, chronic liar, an alcoholic addict. And there was this sham marriage with Lorley, which we heard about from Misty Craig. And he lied about the timeline. We'll get to that. The timeline of when he got home that night, the night before Alexavier died. But let's just take some basic impressions from that testimony, because there were so many lies, it was very difficult to categorize and catalog them. But here's a figure that I think tells you all you need to know. When he was asked questions on his direct, questions that were designed to make Josie look bad, he was very certain. He was certain of his answers. When asked questions that would have made Josie look good in any way, he testified, I don't recall, 130 times or more. If you're telling the truth, you do not have to remember what you told other people. And you experience this, having to go in and out, while Pedron had to constantly be reminded of what he had said on a video recording or an audio recording or something else, just to remind him, yes, that's what you said. You remember that? Again, if you tell the truth, you don't have to remember what you said. And then we had Misty Craig, who testified very reluctantly. I don't know about you, but she looked like another victim of Derek Pedron. Well, in fact, she testified that she was, because this was the Derek Pedron who was the abusive thug staring at her from the gallery. And she testified reluctantly, but she acknowledged that Derek said that he would cut her fucking head off and send it to her mother if she testified about the trial. And he said that he fucked up by telling her about the marriage to Lorley being related to this very trial. And then we had Justin Bolito. Thank God for Justin Bolito, the Good Samaritan that was watching this trial on TV like many others are. And he was so astounded and outraged by Pedron's lies, open lies on the stand, that he reached out to us to set the record straight. He did not want to get involved in this. That is the last thing he wanted to get involved. But he was so troubled by the lies about Derek claiming he never used Xanax that he put himself into this, understanding that he could be put through the ringer. And boy, that is true. You saw the government's lawyer go up and just trash him and berate him with accusations that, let's put it this way, must have come from Pedron without verification. That's all I'll say about that. But what the government lawyer didn't attack was Justin's testimony about Derek Pedron using Xanax. Never attacked the veracity of that. Apparently, according to the prosecution, this young man was engaged in some big grudge against Pedron for terminating his employment at the car wash in some sort of epic bid to regain his minimum wage employment at ShipShape. Is that realistically something that people would want to do, to insert themselves into a trial like this because they want to get their job back for the work under Derek Pedron? There's a law school saying that if you don't have the facts, you pound the law. And if you don't have the law, you pound the facts. And if you don't have either, you pound the table. We saw a lot of table pounding in this trial, did we not? Now, again, if Derek Pedron is willing to lie about these things, what makes us think that he wouldn't lie about his responsibility for Alexavier's death? You have to rule out beyond a reasonable doubt that Pedron was the source of the Xanax. He admitted it. You have to rule out that Pedron was the source of the injuries. We know that they could have occurred at the time when Derek was alone with Alexavier. We know that. And we know that Derek lied on the stand. Now, a reasonable doubt is a doubt that would cause you to pause or to hesitate when called upon to act in the most important affairs of life. And so what are the most important affairs of life that we all go through at some point? Whether to choose a partner, where to live, educational decisions, financial decisions, medical decisions, buying a house. Well, forget buying a house. Would anyone buy a used car from Derek Pedron? And how about Brantley and Major? Their testimony fell well below reasonable doubt. But the government is not trying to sell us all a used car, sell you a used car. They're trying to sell you someone's freedom. That is why this is so serious and important, that this is taken, this is analyzed carefully, cautiously. So let's talk about the children's testimony. There's not a question about whether those children are sympathetic. Of course they are. But the question is reliability. The question is whether we can rely on their testimony in a trial for first-degree intentional homicide. The state must prove beyond a reasonable doubt that these children weren't coached. The state must also prove beyond a reasonable doubt that they did not lie under oath repeatedly. And they also must prove beyond a reasonable doubt that these children were so consistent, so credible, that their testimony can be relied on in this very homicide trial. What did we hear from the children? Again, the same habit of answering certain questions with confidence that made Josie look bad. But anything that made her look good in any way was met with a, I don't know. Now, this is something that I don't know if everyone caught when Brantley was testifying. Well, she was calling Josie, Mom Josie a lot. That was the name that he used instead of mom. He said, Josie did this, Josie did that. But at one point, he answered, our mom. And then he immediately corrected himself. He corrected his own testimony and said, Josie. Now ask yourselves, does that sound natural, or is that something he was taught to say? And he apologized. He apologized to Pedron in the middle of his testimony. And he was asked about that when he came back onto the stand. And he said he apologized to his dad for lying. So he admitted he lied on the stand. But what did he say that he apologized to his dad about? He apologized to his dad for not telling the jury, for not telling you that his dad was an alcoholic, basically, that he used alcohol. That was what he said. I'm sorry, Dad, I didn't tell him that you used alcohol. Now ask yourself, does that make sense? Do you think that he was apologizing for making his dad look good in the eyes of the jury? Or is it that he let slip something he was told not to say? When you have competing inferences and competing doubts, the jury instruction tells you very clearly that you must resolve every reasonable doubt in favor of Josie. And that is the rule that you will need to apply when you're in the jury room. And again, bringing it back to that 2022 911 call, where Josie reported this assault from Pedron regarding the ground beef. And she said, Derek repeatedly punched her in the throat and strangled her, and that he did the same thing to Alex, and that he was teaching his son to lie. That is as reliable as you can get. That occurred at the time, not in preparation for this trial. And that's important. And you can consider that. And so let's talk about Brantley's testimony about the femur injury or the supposed kick down the stairs. So he says apparently he was not talking about what caused the fracture, that this happened after Alexavier had broken his leg. And you must ask, is that consistent at all with the evidence? Now, there was no certainty of the exact day, and we can't rely on his dates, but let's just look at the evidence that we have, the objective evidence about that injury. There was a follow-up appointment with Gunderson where he was found to be healing well. Dr. Golacki checked in, make sure that happened, and Josie took him to the follow-up appointment, and he was doing well. And then Sarah Wagner Barton, the CPS worker, she did a home visit. She came through the house. Now, first she talked to the medical staff, and the medical staff had no concerns about Josie. And she also found that the kids were in good spirits and that she found no immediate safety concerns. But there was another little detail in that report of her talking with Alex and the family at Gunderson, where she said that Alex did tell her that Dad would spank. Well, and moving on, Ms. Wagner Barton then went to do the site visit at the house, and she went through and she saw that the kids were being well cared for. They had all of their basic needs met. She had no concerns. Alex was doing well. He was proud of his cast. He was healing well. And that tells you that he was still healing well. He had not re-injured his femur. And then we do have the autopsy report. And there was no evidence that his femur injury had been aggravated. So the objective evidence contradicts this idea that Josie kicked this child down the staircase. And we saw that staircase. That thing was a death trap. And just to reiterate, the staircase condition was dangerous, but Josie was a renter. Shame on that landlord for allowing them to live in that condition. A tenant cannot be expected to just install railings or put walls alongside a staircase, finish a basement. That is not within their capacity. And so that is something that cannot be held against Josie. Now let's talk about Major Hellerud and his testimony. And the issue there is that you saw his testimony evolved as contrary facts got in the way. Reliable memories do not shift every time they are tested. And again, if you're telling the truth, you don't have to remember what happened. So you had the changing bedroom account, where Major's story changed as the facts developed. First, he saw this attack supposedly in Josie's bedroom from his bedroom into hers. But then he was confronted with the fact that there was a curtain up. And so he said the curtain wasn't always there or it wasn't always up. And then when he testified at trial, it became he actually walked into the room. How can we know? None of those all cannot be true. And you can disregard that testimony because you have to determine whether it is precise proof that you can rely upon. And then you had this implausible testimony where Major said that Alex soiled himself because his mom would have let him go to the bathroom. Now, does that make sense that Josie would make a child soil himself so that she would just then have to clean up herself? That makes no sense. And then you saw the delayed appearance of this other serious allegation about the bending of the leg back while choking, which is how he mimicked it in the interview. And this was not mentioned in the first interview, but it appeared only after he had discussions with family and reappeared. But then he testified at trial to the opposite facts, that somehow this was a bending backwards. And this was a completely implausible mechanism for injury. So this was implausible and it changed over time. And we all know that we show that the evidence suggests that the family discussed the case with Major. And there were concerns about coaching. And so the pattern was, Major remembered dramatic accusations, but when he was confronted with inconsistencies and prior statements and specifics, his response became, I don't remember. Again, how many times did he not remember? 137 times. He remembered the accusations, but not the contradictions. And the law requires testimony that is so consistent, so credible, that no innocent explanation could be true. So, does that mean you should not rely on anything the children say? Well, think about the example of a big pot of stew that you're making for the family. And somehow a big piece of rotten meat goes into that stew. Would you still keep the stew? Would you eat it? Or would you throw it away and start again? That is why you cannot rely on these statements as precise proof of the allegations in this case. We know the state itself is uncertain. We heard that from the lead investigators. But we also know because of the charges in this case. We see how the government added charges in the very middle of the case. That's why you have a new option here for reckless homicide. Because the state is trying to throw as much, everything that they can against the wall and see what is going to stick. They need something to stick. But let's talk about the first count, intentional homicide. The state must have precise proof of causation. And if overdose is an explanation, there is no causation. And if injury is insufficient to cause death, that is not causation. So what do we not have here? We have no motive, we have no eyewitness, and there's no DNA tie, and there's medical uncertainty, and no coherent explanation. Why would Josie suddenly become a murderer while texting with Laura Lee and phone calls with Laura Lee and texts with Raphael, planning the date next morning with children? And let's talk about the timeline of that evening, the day before, February 10. Derek Pedron arrived home at 5:30. How do we know that? Not because he told us. He said he got home at 6:30. But then we found out because we had the surveillance evidence to prove that he had left the Walmart at 5:30. And why would he lie about when he arrived at the house? He thought he would get away with misleading you. And we wouldn't have found out if we hadn't looked at the footage. Perhaps the government hadn't looked at the footage. But if he's lying about the timeline, then we have to wonder, is he lying because he thinks he'll never face accountability? And we know that Alex was awake at the time Derek was around. This was something that Major certainly testified to as well. But let's just get to one detail that I think is very important here. Pedron testified that he had changed Alexavier's pants. But there would be no...
That mischaracterizes the testimony. Mr. Pedron never testified that he changed. That came from the defendant.
Forgive me. There was testimony to that effect. Thank you. But there would be no reason to do that if he hadn't soiled himself. So again, we know that Alexavier was up at some point, and we know that he was asleep during the welfare check. And we know from the medical experts that that would be consistent with either potentially a concussion, a mild concussion, or mild alprazolam intoxication. And so that is certainly consistent with the timeline. And we know that Pedron was downstairs near him at that time, and that Derek had Xanax access. And so we know that Josie was texting about going on a date, and she slept from 3 to 9. Is that consistent with someone who knew she had just murdered a child? And again, her behavior in the morning, it was normal texts, ordinary plans, and then a shocking discovery and CPR attempts, immediately raising overdose as a concern. Panic. And is this consistent with somebody who had just brutally murdered a child? Now, I remember we watched the interview with Josie with Lieutenant Williams. We all watched that together in the trial. And I remember watching that for the first time. And what I saw was a woman who was in shock. She was self-soothing. She appeared to be in disbelief and in grief. And it felt real to me on a physical level. This did not seem like a woman who expected for this to happen. She did not look like a woman who had just murdered a child. And so the reality of the home was that Derek dominated that environment with fear, intimidation, violence, drug use, children cowering in closets. And we have evidence of Josie's relationship with Alexavier. She communicated with the school regularly. She wanted to make sure that he was able to celebrate his birthday because he had a summer birthday and didn't want him to feel left out from the other kids who could celebrate their birthdays. She wrote to the teacher to make sure that Alexavier, she was concerned he was getting bullied. And so she wanted to make sure that Alexavier is not being bullied. Is that a woman who had callous disregard for this child's safety? Is that something, if you had just this murderous rage for this child, that you would do something like that? She wanted to make sure that his winter gloves fit properly, that he had water, that he had toys, that he had Happy Meals, having him sleep next to her in bed, taking him to doctor visits, making sure that he had badger care so that he could have dental care. When his dad had simply just tried to take a cap and shove it back into his mouth. And then we saw the Walmart video where Josie made sure that his sister went and got him a sucker. She wanted Alex to have a sucker too, so he didn't feel left out. She cared for Alex, like her own son. And again, does this seem like someone who had hidden homicidal rage for a child? This death was tragic, but it was not intentional. So count two, we see a contradictory theory where either she intentionally or recklessly killed him, but if you don't believe that, then she negligently caused his death. And you must find 3 separate acts of criminal neglect, not just careless or something that could have been done differently. Neglect, criminal neglect, and causation. And to prove causation on count 2, you have to believe, the government has to prove beyond a reasonable doubt that Josie knew where Derek had put the Xanax in that household. Now, there is no proof that Josie knew there was still Xanax in that house. Derek was connected to the drugs, but there's no proof that she controlled the Xanax or even knew where it was. Now, Derek was an addict facing arrest. The simplest assumption or conclusion is that he either took it or flushed it. She would not know what he would have done with it while she was dealing with Sergeant Kernine. You cannot negligently fail to secure something you don't know is there. And if Derek caused the injuries were not obviously fatal to somebody who would observe Alexavier. There was no proof that Josie knew that his death was somehow imminent. Tragically, abuse had been normalized inside this home. Now, hindsight cannot replace proof. And this is an attempt to get the jury to reach a compromise verdict. If you don't believe the other theories, then you can settle on this one. But the law doesn't permit compromise when the evidence does not support chronic criminal neglect. And so let's go to count 3, repeated abuse and abuse causing death, that Josie failed to prevent abuse or caused abuse. Now, the major failures of this count are that, again, overdose is not ruled out. Injuries not proven to be fatal. And Derek, as the source of those injuries, not ruled out. And in terms of the failure to prevent any of that, they have to show a capability to intervene or a capability of doing something that would have prevented future harm. Now, let's talk about the bathroom incident. Derek goes into the bathroom with Alexavier and closes the door and locks it. She thinks he heard Alexavier, but she doesn't know exactly what happened. What is she supposed to do? Kick down the door? Physically overpower this person who has abused her repeatedly? Or call police at that moment? Calling police has never worked before. Calling the police would not protect her or Alex because Derek would get out every single time and the beatings would only increase. And again, remember that 911 call where she did report Derek hurting Alex and teaching him to lie? What happened after that? He got out and he immediately battered her again. Calling the police would not have caused or prevented, or would not have prevented future harm. We know that restraining orders wouldn't stop him. Nothing would stop him. So before I sit down, I want to share some final thoughts, because when I sit down after this, the government's lawyer has the last word because the government has the burden of proof here. So I just want to say thank you for sitting through what has been a painful trial. We could not do this without you. But you are doing it, and you are doing it the right way. And this case is heartbreaking. A young child died under horrific circumstances. Alexavier should have had a future. He should have had an opportunity to become something other than his father. And sadly, that opportunity was taken from him. And if I were sitting where you're sitting right now, I would want to punish someone for what happened to Alexavier. I would want that. Anyone with a conscience would want that. But the person who deserves that punishment is not on trial today. And I ask you not to convict Josie for her abuser's crime. Because the law requires justice. And justice is not vengeance. Vengeance is easy. Vengeance says a terrible thing happened and somebody must pay for it, even if the proof is uncertain. Justice is much, much harder. Justice requires discipline. Justice requires understanding when there's no uncertainty, even when it's emotionally unsatisfying. Justice requires understanding that sometimes the evidence doesn't provide a neat, complete answer. But does it achieve justice to rely on an investigation that searched only for evidence of Josie's guilt? Does it achieve justice when the medical science does not support the government's murder theory or its allegations of count 3? And does it achieve justice when there remain multiple reasonable explanations that are consistent with Josie's innocence? It is up to you alone as jurors to determine that. Now, your duty is not to the defense, not to the prosecution, not to public opinion, emotion, or sympathy. Your duty is to the law and to your own conscience. And to be able to walk out of this courtroom without ever having to wonder whether you may have convicted an innocent person. And if you have that doubt, then you have your answer, not guilty on all counts. Thank you.
Thank you.
Do you want me to go, Your Honor, or do you want me to?
Do we need a break for 5-10 minutes, or do you want to go ahead? Like everybody's ready to go ahead? Why don't you go ahead?
Ladies and gentlemen, believe it or not, my favorite jury instruction is the burden of proof, because it says exactly what your job is. Your job is not to search for doubt. Your job is to search for the truth. What you just heard was the smoke show continue that Josie started, the defendant started with her testimony. Look at all these other things, but how much of what the defense argued focused on the 2 days involving Alexavier's death? Heck, how many times did you hear the name Alex or Alexavier during their comments? They brought up the 2011 and 2013 other acts as if that was the entirety of what the state relied on. The state's argument regarding those was less than 5 minutes, and the state's argument regarding those told you exactly what the law says and how to use it. They're the ones that brought up using it improperly. I want to talk first about the accusation about the investigation in this case, and that there was tunnel vision associated with this defendant, because nothing could be further from the truth. The defense gave the example of a puzzle that is missing pieces. There was a puzzle with missing pieces in this case, but it was the defendant that was taking those pieces away from the. When they responded that day, they were first responders trying to save Alex's life. They performed CPR on Alex's body. In the efforts of trying to perform CPR on Alex's body, they moved the pill container. They put it on the bed. They touched it. When this case was first being investigated, as an overdose. That pill container was sent out to the crime lab to see if it had Alexavier's DNA on it. Why? Because law enforcement was looking to see if this was, in fact, an overdose, just like the defendant said. That's why they sent it out looking for Alexavier's DNA. They were investigating it as an overdose. If you looked at the first search warrants in this case, which was brought up, the first search warrants were looking at child neglect resulting in death because they were looking at it as a potential overdose where drug exposure happened in the home. Is that pointing the finger at this defendant? No, that's keeping an open mind. You heard that the defendant willingly gave over her cell phone. You saw the video. Investigator Williams said, we're going to get a search warrant for your phone. She knew they were going to get a warrant for her phone. It was with that information that she turned it over. But the defense paints it like it was a voluntary, here's my phone, here's my passcode, look at whatever you want. That's not what she did. And don't let them portray it that way to you. Law enforcement did investigator search warrants for her accounts, Google, Facebook. But they also did them for Mr. Pedrick. They were also examining him as a potential suspect. You heard that they did search warrants for her and for Mr. Pedrick. But it was this defendant's words to investigators originally, and this is important. That morning, she said that Alexavier was asleep the entire time that Mr. Pedrin was home. Alexavier was asleep the entire time that Mr. Pedrin was home. Why is that important at that stage of the investigation? Because the autopsy is done on February 13th, and that's where they see all the internal injuries. Based on the internal injuries, they now know that this is a child abuse case, that it's a severe child abuse case. But what the defense doesn't want you to know is that the investigators are relying on her word during this portion of the investigation. Her word is that Alexavier was asleep during that time frame when Mr. Pedrin was home. And so what does that mean? That narrows the suspects. Mr. Pedrin couldn't have committed the child abuse according to her words. And so they have now lost probable cause to get a search warrant for his phone. But they don't tell you that. And so they continue to investigate. They have the internal injuries. They have the forensic interviews of the children. And the forensic interviews of the children, in all of the forensic interviews, not one of the children ever says that Mr. Pedrin does any form of child abuse to any of them. Araya, no child abuse by Derek Pedrin. Brantley, no child abuse by Derek Pedrin. Major, no child abuse by Derek Pedrin. But they all point the finger at this defendant alone. Those children were in two separate homes, and they talk about hitting, kicking, and choking by this defendant. That's magnificent coaching by some power from above that children in different homes can magically say the same thing unless that's what happened. And so now, they are looking at this defendant for child abuse. Because this defendant's own children say she's a child abuser. And then they get the toxicology results. And they have a conversation with Mr. Pedrin. And I want you to think about what Mr. Pedrin says regarding the toxicology results. I buy Xanax. He's admitting that he illegally purchases Xanax. He's admitting that he illegally purchases Xanax for her. And who has the phone, the only phone with a text message that comes back to Xanax? This defendant. Text message to her mother saying, do you want to try a Xanax? What does that message tell you? She has Xanax, she possesses Xanax, and she's willing to give it out to someone else if they want to try it. Now, she's had the benefit of listening to everyone testify. She's had the benefit of seeing that text message and knowing it's going to come into evidence and having to come up with an excuse for it. And how much did you hear that she was prepared? She initially said that she prepped every week since being charged in this case for the moment that she was on the stand. Think about when she was charged with the offense and she got a copy of the criminal complaint. And it mentions the child abuse and it mentions the Xanax for the first time. She knows about the results. Who's the first person she calls in this world? Mr. Pedrin. What does she say to him? I love you. Repeatedly. I love you. Do you love me? I want to talk to the children. And what does Mr. Pedrin say? He allows her to talk to the children. You heard arguments from the defense about the theory of the case. The theory of the case. Investigative Sergeant Rich Amundsen testified that Mr. Pedrin is still a suspect. What do you know about this case? You know he was bringing Xanax into the home. Heck yeah, he's still a suspect. You know he committed child neglect. Heck yeah, he's still a suspect. There's nothing that Investigator Sergeant Amundsen said that is not true. But they want you to believe that because he's a suspect in those things, he's a suspect in the abuse and death. That's not what was said. They were asked if he was still a suspect, and the answer is yes. To neglect, to delivering Xanax to her. And you're asked about a working theory of the case. You heard the theory of the case, not from Investigator Williams, who is removed from the case after doing a few months' work on it, is obviously upset about being removed from the case and hasn't done any work on it since. But you did hear a complete theory of the case from the investigator that's been on it ever since. Let's talk a little bit about the DNA evidence because the defense wants to make a big deal about that DNA evidence, right? You didn't test the bag that belongs to this defendant. You didn't test the pill container that belongs to this defendant. It was tested. It was tested for Alexavier's DNA. And then when they went back and watched the body cam, they saw CPR being performed. And then they saw those containers being moved. That's Alexavier's DNA being transferred to those containers. The bag is her bag. Of course it's going to have her DNA on it. What they didn't explain and what they can't explain, because it demonstrates her guilt beyond a reasonable doubt, is that bag coming down and being put on the floor. Is that pill container being emptied out? Is that pill container being used to stage an overdose? And what did that buy this defendant? It bought her time. It bought her time that day because the investigators allegedly looked at the scene and said, this does look like an overdose. But then they started putting the pieces together. They started looking at the evidence because what they didn't know when they responded to that scene was all the internal injuries that Alexavier had before he was administered those drugs. When you know those injuries and you know how severely this child was abused, when you know that in the context of this bag and a child having to open that container, when you know that the pills were dumped in that bag, you know it's staged. The defense also keeps throwing out overdose, 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 as if that's what the medical examiners said in this case. The practice of medicine involves differential diagnosis. It involves looking at the entirety of the facts and the picture. If you look at just the pills and the toxicology results in this case, it's consistent with overdose. That was the question. But you have to look at it in the context of a beaten and battered child who is then drugged, who is then given the amount that could kill an adult human being. Who is given an amount that's going to result in that child being unconscious and dying within hours. That completely removes Mr. Pedrick. There's only one person in the world who had the ability to administer drugs to that child, this defendant. There's only one person who had the ability to abuse that child without anyone else knowing about it. That's this defendant. There were other children in the home. Mr. Pedrin was there. She said Mr. Pedrin couldn't have done it originally. It was only after being charged at trial that she says, this is what I heard in the bathroom. But you also know that didn't happen because you know how severe those injuries are and you know how symptomatic Alexavier would have been. A fractured rib, a lacerated liver, bleeding into his mesentery. You saw the photographs of all of his injuries. You heard that law enforcement had contact with him and saw none of that. You heard that Laura Lee heard a voice of a child that was okay at 10:30 at night. Dr. Quinton testified that both the injuries and the toxicology in his system were substantial factors to his death. So no, it's not correct that if you rule out toxicology as an overdose, and if you look at just the pill matters, that this isn't a homicide. That is not what Dr. Quinton said. And the other forensic pathologist, the one who didn't write a report, if we're going to criticize law enforcement for not writing a report during a meeting with somebody, what about their forensic pathologist who didn't write a report with all of his findings and conclusions? It was left to me asking questions, only to find out that his opinion is that an adult abused a child, that he would have been symptomatic rather quickly as a result of those injuries, and that with that amount of toxicology of Xanax in his system, he would have been unconscious and dying within a few hours. That was their expert's testimony that he couldn't bother to put in paper despite being paid $12,000. Why, the defense screams. The instructions that you have in front of you say that the state does not have to explain motive. And don't let them put that on the state. That is not the state's responsibility. The state's responsibility is to prove facts and evidence. And the facts and the evidence are that this defendant brutally beat a child and then administered Xanax. There's only one person in the world that could stage that scene, to bring that bag down, to empty the pill container, to put it by the body, to buy more time. Those who have nothing to fear have nothing to hide. Who's the person who's been hiding things and concealing things since the very beginning of this case? Whose testimony wasn't even commented on by the defense? This defendant. If children get something wrong on the stand, they're inconsistent. If children are too consistent, they can't be believed. That's also what was argued in this case. What kind of world do we live in where we can attack a child no matter what they say in a courtroom. It's just never going to be good enough. Because child abuse is a crime that happens behind closed doors, and if it's children that witness it, too bad, so sad. No matter what, they just can't be believed, even when they're that consistent. Those who have nothing to fear have nothing to hide. This defendant has hid a lot. Tell her that you see her. Tell her that you see her for who she is. Tell her that you know what she did to Alexavier. Tell her she's guilty.
Thank you, Mr. Torberson. So, ladies and gentlemen, carefully consider the closing arguments of the attorneys, but arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence and upon the instructions given to you by this court. You are to decide this case fairly and impartially, without fear or favor and without passion or prejudice. You are to decide only whether Josie Dikeman is guilty or not guilty of the offenses charged. Any consequence of the verdict are matters for the court alone to decide, and you must not must not affect your deliberations. Now, the following 8 forms of verdict will be submitted to you concerning the charges against Josie Dikeman. In count one reading is, we, the jury, find Josie Dikeman guilty of first-degree intentional homicide as charged in count 1 of the information. Another, the second reading, we, the jury, find Josie Dikeman guilty of first-degree reckless homicide as charged in count 1 of the information. The third reading, we, the jury, find Josie Dikeman guilty of second-degree reckless homicide as charged in count 1 of the information. The fourth reading, we, the jury, find Josie Dikeman not guilty of count 1 of the information. Another reading, or count 2, another reading, we, the jury, find Josie Dikeman guilty of chronic neglect of a child. Consequence is death as charged in count 2 of the information. Another reading is we, the jury, find that Josie Dikeman not guilty of chronic neglect of a child. Consequence is death as charged in count 2 of the information. Count 3, one reading, we, the jury, find Josie Dikeman guilty of physical abuse of a child, repeated acts causing death as charged in count 3 of the information. If you find Josie Dikeman guilty, you must answer the following questions. Did at least one violation cause the death of the child? Yes or no? To answer yes, you must all agree on the violation that caused death. If you answer no, you should consider the following question. Did at least one violation result in great bodily harm to Alexavier Pedron? Yes or no? To answer yes, you all must agree on the violation that caused great bodily harm. The final reading, it's on the second page. We, the jury, find Josie Dikeman not guilty of physical abuse of a child, repeated acts causing death as charged in count 3 of the information. I just point that out because it's on a separate page in the verdict you'll be given. It is for you to determine whether Josie Dikeman is guilty or not guilty of each of the offenses charged. You must make a finding as to each count of the information. Each count charges a separate crime. You must consider each one separately. Your verdict for the crime charge is one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must reach unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you're deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it's important that you communicate with the court only by written note. If you have questions, the court will talk to the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you've agreed upon your verdict, have it signed, dated by the person you have selected to preside. After you have reached a verdict, your presiding juror will notify the bailiff that your verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court. The court may ask each of you if you agree with the verdict. So at this point in time, we're going to swear the officers. No, we'll do the alternates after we swear the court officers.
Do you swear that you will, to the best of your ability, keep all jurors sworn on this trial together in some private and convenient place until they have reached their verdict or are discharged by the court? And that you will not, before they have rendered their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon?
All right, at this time, we'll select the alternates. The two numbers, because today is May 14th, 5 and 14. By the way, your names are randomly given different numbers, 1 to 14, so I don't even know what that is. There's two random numbers here. Who are the two alternates? And rather than their names, if we could use initials, 5 and 14. Initials.
NK?
Is there only one NK here? NK? Nobody's NK? Okay. Okay. WM. Okay. So we have the two. So the two alternates, what I'm going to do is have all of you go on out. The two alternates, if you could meet me in my office, we have a couple minutes to do some things, but I want to talk to you for a moment. Oh, thank you. Please leave your instructions there. I will gather them, we'll bring some back, and we'll also bring you the verdicts. Thank you. Okay, everybody may be seated. Some minor detail just occurred to me is tomorrow we have a different bailiff coming for one of the bailiffs. We'll have to swear that bailiff in. My question is, we should do that on the record when they get here. Parties can be there, obviously, for the swearing. I would do that at 8:30 tomorrow. Well, as soon as they came up with the jury. That's just we just have we have a different bailiff tomorrow. So somebody can come up to represent the parties. Not everybody has to be here necessarily, but just so you know. I'll ask them to show up 8:30, and as soon as they're all here, we'll ask them to hold off, and then once the jurors or the bailiff is sworn, we can start. Does that sound like a way to deal with that, Mr. Torbenson? That just occurred to me that that's an issue tomorrow.
Yeah, we can make that work.
Judge.
Okay. Then the other, first of all, was there any problem with how I did the final reading of the jury instructions, Mr. Robinson?
No.
Mr. Zacher?
Oh, yeah.
And my usual practice is not to send any exhibits back. If they ask about an exhibit, I'd probably end up calling you and asking what you feel about it going back. Give us numbers so we can reach you. I initially start with a call. If we need more of a hearing, we'll bring everybody in. The other thing is we're telling the jurors that they can go to about 5:30 tonight. We will break and have them come back tomorrow morning, as I think I said. I'm not sure I said this, but that's what our intention is, 5:30 to 6, whenever they want to break.
Judge, is your intention that if we get close to 5:30 to come at the record, on the record and dismiss them, or are you going to dismiss them without coming back?
I will put it on the record.
Okay.
And so we do need somebody available.
Okay.
Between 5:30 and 6, if they feel like they need that break. If we find out otherwise, we'll let you know, but anything further from the state?
No.
Anything further, Mr. Zacher?
Judge, I do have to put objections to the state's rebuttal on the record here. Once more, the concern is burden shifting when the explicit language is what the defendant didn't explain, and expecting a response or an explanation from Ms. Dikeman's side of the case. Additionally, we're going to object to mischaracterizing when the state indicated that all 3 children said that Ms. Dikeman abused Alexavier. It's arguable even with 2 of them, but Araya in particular said nothing of the sort.
Okay. I may change my practice and do so 160 after, because I think that addresses that issue somewhat, which is when you do 160, you say, rely on the evidence. Now, just so you know, I'm not making any comment about it, but what I'm trying to say is that if there is, because rebuttal happens, no, you can't respond. If there is evidence which is not in the record, that tells the jury, hey, you're supposed to disregard it if it's not there. So I think you have to put the objections on the record. That's clear. But I'll note those objections. I'm not going to do anything at this point with the jury and deliberations. So.
Thank you, Judge.
Just for the record, the forensic video of Araya talked about soap in the mouth, and I would consider that a form of potential abuse, especially from a non-parent doing it. But so she did make that statement during her forensic.
Okay. All right, give us numbers. Like I said, we'll let them deliberate for a while, and hopefully we'll let you know if something happens. Thank you.
Calls are fine.
Hey, do you want to write yours?
I'm always up in the middle of the night, so.
All right, thank you, everyone. Oh, shoot, let me give this to them.
Are these just our copy?
Yeah. Yeah.
Do you stay here?
Stay relatively close. And I will need you back at 5:30. Yeah, I do. I can't get out of the enclosure here. Yeah.
Well, it's not all gonna fit. That's why I'm
Really
gonna
can't, yeah.
do 2 trips.
I'm sorry. I didn't get to see all the closing arguments. I do see some movement in the courtroom, so I don't know if that means that they may be coming back. I figure I saw that. Say, hey, Mark. I just walked in the door. My dog missed me. He's going nuts. I didn't get to hear all the closing arguments. I only got to hear bits and pieces, obviously. But all I noticed was that the prosecutor was yelling a lot. He was like yelling at the jury. What did y'all think of the closing arguments? Who do you think did better? The prosecution or the defense? I feel like the prosecution on the rebuttal just beat a dead horse, but that's what they usually do. Oh, I saw people in the plexiglass, so I kind of thought they were coming back, but do you think they'll come back with a verdict today? I wonder. I don't know. You think so? Oh, see, there's movement. I see people's. All right. We'll see. They have a lot to consider on the jury charges. Those direct instructions are very detailed. Hi. Yes, I missed you too. I think they'll find her guilty on a lesser charge. Yeah, I think they will on a lesser charge. I don't think the first degree. I think on the maybe reckless homicide. I don't think she could be. I don't think they proved first degree. I haven't been in other chat rooms though. I have not checked other stop. But I'm pretty sure in the other chat rooms they are being very ugly to her. Yeah, they're pretty harsh. Yeah, the other chat. I mean, some people are like us where they think that he succumbed to his injuries from Derek. I just feel like it's a similar case to the treadmill trial. I think it's very, very similar to the treadmill trial. I just think that neither side did a very good job for Alex. I don't think the prosecution did a good job for Alex. And I hate that. But I think that I think they when they talked about, I did hear a little bit of him talking about the staging of the scene, which I think it was kind of a stretch I think talking about the whole staging the scene. I don't know if she's that smart, to be honest with you. I mean, I don't know if she could think that far ahead, but then at the same time, she did wait a while to call. So there is that. To call 911. There was a gap of time before when she called her mom to when she called 911. So what was she doing? Although she did say on the stand that she was spending that time with Alexavier because she couldn't accept that he was gone. So I don't know. I think you could interpret that in many different ways. Has anyone heard you remember the little baby boy that went missing? Was it in Arizona or was it in Colorado? That the mom claimed her son was kidnapped outside of like a sports store. And then it turned out then they like arrested her and the husband. They never found that baby. Does anyone remember that? What was his name? Also, does not anyone not think it's strange that Nancy Guthrie has yet to be found? That's not odd. I just think, I mean, and who kidnaps an 80-something-year-old woman? And who do you think did it? Do you think it was, I think it was someone that knew her or knew, I think it had to be someone that knew where she lived, knew her house. I mean, I just think it had to be because she lived in a pretty, I don't want to say, I mean, she lived kind of out there, out in the desert. And who's going to take an 80-something-year-old woman? That's like taking a baby, a child. It's a lot. It's a lot of upkeep. So I just, and they got nothing out of it. Absolutely nothing. So it just makes me wonder. Oh, I see movement. I see people. I don't know what they're doing. That's what I think too, Mark. I think someone that knew her did it. I think it could have been like somebody that was familiar with her home, or do you think it could have been someone that like was a family member? Because I mean, they did put that out there. So that's in everybody's brain, right? That it was somebody like a family member. So do you think it could have been that, or do you think it could have been somebody that had been going in taking care of her, like housekeeper, caretaker, gardener, somebody that had access that they just overlooked? I just am, or do you think it could have been a family member that had it done, right? This, my thought is, just thinking out loud, that somebody did it, right? And they didn't think it was going to go awry. This is just like in the movies, right? They did it and they were like, well, we're going to do this and we're going to ask for some money and we're going to give her back. But it didn't go as planned and she died. Right? And crap. Kind of like it happens in the movies, but it happened in real life. So I'm thinking, but they had already sent, they had everything like timed to be sent, like the ransom letter, all this stuff was already like ready to go. So I'm thinking they had to follow the plan. It was already ready to go. But they just didn't expect her to probably maybe fight like she did. Resist. I don't know. Because I just feel like you wouldn't go into an 80-something-year-old woman's house and take her. And not only that, but I'm thinking Savannah Guthrie, of all the people in all the world, is she that popular? I mean, I guess I don't watch the Today Show, so I don't know. You never know. You never know. I mean, I guess she's relatable. People watch her every day. I mean, I guess. But I just wouldn't pick that person. It's not the person that I would be like, yeah, that's who I'm going to go kidnap her mom. I don't know. I just find it odd. And I did research her I did research the whole family because, like, so having a crime channel is what you have background check access. So I did background check her daughter, her son-in-law, Savannah, like the whole family. So her daughter she is actually going back to school. She is a nurse, so she took care of Nancy. Her son-in-law is a teacher and has been a teacher at the same school for a very long time. So they're just regular people. They're not like, I mean, yeah, they have a famous sister, and her son has top secret clearance with the military. He was in the military. He worked with very high top secret confidential stuff. So the son, and then Savannah, she's on the Today Show. So her kids are pretty successful kids. The only one, again, is just the daughter that everybody, Anjanette Levy, I think, is the one who went on TV on Law and Crime and said that the son-in-law might have been possibly involved in this whole situation. So I don't know, but they're the only ones that maybe possibly because they were the ones there taking care of her. Maybe I don't know. That's what people were saying. I'm not saying that. I'm just saying. Really sad. I think it's really sad. I just feel like, how can we be here all these many months later and this woman has not been found? I feel like she's not far from home, though. It's just my thought. I think she's still pretty close. Because what are you going to do with her? Oh, crap. Haven't seen any more movement. They said they were only going to stay till 5:30, right? Is that what they said? Oh. They're just teasing us with these little shadows. Oh, so I know I've talked about the Julio Fulio trial. They're in the sentencing phase, right? One of the kids that is part of this gang that was found guilty with this group, it's all over TikTok. It's all over. They're saying he came from a good family. He was a good kid. He just got mixed up with the wrong crowd. And he's like a lesson to, he should be seen as a lesson to kids out there of getting mixed up with the wrong crowd. Because he had everything going for him in his life. And then he goes and hangs out with gang members, basically. And now he's going to, he's up for the death penalty. What? I mean, how does your life go from apparently, supposedly, you know, you're from a good home, and then you're hanging out with gangbangers, and you're on trial for your life? That's pretty wild. And now he's facing death. But I mean, in the videos, he is, I mean, he did it. So when you about that life, hate it, but I know, right? Like you make some bad decisions. It only takes one bad choice, and it's sad too because they're young. Like they're young. Some of these people are like cold hearted. Like in their interrogations, like straight up cold hearted. Like they didn't care. But this kid, like he's just a kid. But he was hanging out with the wrong folks, and he thought he was cool. And I think that's really sad. I just think it's really sad. But it's all over TikTok and all over YouTube, everywhere where he just like, he is messed up. Like his whole life is thrown away. All because he started hanging out with the wrong people. And I just can't, I mean, but if you think about when you were younger, like, thank God there's no social media evidence of when we were younger. Holy crap. I mean, good Lord, at the poor choices I made growing up, but dang, I mean, I look at some of these, like watching some of these trials and looking at some of the things kids do now. Kids just don't understand the finality of things today. I mean, maybe I feel like I sound like my parents, but I feel like seriously people don't understand that it's fine. Like it's done. Once you pull the trigger, once you do the deed, it's done. It's done. Like you can't take it back. You can't say, "Oh, I'm sorry." Like it's just over. And I feel like these people the kids don't understand that these days. They just, until it's too late, till their life is over. And they're seeing themselves going to prison or looking at death row, and then they're like, "Oh crap. I did that." And then it's too late. It's way too late. So, but I mean, like back when I was a kid, I feel like, I mean, I didn't even sneak out of the house. My biggest thing was like not making curfew. Kids now, like swiping left or whatever, right? I don't know what they're doing. It's terrible. Oh no. Now you got the TikToks and whatever. Snapchats. Get all kinds of things. Oh, and that one kid, what was that other kid that was on trial last week? Was it last week or the week before? In Florida, I think, that he got found guilty. He thought he was going to get to go home. Him and his friends rolled up on the teenage girls in Florida. We were talking about it. Stein. Was that his name? Stein? Yeah, he thought he was going to get to go home. because his mama, she thought it was better for him to be smoking pot and drinking and stuff at home. And she provided the rental car and everything. She thought it was better for him to do all the funsy stuff at home and hang out with all his friends. And he was hooking up with people he didn't even know on Instagram and stuff, just hanging out with strangers. And then he hooks up with these 3 guys and goes riding around, and then sticks up these 3 teenage girls on the corner on their way to McDonald's and ends up killing one. And he thought he was going to get to go home. He thought, oh, it was a mistake. I didn't mean to do it. What? It was an accident. It just went off. What were you doing? What were you doing with a gun in the first place? Why are you pointing it at teenagers? Why are you riding around in the middle of the night looking for trouble? I mean, kids are dumb. People are dumb. People are dumb. Oh my gosh. Just as we're talking about Nancy Guthrie, somebody is doing a thing about it could be someone in the family. All right. I am seeing if there's any more movement. I don't see any more movement. Yeah. I mean, I have like 0 patience for the dumb, but I'm surrounded by it. That's why I don't leave my house. I stay home. People are getting dumber and dumber. It's nuts. I don't know. I don't know what we're going to do. I'm just waiting on the good Lord to come. Save us. I'm like, when is he coming? And nobody's ready. None of us are ready. Well, he said, what, till 5:30? Is that what he said? He was going to let them stay till 5:30? And if they didn't have anything, they were going to come back tomorrow? I see movement. Wish I would stop coming in there if you're not coming in there. You don't need anything in there. Just waiting on that judge door to open. Oh, are they allowed to ask questions in Wisconsin? I didn't ask that. Is the jury, let me look that up. Is the jury allowed to ask questions Did he say that? Is jury allowed? Some states, the jury's allowed to ask questions or areas. So it doesn't look like the jury is allowed to ask questions. Well, they have to be allowed to ask questions. Oh, no. So they are allowed to ask clarifying questions. But I have seen trials where jurors are allowed to ask. It's weird. I've seen trials where jurors are allowed to give when a witness is on the stand. Have y'all ever seen that? Where when a witness is on the stand, after the lawyers ask a question, then the jurors can present questions, not verbally, but in notes. And then they pass them to the judge. And then the judge reads them to the attorneys. And then the attorneys look them over and everybody decides if it's okay to ask the witness. It's really weird. But yeah, there's some places that the jurors are actually allowed to be like, oh, hey, by the way, what time did you say you got home that night? And the attorneys and the judge say, yeah, it's okay for them to ask that question, or no, it's not okay, or whatever. And then the judge asks. So, but no, not in Wisconsin. They don't do that. But yeah, in some trials I have seen where the jurors are allowed to ask the witness a question. I wish I would be able to ask a witness a question. That would be awesome. Because there'd definitely be some questions I'd ask. I sure would have asked him, like, I'm sorry, did you give him lorazepam or alprazolam? And what time did you say you beat him? I would be asking questions. They wouldn't allow those. They would definitely not allow. The attorney would be like, no. This juror's a smart ass. Which juror asked that? Kick them off the jury right now. Why haven't you not been picked for a jury, Mark? Oh, I see the judge. Are they coming back, or he's just telling them no, go home? You've been called for jury duty 4 times and never picked. What are you doing? Or is that Gwen? Oh, you were picked for one case. Okay. It was Gwen that was never picked. Okay. Was it a good case? It'd be my luck that I would get picked for like insurance fraud or something lame. I wouldn't get picked for a cool case. If I got called for jury duty. I'm probably never going to get called. I've made it this age and not got called yet. Sucks. Oh my God. That's horrible. Oh, that sounds awful. Oh. Were they guilty? Oh my Lord. Did she live? Oh, I have so many questions. I mean, this court is so casual. The judge does not even come out. Oh, by trolley. Oh, my little arrow thing was covering up part of your thing. I just saw train. I was like, oh my goodness. Oh my gosh. Oh, thank goodness. Oh my gosh. I was like freaking out. A trolley. A trolley mirrored. Oh my Lord. That would still be what was she doing? Was she trying to catch it before? Oh my Lord. That would be my luck. That would be me. That would be me. That I would be the one that would be like trip on the sidewalk on my own 2 feet and look at the sidewalk and blame the sidewalk. What the hell? Yeah, that'd be me. One of my favorite things is watching people.
This is the Dikeman trial. The question. There's
Question.
2 questions are really 2 requests. It's all right. One is, can we watch the first forensic interviews of Major, Brantley, and Araya?
Oh,
And the second one was, can we watch the welfare check body cam videos? Body cam video, I assume, of
Arneen and Path.
there's 2 of them, right?
There are 2.
Yeah, we might have to get where they.
oh.
So first of all, on the issue of length, just so I understand, if I remember right, Major's first interview was. Let me go back to my notes. Was that 41 minutes?
Wow.
Sound about right?
Accurate.
And they're not asking for the second interview. It's just the first interview. And then for Brantley, the first interview, I did not write that down, but I think it was about
30 minutes.
About 30 minutes, yeah. And then if I remember right, it's pretty short. It's about 27 minutes or something. So.
Are we gonna be here all night?
Right, okay. 20 minutes. And then the videos, the body cam videos, I don't know necessarily how long those were. They were relatively short.
They're short snippets.
Yeah, Sergeant Kearney's was short snippets. The
think-
longer one when he was actually in the home, and then Sergeant Paff's, I think, was 10 to 15 minutes.
My guess is they're talking about the video of Alexavier, of the views of Alexavier, actually. But I really don't know. They just said, I'll read it exactly. Welfare check body cam video. That's all they wrote. We could ask for specific areas. I think the forensic, I think they want to see the whole thing of the forensic interviews. I think the welfare check body cam video, there was a whole bunch of bits and pieces.
What do you think this means?
That were shown. We could ask specifically which ones. The other thing is timing. Do they want to do it tonight or do they want to do it tomorrow morning at 8:30? first of all, what's the feeling about them seeing these? The only way they can see it is by coming in the courtroom and watching them.
Oh,
What's the state's position on it?
I have no objection to them seeing them.
Right. And then the only, other than maybe trying to get a little more detail on the welfare, on the body cam question, the other issue would be to do it tomorrow because, obviously that's about it's close to 2 hours worth of video, maybe over 2 hours worth of video. Yeah, that's what I was hoping we would do. Sorry. That's what I was hoping we would do tonight. So this is what I'll tell I have to ask the jury this one question before I bring them back. So why don't you wait here a second? Let's see if we can get a detail on that. I'll come back, then we'll bring the jury in.
what do you think it says though that they want to see these forensic interviews of the kids? Because
I'm just,
do you think they are believing? Do you think they think the kids were coached by Derek? I think Araya's interview was probably the most honest interview of all of the kids. She was 4 at the time. I think Major and Brantley was all over the place. That kid is like a chicken with his head cut off. He just wanted out of the room. I feel like he did not want to be there. I have to hear him again though. See, so I don't really remember. I can't remember if it was the first interview or the second interview. But they're wanting to hear the first forensic interviews when they very first talked to the kids. Because their stories are completely different. Not completely different, but pretty different. I wonder if they want to hear them tonight. Oh. But the kids don't act.
maybe seated. So, Kevin did just relay this to me.
They want to watch the forensic interviews of
Didn't
the
write
kids.
it down, but they want to see on the body cam really 3 things. One is the officer looking through the window. Is that Crenine?
Yes.
Yeah, Officer Crenine looking through the window. And then the 2 times, I think an officer, I think it was Crenine that went in and looked at Alexavier. So they want to see those 3 bits. That's all Crenine. So both, everybody's okay with that being seen? All right. So what I'm going to do is bring the jury in, and I'll explain that we will review the forensic interviews. We'll probably do the body cams first and then the forensic interviews, just because I think that's how they came in sequentially. I'm not sure that matters, but and then we'll do it tomorrow morning. I'll ask them to be here at 8:30, and as soon as we can, we'll start up.
Although what?
And before we, again, just a reminder, we'll have to swear our other bailiff because we're switching bailiffs tomorrow morning. So we'll do that tomorrow morning too. So then if we can make sure we have those clips figured out.
Yeah, if I will identify which ones they are, Judge. I think it's the easiest, if I play them from my computer, I'll guarantee they're the same ones. And then
Right.
I'll save so we don't have the issues with the buffering and stopping that were happening when I didn't have them saved on a
Hard drive.
computer. Yes, yeah.
And that's fine. Any objection to that?
As long as it's the same clip.
Okay. So, so we'll do that in the morning. I'm gonna bring the jury in. We'll tell them, I'll give them ask them not to talk about it, and we'll see them tomorrow morning. And I'll explain what we're deciding right now. Okay, bring them on in.
Well, I mean, at least they are paying attention, right? Oh, they want to see the body cam footage of the welfare check on Alexavier. They want to watch the forensic interviews of all three kids, Brantley, Major, and Aria. The first interviews,
All right.
not the follow-up interviews.
All right, everybody may be seated. I'll just start with this. It's inevitable that everybody keeps on sitting in the same seat no matter what. It's human behavior. Anyway, so we did get your question. We're going to allow you to see these forensic interviews and the clips, which was brought to our attention tomorrow morning, though. So if you can get here at 8:30, we'll start as soon as you're all going to be here. And we'll start with those clips right off the beginning, and then you can go back to deliberation. Now that you're in deliberation, it's become even more important you not talk to anybody, not to say anything. In fact, as you walk out this door, stop thinking about the case. Like that's possible, but try not to think about the case. Reality is you should deliberate together. You shouldn't do anything. I know it's difficult to do that, but we need you to sort of go through this gymnastics of trying to not think about the case and only come together and talk about it. Also, when you get together tomorrow at 8:30, don't talk about the case at all until two reasons. One, you want to see the video. Second one is we also have to swear Terry back in and to become a bailiff in order to have two people here as bailiffs. So have a good evening. Try to relax a little bit. We'll see you tomorrow morning. Thank you for your time so much.
Well, okay. Gingerbug. Well, I missed most of the closing arguments, but I left them on for you guys. Mark stuck around and watched. I just heard, I peeked in a little bit, and all I heard was the prosecutor yelling. Like he was yelling at the jury a lot.
State, any problem with how I explained that to the jury?
No.
Defense?
Yeah.
Okay.
Too late now. What are you gonna do? Bring him back in?
Be here, whatever you need to do to set up, 8:15, 8:20, we'll start as soon as they're ready. I mean, you could come at 8:30 if you think you have it all set up. But the jury tends to really get here at 8:30. So that's why I say, let's say 8:25. Gives us 5 minutes to set up. If you need more time, let us know.
Sounds
Okay.
good.
All right. Well, we'll see you tomorrow. Take care, everybody.
Thanks, Judge.
Okay, so we'll be back in the morning. So I guess we need to hear these forensic interviews of these kids. It's the first interviews, the first round of interviews with the kids that were done before Derek really had his grip on them. Apparently that's what they want to know. So we'll get to hear those and the body cam footage. I'm just trying to figure out what the jury's strategy is, what their thought process is for them to want to hear the first forensic interviews, that they want to hear the first ones. But I guess I need to hear them too. So we'll hear them and try to figure out what their thinking is. I don't know. We'll be here for it in the morning. I was about to say, at least they're taking their time, but they didn't get this for deliberation until what time? Like 4, 3:30, 4? When did they get this in their hands, Mark? I don't even know what time they got it. 3:30 or 4. So they haven't had it that long. It just seems like a long time because we've been sitting here. Yeah, 3:30 or 4. So they haven't had it that long. So it's yeah. Yeah. So it hasn't, honestly, if you think about it in time, in the amount of time for the jury that actually had it, it's only been a couple of hours. Yeah. So when you're thinking of somebody's life in their hands, in the grand scheme of things, no. it hasn't been that long. so we'll calm down. I'll calm down a little bit. It's only her life. Yeah. So we're good. We'll be back in the morning. So I'll see y'all in the morning, hopefully. Thank you so much for sticking it out. I appreciate it. Thanks so much. And we'll see you tomorrow. 감사합니다.